Can you hear me now?
I can hear you.
Okay, I'm sorry I was on mute. You were talking a moment ago. Were you asking me something?
I'm sorry, Judge. Let me turn my fan off real quick. All right, now I think I can hear you, Your Honor.
Good morning.
Good morning.
I'm Jim Guess with Adamy Sheffield change the name, Adamy Sheffield Mask and Burns. I'm of counsel to that firm, and I'm appearing in the hearing today on behalf of defendant Dylan Melton, and I'm an interested observer.
You know, James, we can see half your face, but I remember you from depositions.
Let me see if I can move around it. There we go.
So you're still around.
I am still around.
Good to see you.
Good to see you. Whose law library am I looking at?
If you're referring to the background here, that would be Lynch Chapel Allsups, but I don't own it. I'm in Midland, Texas, stealing office space today.
I love the old law libraries that we practiced with when I was a youngster and had to dig answers out of books. But I still love the appearance.
I remember when this came out, they called me. I had a full law library, paid $35. I don't know how many years I'd had it. They offered me $750 if it was in mint condition. I'd rather throw the damn thing away. I would never. It was more expensive. $35 a book every month for I don't know how many years. Where?
I got licensed right about the time that libraries went from being an asset that attorney sold when they retired to being something you had to pay folks to haul off for you because there was no market.
Yeah, there was none. Like I said, mine was. I bet you by the time they came out, I'd spent about $25,000 on it, and they offered me $750 if they were in mint condition. I mean, that's.
But I still love the way they look. I think they.
Yeah, they do, right?
I love them.
Yeah, I do think I do enjoy it. It looks impressive, but sometimes it's hard to wave a disc around and impress a client.
All right, I'm going to hold on. We've still got people joining. You can get a photo to use as a background. This is actually some oak paneled courtroom in Wales, I think, that I have as a background.
I was really impressed with the local lawyer because he had this really fancy office in the back. I said, God, I think Edgar was making that kind of money. And then the number is just a background that you get. Oh my gosh.
Right. Well, they're still coming. Okay, I'm going to call these. I think we have only civil dockets this morning. I saw a TRLA earlier. Are you hearing a civil matter? Or have they signed off?
Yes, Your Honor, this is Kathy Starling. I changed my name so not to confuse the court, but I'm winding down my practice, and so I'm here not representing TRLA this morning and just
Okay.
representing myself,
All
yeah.
right. That's fine. All right, Atascosa County, in the matter of April and Joseph Monsabayas. I see. All right, ma'am, I'm asking you to unmute your phone.
I'm here.
All right, and is Lucinda Vickers still your attorney?
Yes, yes, sir.
Okay, have you heard from her?
Yes, I have. And she has another case also is going as well at the same time as mine.
Okay. All right, I'll mark you present and recall. Karnes
Judge.
County,
Okay,
Apperson versus EOG.
Your Honor, Corey Waymeyer on behalf of the Move-ins DDR Gaddy and the Stephen Bressler Trust. We're ready, Your Honor.
Your Honor, plaintiffs are here and ready on DDR Gaddy and Bressler's 8th motion for summary judgment. As the court will recall, a number of other matters were originally set for today, but there was a continuance as to those moved to February 8th to 10th, but we're ready on the 8th motion for summary judgment.
Okay. All right. Would it be, and I know that there were 2 binders dropped off. Would it be possible to get a link to somebody's server or to a Dropbox with all of the documents I need to look at?
Yes, Your Honor. We will get that uploaded into Dropbox and to you.
All right. Thank you. And it says 2.5 hours. Is that still?
Yes, Your Honor. I think 2.5 hours is a good announcement, Your Honor.
Okay. All right. Let's see what else we have. Frio County, in the interest of the Zamzow children.
Good morning, Judge. Porter Corrigan, I'm present on that. Lucinda Vickers on the other side. I don't see her quite yet.
Her client in Atascosa County case said she's in court elsewhere right now. I
Okay.
saw Katie Roberts check in.
I'm here, Your Honor.
Yes. Okay, what do we have to hear?
Well, this was
Actually, hold on. Here comes Ms. Vickers. All right, Ms. Vickers, I was calling the Zamzow case from Frio County.
Yes, Your Honor. I'd like to confer. I don't know if you want to give us a breakout room.
Yes, I need to make Ms. Riley the host, and I will ask her to handle breakout rooms.
Okay.
And in the Monsibai's case, Mr. Monsibais, I believe, is here, and your client is here.
Yes, Your Honor. I was trying to figure out, the parties were pro se, and I believe Mr. Monsibais did today's setting. So I'm not really sure exactly what we were set for today.
All right,
Obviously,
well, I'll just ask you to confer with him then.
that's fine.
Okay. All right, in the matter of the marriage of Tabitha and Jose Santos.
Good morning, Your Honor. Sylvia Rodriguez on behalf of Mr. Santos. I wanted to see if, possibly we could get reset for another 10 days. We've been going back and forth trying to negotiate the property division, Judge. I think we could get it done if we had maybe another 10 days. Is that okay with you, Mr. Burgess?
Yes, that's agreeable, Your Honor.
Okay, if the two of you will get with the coordinator and/or just get with the, look at the calendar, and if you can agree on a date in chat or in a conference room, just post that in chat to me with cause number, name, and date that it's being set to, and after that, you are excused.
Okay, thank you, Judge.
You're welcome.
Thank you, Judge.
The matter of William O'Connor and Eliza Shapa.
Your Honor, I'm here for Mr. O'Connor.
I thought I saw Mr. Padilla. Yeah, he's just muted.
sorry. Oh, yeah. I'm sorry, Judge. I'm here for the respondent. I have to announce not ready due to the fact that I haven't heard from my client in over a month. So after today's hearing, I expect to file a motion to withdraw.
Your Honor, this was Mr. Padilla's motion, and I would like to get some temporary orders set up for my client.
Okay. And where is the child right now?
She's at home with her father.
Who's custody? Who has possession of the child? Which parent?
My client does. There's a protective order
The
currently
father
in
does.
place.
The father does, Your Honor.
Okay. All right. I expect that we're going to move forward and have some sort of temporary orders this morning. I'll ask you to confer about that. And Mr. Padilla, if you can't agree to anything, I understand that, but I'll still ask you to confer, and we'll have a brief hearing if necessary later.
Okay,
Wilson
Judge.
County, in the interest of Aaliyah Alvarez. Mr. Strala?
Yes, Your Honor, I'm present on that with Mr. Ray Adams and on the other side. This is about a TRO, whether or not to extend it to a temporary injunction. We've conferred extensively, although we haven't really talked about time. I would say maybe an hour and a half, something like that, maybe.
I agree.
Judge, the Attorney General is also present.
Okay, and do you need to be this morning? Is support up on the docket this morning?
No, Your Honor, not at all.
We weren't served on the pleadings, Your Honor. I was just appearing. I would ask to be excused. I don't see that we are needed.
Okay, no, you're excused.
Thank you, Your Honor.
All right, we have a local rule that typically limits temporary orders to 60 minutes, so I'll put y'all down for 60 minutes.
Sounds good, Your Honor.
Amanda Palmer et al. Versus Dylan Melton et al.
Plaintiff is present, Your Honor. Jimmy Franklin.
Your Honor, this is Alex Good on behalf of the movement. I have a traditional and a no evidence motion for summary judgment. And even though there's two of them, I anticipate it'll take about 40 minutes, 30 to 40 minutes.
Your Honor, I'm Jim Gass, representing defendant Dylan Melton. I'm an interested observer.
Okay. And Mr. Franklin, you agree on the 45 minutes?
Yes, sir. That's I don't have any basis to object. That sounds much more reasonable than the hour and a half I think that was originally allotted.
Okay. All right. And I have the file over here. Are there any exhibits that may not have been printed by the clerk's office that were attached to a motion or a response?
Your Honor, there was, in my original motion, what I'm asking the court to do is as a matter of law, I didn't have any exhibits. I understand Mr. Franklin's response filed last week was 109 pages, and he astutely labeled the name of his document with that page count. So assuming that that was it, that would be all the exhibits.
All right, let me see if I have all of that.
Judge, we would not have printed those out.
Okay, and that's, since we have typically the clerk's office doesn't do that. Can you, Mr. Franklin, post to me in chat a PDF of your exhibits?
Right now, I'm not that good with this equipment, Your Honor.
I can put a PDF up there for you. I got
I've heard of that phrase before.
I'd appreciate that.
Thank you, Mr. Good.
In the matter of the marriage of Julia and Matilda Martinez.
Good morning, Your Honor. Kathy Starling, and then Mr. Pena, I saw him
Yes.
on the Zoom call earlier. We're gonna be conferring on that this morning. I don't know if you want to put us in a breakout room.
Okay, I'll mark you conferring. Mr. Pena, you're in agreement?
Yes, Your Honor. I think that would be good, and a breakout room would be perfect.
All right, Ms. Riley is the host at the moment. All right, in the state of Sacramento, Garcia.
Good morning, Your Honor. Anthony Bancroft for the estate of Sacramento Garcia. I believe Mr. Brent Bernstein should be here as well.
Okay.
Mr. Bernstein and I are co-counsel in this, and I believe Mr. Ecke is the ad litem. He should just be present as well.
All right, let me scroll through both pages. All right, I don't see either one of them right now. I will recall.
Your Honor, if you would please, I guess, put us in the conferring stack and I'll give them a call.
All right. Will
May I
do.
be excused, Your Honor.
Yes, sir.
Thank you.
All right, expunction, Dylan Ford.
That case has been dropped, Judge.
All right, are that all the dockets I have?
Yes, sir.
All right, there's seem to be a lot of folks here yet. Is there anybody who's here today, your case was not called? No? Okay. All right, I'll let the folks who need to confer, and let me go back through here and see what the shortest thing we have is.
Ms. Vickers, I'm going to place you and Mr. Corrigan and Katie Roberts into a breakout room number 1. Do you need anybody else in that room?
Ms. Vickers, I think you're on mute.
Yeah, I got it. At some point, I'll have to confer with Mr. Monsiváis, who's pro se.
Do you want to speak to him first, or you want me to put you in the breakout room with Corrigan and Roberts?
Why don't I speak to him briefly first and see what we're going to do with that?
And what was his name again? Joseph Monsiváis?
Yes.
Okay, I'll put y'all in number 1. And then Starling and Renee Pena, I'll put y'all in number 2.
Thank you.
Thank you.
You're welcome.
Are you in the attorney appointments thingy? Yeah, I am.
All right, it looks like the shortest thing we have with everyone conferring is the Palmer motion for summary judgment. So give me a moment to
No, go ahead and do
file
it. I'm already out.
and read that.
Your Honor, I'm trying to get that PDF. There it is. The PDF is uploading. It's 33 megs and it's about 40% done. It should be done in less than 30 seconds.
Okay. All right. And in the EOG Karns County case,
Yes, Your Honor.
I'm just wondering here, we've got an hour, we've got 45 minutes. That puts us to go on 11. If everything that's conferring settles, I could certainly start this before noon. If not, it will be a lot later. So would parties prefer to just wait and see what happens and work at your desks, or come back at, say, 12:30?
Your Honor, for my part, it's whatever pleases the court. I'm happy to wait, or if it pleases the court to have all these folks off your screen, that's great too.
Well, it's not so much off the screen. I'm going to be sitting here regardless, but I hate to think of the meter ticking sometimes when people are just sitting here watching me do other things. So is anybody asking just to not hang out to get a firm time, 12:30, 1 o'clock to come back, or you want to just hang out and see what happens?
Your Honor, we're at the court's disposal. So whatever you would like, we're happy, just like Mr. Waymire said, we're happy to reconvene at 12:30 if you'd prefer, or happy to just be on hold and wait till the court can hear us.
All right, why don't we come back at 12:30 and hopefully everything will be wrapped up by then, and I can work on, give me also a chance to look at your pleadings beforehand.
Do you want us to upload those in the chat, Your Honor? Or do you already have our response with the exhibits?
I have hard copies. I would actually prefer if you can just get me that in Dropbox.
Okay, is there a link by which to do that somewhere?
You're going to have to create one. I think Mr. Weimar said he was already working on that.
We are, Your Honor. How would you like us to get you the Dropbox link?
Just post it to me in chat is fine.
Very, very good, Your Honor.
Okay, if anything changes on announcements, come back, and I'm going to.
Your Honor, Anthony Bancroft, may I approach your bench?
Yes, sir.
Your Honor, I believe I figured out what happened. I have a Zoom setting to be in front of you right now on the estate of Sacramento Garcia. Co-counsel and ad litem received notice from the court that Judge Ellison
okay.
Had given a different Zoom ID and passcode. I don't know which one to use since you called the docket.
It's on my docket, so I would expect mine. Has Judge Ellison heard something previously?
I believe Judge Ellison heard a protective order. I'm sorry, a temporary restraining order, but that was like 8 months ago. So would you like me to tell counsel and ad litem to come back to this ID, Your Honor?
Yes.
Very well. I'll make it happen.
All right, I'm going to pull the Palmer MSJ. Give me a moment.
And Your Honor, just for clarity, the only thing I've uploaded is the response. My motion and then the reply brief I filed last night were 9 and 4 pages respectively. They were very brief.
Okay. Actually, if you would just upload everything, Mr. Good, if you have it.
Yeah, you bet.
It's actually easier just to. Is it Mr. Weimeyer, somebody on one of the oil and gas cases, when I couldn't find something because I was hunting around on a Acrobat, said that they have a vertical monitor. So I got a vertical monitor stand and now I can see the whole page at once, and that's a lot easier to review the documents.
Your Honor, this is Marty Truss with EA.
Yes, sir.
Here for the Apperson hearing. Are we excused until 12:30?
Yes.
Thank you, Your Honor.
And Your Honor, I'm seeing in the chat feature that the PDF of all of the motion, response, reply with exhibits has been uploaded to the chat feature. We're working on the Dropbox link as well, and we'll get that up, but the PDFs are up there.
Okay, as long as I have it. I had a bad Zoom day yesterday, but Zoom seems to have been working better. Back in the summer, if you got a very big document over a couple of megs, it was very difficult to make it work. It would just hang up, but everything seems to be coming through right now.
Your Honor, the Palmer motion for summary judgment and reply brief, all those documents are in the chat now.
Okay, I see them. All right, give me a chance to look this over. All right, Mr. Bancroft, it looks like all the attorneys are here on that case.
Good morning, Judge.
Good morning.
And Judge, Mr. Ecke, the ad litem, is signing on right now as we speak.
He's here. Okay. All right. And I still have a number of folks who didn't answer anything. You're welcome to watch if you want to watch. But is there anybody whose case was not called? All right. Anyone who has a criminal case in the docket today? All right. Okay. So what do we need to do on Sacramento Garcia?
Your Honor, it's an airship proceeding.
What? Okay. This is the merits.
And I have my client in the office if we need to get his testimony.
Don't call him.
And the 2 witnesses, I have to provide the new Zoom language.
Okay, well, I'm gonna go ahead and do another matter. It's about the same length, a little bit than yours, and let me know whenever y'all are ready to go.
Thank you, Judge.
Lori?
Yes, ma'am.
Okay, for Mr. Monsibius, he should be back in the room. Do you see him? There he is.
He's out.
We're gonna need to have a court date to set this, give him time to hire a lawyer. We do not have an agreement on what we proposed, and he wants time to hire a lawyer. So I don't know what court dates you have in like 3 or 4 weeks.
Any date on the 16th, 17th, or 18th would work.
Okay, let me go to that.
Yeah.
Hang on,
20,
let me-
the week of the 22nd, 22, 23, 24, 25, any of those dates are open. The 8th and the 10th are both open. Might be a little too soon.
Yeah, the 10th is bad. And then you said you've got the 22nd, the 23rd,
24 and 25.
that whole week,
Yes, ma'am.
24 and 25?
Yes, ma'am.
Okay, could we do Wednesday, February 24th?
Certainly.
Okay. And Miss Monsibius, are you there? Okay, I see her. She's okay. So we're going to reset this for February 24th. So Mr. Monsibius, are you available on that date? Okay, so this will be the notice that you get. He's representing himself. Do you send them through email, Lori, if they have an email address on their pleadings?
Yes, and I think he gave us one before. He should have
Okay.
gotten one.
Okay.
Did you, Mr. Monsibius? You
Yes,
received
ma'am.
that email? Okay. Yeah, I usually send one out.
All right. Well, then he and my client, Miss Monsibius, can be excused, and I will need to go into the breakout room with Porter Corrigan and Katie and Grady Roberts.
Certainly. Okay.
Lorian, is that all for Atascosa?
That was the only case. Yes, Chris.
Okay. Well,
Thank
I'm
you.
going to log out then. Thank you so much.
All right, you have a good day.
Bye, you too.
I'm going to put Vickers and Corrigan and Roberts into breakout room 3.
Okay.
Me and,
Thank you.
I'm sorry, this is Alfredo Padilla. Me and Ms. Katie Roberts have already conferred over the phone, and we just need to get back in front of the judge.
Mr. Court. Okay, got it.
Lori. Lori, can you hear me?
I can hear you.
This is Ophelia, Frio County.
Yes, ma'am. How are you?
Good, how are you? What was the announcement on Frio's 2010-280? I missed that.
They wanted a reset, but the date they picked was a full date. So they're conferring right now. We called their office. Norma called their office so they can get another date. So
okay,
I don't have a date for you right now, but
all right.
soon.
Thank you.
Thank you.
Your Honor.
Yes. Yes.
We have the witnesses and everybody's on now, Judge.
Okay, all right. Well, I'm going to hear the other case first. I'm just about ready for that.
Did you say Katie's, Judge? This Mr.
No,
Padilla.
sir. No, Mr. Padilla, you're in line too. I'm going to finish
Okay, yeah.
the motion for summary judgment, then I'll take announcements on time.
We conferred to no avail just since I have no client.
Yes, sir. I know.
Okay, okay, all right, thank you.
I'll take time announcements in a bit. All right, in Palmer versus Melton et al. Everyone ready?
Yes, Your Honor.
Yes, Your Honor.
All right, go ahead, Mr. Good.
Yes, Your Honor. My name is Alex Good, and I represent Sierra Lambeck in this matter. I understand you've read through the briefing, but central to the motions for summary judgment I have before the court is a single issue. My client, Sierra Lambeck, was the backseat passenger in a vehicle. Now, plaintiff is bringing a lawsuit trying to hold other people responsible, but I'm only here on behalf of Sierra Lambeck. The theory against my client is that she is a negligence theory, that she breached her duty to remonstrate, warn, or protest from the back seat, and that she should be held responsible for the events of that evening. Now, the events that evening, this occurred on November 4th of 2017. My client, Sierra Lambeck, in her early 20s, had invited Sky Yates to be her guest at one of her cousin's weddings. And so the Lambeck family was in attendance, and at least relevant to this motion, my client's mother, Lynn, was also in attendance. Towards the end of the evening, Sky Yates stormed away from the Kosciuszko Hall, where the wedding venue occurred, started walking down Farm Road 541, and in an effort to get him off the road, Lynn began driving the pickup truck, and my client, Sierra, sat in the back seat. There was a third passenger, but that person's not a party to this lawsuit. And they went down the road. There was an exchange that occurred for about 5 or 10 minutes. It's my understanding, and the deposition testimony speaks for itself, that they attempted to get him off the road. It sounds to be an emotional exchange, and then Dylan Melton's vehicle was driving the opposite direction. Your Honor, there are a number of other facts that are in play at this case, but they're not relevant here. Mrs. Palmer, Amanda Palmer, is the mother of the deceased. And while I understand why she is looking for answers, they're misplaced when they're targeted at my client, Sierra Lambeck, as the passenger of a vehicle. They're attempting to hold, so eventually what happened was that there was a collision between Mr. Melton's vehicle and Sky Yates that resulted in his death. So she's suing on behalf of herself for wrongful death and then attempting to bring a survival action on behalf of Sky Yates. In my motion for summary judgment, Your Honor, what I've done is I've tried to create a series of cases that show that the issues in this matter are clear. In order to prove negligence, plaintiff has to prove duty, breach, causation, and damages, and they cannot do that here. Most importantly, there is no duty that Sierra, as the passenger of a vehicle, owed to Sky Yates. And so as they phrased it in their petition, what they have alleged is a duty to remonstrate. And as I circulate, I'm younger in the profession. I thought maybe I just hadn't heard this word before. I circulated it in my office, and it took some digging. And the best I can find out is that a duty to remonstrate, because it doesn't seem to be recognized by Texas law, it is not defined by Black's Law Dictionary, is the best at what Mrs. Palmer is alleging is that Sierra Lambeck should have either warned Sky or the mother, and frankly, it's inconsequential to either get out of the way or move from the lane of traffic. Now, Your Honor, I don't think it matters to this, but it's the testimony's record that Mr. Yates was, like I said, emotional, intoxicated, and walking towards Poth because he was angry at some sort of situation.
Mr. Good. It's Poth.
Poth, yeah, I'm sorry, Poth. That he was walking towards Poth in that particular state.
There's a line about that in the Great Waldo Pepper, but go ahead.
Fair enough. I've learned a lot of geography from pop culture music. So those are the details of that fact. Now, Your Honor, you're familiar with the standards of the summary judgment. I mean, to the extent that they blend together and or different, plaintiff has not offered. I'm going to start with a no evidence motion for summary judgment. Mr. Franklin, representing Mrs. Palmer, has no evidence to prove that there's a duty. And the evidence he's attached in his response is inconsequential. There's no case law cited. I've tried to address this in my reply brief. There's no case law that cites that there should be an imposition of a duty on the passenger of a vehicle. In fact, the general rule is that passengers of vehicles have no responsibility. They're free to go to sleep. My client in the back seat has no control over that vehicle. Now, there is a strange allegation that Sky Yates and Sierra Lambeck had a special relationship. That's not pled. I've addressed it in my reply brief. But this moment doesn't fit special relationships either. Case law is clear that if there is a special relationship, that might be a grounds to impose a duty of reasonable care. There's no case law on people who are cohabitating together, but there is case law that shows that a spouse does not have a duty to control another spouse. And I think it's analogous to this situation that Sierra and Sky weren't even spouses. And even at a higher bar, if they were married, they still wouldn't have a duty to the other to control the other's behavior. Now, the only other duty I can glean from the pleadings in this matter is that Mr. Franklin might think that my client, Sierra Lambeck, had a duty to control Lynn Lambeck, the actual driver of the pickup truck they were in. Now, again, there are moments where parent-child might create a special relationship, but those are minors, and the duty there is imposed to the parent, not the child. Again, Sierra Lambeck, my client, was the passenger and child of Lynn Lambeck and had no duty to control or prevent this. And because of that issue, the attached documentation about the position, the photographs that Mr. Franklin has attached, the deposition testimony, is inconsequential. There's no evidence because as a matter of law, there is no duty. Because there's no duty, they have no evidence of breach. I think it's part and parcel of one another. As a part of my motion for summary judgment on the no evidence, I said that there is additionally, they have no evidence of proximate cause or of causation, the third element in a negligence cause of action. My client's behavior in the back seat trying to plead with Sky to get him in the vehicle was not the but-for causation. This wasn't the foreseeable outcome of those events. I think Mr. Franklin has stated the law correctly in that but-for or proximate cause does not require the actor or omitter to see the specific line of events. But again, this analysis is inconsequential. I've briefed it correctly in my reply brief now that I've seen where Mr. Franklin's response came from. In my reply brief, and I'll be candid, even on the record, a lot of it comes from O'Connor's that specifically outlines what the risk utility test is. The risk utility test, and Your Honor, did you receive a copy of the reply? I put them both in.
Yes.
Okay, yeah, I did. I filed it last night and wanted to make sure that we got there. The risk utility test warns courts that this is the proper analysis to undergo before imposing a duty. There is no assumption of a duty. The only statements in Mr. Franklin's response that say that there's a duty, a generalized duty for my client to owed a duty of reasonable care to warn. There's no case law that supports that. The general rule is that people don't owe duties to one another. The risk utility test informs us of, and if you've read through the briefing, I don't want to be redundant, but I think it matters, that under the risk utility test, this must be applied before the court can find a duty. And under this one, the factors appropriately consist of risk, foreseeability, and the likelihood of injury. And case law tells us that foreseeability is the most important of those factors. But it's also very clear that foreseeability alone is not enough to create a duty. My briefing is clear, Your Honor, and I'll be happy to provide you the cases with this, but there is no, generally, this is what the case law says. Generally, there is no duty for passengers to control a vehicle. Generally, there is no duty for people to warn against other people absent some sort of special relationship or finding. Now, if we look at the rest of the risk utility test about the actor's conduct, the magnitude of the burden of guarding against the injury and the consequences of placing this burden on the defendant, if we were to place this burden, if we were to, in this case, say that passengers are responsible for the behavior of a vehicle, we would be going against a long line of cases that specifically state there is no duty for passengers. There are bizarre instances where, and I've briefed this in my initial motion for summary judgment, that are quite distinguishable from this case, where there's one case that essentially says that two gentlemen who were leaving work and using drugs with one another, there was a spill inside of the vehicle, and the passenger who owned the vehicle didn't ask the driver to stop so they could clean up the spill, and it resulted in injuries. That is quite different from this case. So again, as the court goes through its analysis on the risk utility test, the imposition of duties on passengers of vehicles would be a large imposition. It would be one that socially would fly in the face of years of case law. The risk utility test doesn't ignore the idea of superior knowledge. It also says that the courts must consider the superior knowledge of the risk by the alleged defendant, the party's duty to control the other party, societal changes, and conflicts with statutory law. Now, Your Honor, again, the special relationship wasn't pled. This risk utility test wasn't fleshed out until the response brief, and I've contained the analysis in my reply brief. Plaintiff doesn't offer any evidence for this court to weigh when balancing the risk utility test. What we have in the response, whenever I filed my no evidence motion for summary judgment, it was incumbent upon plaintiff to carry its burden to offer a scintilla of evidence. Because this issue is a matter of law, what he needed to do was produce case law. And we don't have that. What we have is a long list of cases that have been copied once in the no evidence response and then yet again in the traditional response that just say that foreseeability is a factor. I agree, it is a factor and it might be an important one, but it is not enough. It is not enough. There is nothing to impose or to distinguish my client from the general rule that she was owed no duty to the general public or had a special relationship with Sky Yates. That's the no evidence portion. And I don't believe that plaintiff's counsel has shouldered their burden now that it's transitioned over to him. With regard to my traditional motion for summary judgment, the argument's quite similar, and I won't be redundant here again, but traditional summary judgment is proper in this matter because the case law is clear on this point. Passengers of vehicles do not owe duties to the controller, or do not have control over the vehicle and do not owe duties around that. This is an extremely unfortunate set of circumstances, Your Honor. And having been with this case since I represented Sierra Lambeck, I've been there through the depositions, and I understand Ms. Palmer's attempt to get a different answer on this case. But my client's the wrong actor. If there were to be a signal to people in Wilson County that the passengers of their vehicles would be responsible, it would make it impractical to impose these duties onto the passengers of vehicles. Without sounding insensitive, Sierra Lambeck wasn't a backseat driver in this moment. She lost the man she was living with that day. She had her own experiences trying to bring a disorderly moment to an end by trying to get this man off the road. It doesn't justify what happened, but she is in no way responsible. Relevantly, these issues are a part of case law that's well established. This matter should not proceed to a jury. And Your Honor, I do want to make it sure, and I know that we've got a court reporter on this, I want to preserve it for the record, that even in the traditional motion for summary judgment, what has been attached to the plaintiff's response, to the extent that it's not objectionable, doesn't create a genuine fact issue. What we have here is deposition testimony and photographs of the scene. My motion for summary judgment is squarely focused on duty, breach, causation, not how the event occurred. Amanda Palmer wasn't there. Her photographs afterward are inconsequential. She has no firsthand knowledge of all the testimony that's here. Plaintiff has failed to shoulder its burden or create a genuine issue of material fact as to duty, breach, and causation. And Your Honor, I told you I wasn't going to sound redundant. If you've read the briefing, I've fleshed this out with the case law, and to the extent that plaintiff's response says that this would be an issue of material fact, this is precisely the sort of situation where there's no legal theory upon which to bring a claim against my client that should be dismissed and not considered by a jury. So for that, Your Honor, we believe that motion for summary judgment should be granted on both counts, both for no evidence as well as traditional.
Mr. Franklin?
Thank you, Your Honor. Very simply, Judge, Sierra Lambeck, on the ton of facts and evidence that she knew about that I've presented to you, the sworn testimony of what she knew, when she knew it, what she saw, she is, under Texas law, a clear, classic, traditional, independent tortfeasor. She is a joint tortfeasor in this collision. She is one joint tortfeasor of three, actually four, because I anticipate the court would, under the current comparative law, submit my client's negligence for the jury's consideration as well. Miss, I'm sure the court's read it, but in the evidence that I have attached to our response, Sierra Lambeck admitted that she knew it was illegal to stop a vehicle in the middle of a roadway unless it's an emergency. She knew that. She also told the court through her deposition that she saw the risk coming way down the road. She saw the 17-year-old Mr. Melton at midnight on this 2-lane dark country highway way down the road. She saw him coming so far, Your Honor. She saw his headlights go around a curve. I showed you that evidence. She saw his headlights go over a hill. She saw his headlights come across a bridge way down the road. She saw him coming. And if you read the testimony, no one else, she could not, Sierra was the only person in this group at this time, which would be my client, Mr. Yates, Sierra's mom, Carolyn Lambeck, the driver, and Sierra. Sierra was the only person that the evidence before you establishes saw the risk coming. She forget remonstration, any duty of remonstration. I've got cases on that in a minute. This is the simple Texas rule of if the risk is foreseeable, there is a duty of care. And it's my burden for my client's burden through me to present you with enough facts, evidence, and circumstances that you as the judge can say, hey, as a matter of law, in this case only, Sierra Lambeck, with what she knew, she's got a duty to do something. She has, like Mr. Good just told you, and this is beautiful, Judge, Mr. Good nailed this. Remonstration or independent tort or negligence, it's duty to warrant. All it is duty to warrant. Do something. Mom, you're blocking Sky. You pushed him out to the middle of this roadway and this truck is coming. You're blocking Sky. Pull up or do something. That's warning. That's remonstration. And she knew it. She saw it coming. She saw it coming. She saw it coming. She did nothing. And that puts a duty on her, Your Honor. She was not asleep. She doesn't get to say, oh, I'm a passenger. I could have been asleep. No. It's a case-by-case, fact-by-fact basis that the court must decide on this foreseeable duty. And she is a major player in this case. The jury, Your Honor, under comparative submission of all these people, all 4 of them, the jury may likely put the most on Sierra. I mean, the evidence is that her mother, the driver of the truck that had stopped illegally in the roadway and pushed Sky, he was in the middle of their lane when they first came upon him. And I gave you this evidence in my response. And then the mother, by somehow driving her pickup, she forces Sky to the center of the highway and puts him at even greater risk and then blocks him with her pickup while she and her daughter right behind her are hanging out the windows, respectively, pleading with Sky to get in the truck. Well, that's negligence on both those ladies' part. The truck is illegally stopped. The truck is illegally blocking Sky from getting off the road. And Sierra, in her deposition that I have shown you, Your Honor, in my response, she clearly said, hey, Sky could not cross the road to the other side to safety because that would be in front of the oncoming Mr. Melton truck. And Sky couldn't jump in the bed of our truck because he was at the front of our truck talking to my mom. So this is all evidence before you, sir. We've got multiple acts of independent negligence, stopping their truck in the roadway illegally, blocking Mr. Yates, who was known to both these ladies to probably be intoxicated, and negligently forcing him to the center of the roadway, putting him in greater risk, and then not moving out of the way and letting him get to safety. Miss Carolyn Lambeck, the driver, I gave you this testimony, Your Honor. She testified she didn't see the oncoming pickup till at the very end. So she's not paying attention. She's not doing what she needs to be doing. So she's another joint tortfeasor. But Sierra in the back seat, hanging out the window, trying to get her boyfriend to do something, knowing the whole time that they are illegally stopped, they're blocking Sky. They pushed him to the center of the roadway, and here comes a big truck, or here comes another vehicle from way down the road. Sierra cannot escape liability. It's not for any of us today to decide apportionment of comparative fault between these players, but Sierra doesn't get a pass because she was simply a passenger. Now, on the second legal duty issue of does Texas law impose a duty on passengers to remonstrate? And And the short answer is, for generations, Texas has. The first case I cite to the court is Ford Motor Company versus Madden. It is 42 Southwest 2nd, 165. It is Texas Court of Appeals, Waco. And very simply, Your Honor, in the Ford versus Madden case, Madden was the passenger. Atwell was the driver. And the court goes into great detail to explain how the jury found in the facts of this case that Madden was not negligent in failing to request Atwell to decrease his speed, that Madden did not acquiesce in or approve of the speed Atwell was driving, that Madden did not fail to keep a proper lookout, that Madden was not guilty of negligence in failing to remonstrate or caution Atwell with reference to the speed the car that he was being driven. And then the court goes on to say that additional cases where appellate courts have recognized, oh, and by the way, Your Honor, this Ford versus Madden, this is law of the land. This case is shepherdized. This case is still good law. It's been good law for generations. This is, remonstration is like Mr. Good just said, it's just warrant. It's basically all it is, just warrant, do something. And in this case, Your Honor, the evidence that I have presented to you is overwhelming that Sierra had this duty to warn her mother, because Mr. Melton, the 17-year-old in that pickup, he could have wiped out their pickup. She had a duty to warn Sky, get off the road, the truck's coming, somebody do something, Mom, do something. And she herself was at risk, Your Honor, from the Melton pickup. She saw it coming from way down the road. So she, under these facts that are proven and established, they're not controverted, they're not disputed. Mr. Good in his response, or Blind, he doesn't dispute any of my facts in my response. And I go to great length to present you the evidence. And she herself was at risk. So there are two separate duties here that I have met the burden on. The first one is this foreseeability of harm creates a duty of care. That's long been Texas law. It applies in every possible conceivable negligence case you can imagine. It applies in premises liability cases. It applies in shopping cart grocery cases. It applies in car wreck cases. It applies in security cases where you have someone being sexually assaulted by another party, but yet the parent, the supervising parent or whoever knew about the rapist or his proclivity to rape and assault, and they did nothing. They covered it up. So the foreseeable duty, if you have the facts and it creates a harm, has long been Texas law, and I have certainly met that issue in this case, Your Honor. And then, of course, secondly, this duty to remonstrate, the case law goes on forever. The second case I wanted to mention to you, Judge, and this was mentioned and cited in the Ford versus Ford versus Madden case. Yeah.
And what was the site on that? Because when I hit search on your response, I don't come up with the word Ford.
I don't have it in my response, Your Honor. I found this last night, and in summary judgment or any point in trial, or you can raise law, you can raise legal authority at any time, and I apologize, but you won't find it in my response. I am raising it now, and I will supplement. The site is 42 Southwest 2nd, 165, Texas Court of Appeals, Waco. And it's Ford Motor Company versus Madden, M-A-D-D-E-N. And it's not in my response. I apologize, but legal authority can be cited at any time in a proceeding, even on appeal. And I apologize, Your Honor. I did not have.
Okay, that's fine. I
knew years ago. I'd done the research on remonstration years ago, and I couldn't find the cases that I used 3 years ago, so I had to recreate the wheel. Second, the other case that's cited by the Ford versus Madden is Murphy versus Milheiser, M-I-L-H-E-I-S-E-R, This is Galveston, Texas Court of Appeals, 30 Southwest 2nd, 586. It's in that case, the driver of the car was going 80 miles an hour and the passenger did nothing. And then the passenger sued and the courts and the jury imposed contributory negligence on the passenger doing nothing.
And do you have any cases where a third party has successfully sued the passenger for not remonstrating? It's one thing to tell the passenger you didn't remonstrate and therefore you're precluded from a recovery, but.
I may, Your Honor, 1 second. I do have a case to cite the court that may specifically address the court's question. It is Lofton versus Norman. It is 508 Southwest 2nd, 915. And this is Texas Court of Appeals out of Corpus Christi. And that case, Your Honor, is very similar. The facts of that case are not on all fours, but they are really similar. It's another 24-foot wide Texas remote highway. There's a collision that causes cars to be stopped in the roadway. And whether or not enough people warned of the oncoming traffic. So that case, Lofton versus Norman may very well assist you, Your Honor, in answering that specific question. So my answer is yes, this is not a novel issue in law at the appellate level, at the trial court level. You're not going to be the first judge that dealt with this issue, Your Honor, I promise you. So with that, the proximate cause argument, it's if you'll read the cases I cited in my brief, and also if you'll read the Ford Motor Company versus Madden, it's when you get to this much evidence for duty on the passenger, you've got proximate cause becomes a jury question. It's usually a jury question in these kinds of cases. And the breach, of course, is Sierra's failure to do something. Basically, as Mr. Good said, it's failure to warn, which I agree with. She should have done something. She was not asleep, as Mr. Good's trying to suggest. She is active, independent, tortfeasor. She's a player. And we all may disagree on her percentage of play or involvement, but that's for the jury. I think I'm done, Your Honor. Yeah, I'm done, Judge. I ask you to deny no evidence in the traditional. If I may, Your Honor, a couple of things. If the court will allow me to file supplemental case authority on these cases, I've cited you that I didn't have in my response. And secondly, on this traditional motion for summary judgment that Mr. Good's still pushing, I read his reply yesterday, and I don't see any evidence that gives him standing to argue to you today traditional summary judgment, because traditional summary judgment has to have evidence. You can't just say boo and you win, because that's the whole purpose basically of the no evidence. So my client has objected to any traditional motion for summary judgment that Sierra and her lawyer think they've advanced to the court today. It's wrong. It's not there. And if it is, I went ahead and briefed the traditional issues the same as I did the no evidence. Traditionally, you just show your evidence on proximate cause and duty and go forward. So I object to the continued claims of traditional summary judgment. It's not there, and I ask the court to grant plaintiff's objection and motion to strike the claims or whatever traditional summary judgment that Sierra Lambeck is trying to advance today, because she didn't meet her burden. She's got to have evidence. You don't get traditional without evidence. So with that, Your Honor, I'll stop. Thank you very much.
Your Honor, may I respond?
Yes, Mr. Franklin, is foreseeability enough generally in Texas law in your view?
Yes, sir. As long as, if you read my authority, as long as the person, in this case, the passenger, if the general danger, and Mr. Good even admitted this to you a while ago, Your Honor, when he was making his presentation, he agreed with me of that case law that I cited. You cannot, in doing this foreseeable duty analysis, you do not apply the current substantial factor proximate cause test. You simply consider whether Sierra knew or should have known of the general danger that was posed by the approaching vehicle that we know was the 17-year-old driving this big dually pickup, and that's it. So yes, foreseeability and proximate causes, it's a general danger, knowledge of general danger proximate cause, Your Honor. It's not the substantial factor. You know, Sierra Lambeck knew that it was a substantial factor, approximate cause to get for duty to be established. She just has to be aware of the general sense. And remember, Judge, she admitted, and I showed you this in my response, Sierra knew that truck, her mom had illegally stopped the truck in the middle of the road. They had created this block and this burden, this hazard to my client. They increased the risk of harm. So yes, and foreseeable risk of harm, foreseeability is the biggest evidentiary burden that I have. The cases that apply the foreseeability standard for duty are heavy, heavy, heavy facts. And I have taken you through Sierra's deposition ad nauseum, showing you that she appreciated the risk coming from way down the road. She knew that her boyfriend was upset. These two women wanted him in the truck come heck or high water, and that's wrong. They needed to get their truck out of the way, do something instead of blocking him and forcing him to the center line in front of this oncoming truck. That's wrong. So that's your duty, Your Honor. That's my evidence of the duty. It is mostly foreseeable and some per se as because of the truck being illegal stopped in the middle of the road. So you get there multiple ways. Thank you.
So if I see two people backing towards each other and two different automobiles backing towards each other in the HEB parking lot, do I have a duty to, because it's perfectly foreseeable that if they don't stop what they're doing, one of them at least, there's going to be a collision. Do I have any duty to those drivers or their
passengers? You do not, unless you are in one of those two vehicles or you're asleep in one of those two vehicles. If you turn around and are guiding your driver to back out or whatever, like Sierra was, she was actively engaged in this whole event, this whole series of events. Sky, get in the truck. Oh, we're stopped. Oh, we're blocking. Oh, there's a car coming. Oh, Sky can't go anywhere safely. Something says move, Mom, move the truck. Sky, do something. Truck's coming, vehicle's coming. So to use your analogy, Your Honor, there should be no duty in that case. You go by, it depends on the facts, and it's fact heavy. And I've given you pretty much all the facts that Sierra Lambeck was willing to give me on the day of her deposition, plus what can be reasonably inferred. So to answer your question on the bare bones facts that you presented me, I think that my answer has to be candidly no, because I don't see enough facts to where me as the third person would owe a duty to anybody unless you change the facts and put me in one of the cars and put me actively engaged in the backing process. It's factual. It's factual, case by case.
Okay. All right. And how long would you need? I don't need anything elaborate, but if there's any case law that you have where the duty to remonstrate has been used to hold a passenger liable for injuries to a third party and not just as a defense against the passenger's suit for damages, I'd like to see that.
Could I have a couple of days, Your Honor, until Friday or?
Absolutely. Absolutely. All right, Mr. Good.
Yes, Your Honor. One of the details I'd like to point out on this is just from a procedural posture, I'm asking for judgment as a matter of law. I am allowed to bring a traditional motion for summary judgment when the law is clear on the issues. So there is no requirement. I've re-reviewed it again. I've got Rule 166A in front of me, and it says that I may attach evidence. There is no requirement to do this. But just from a procedural posture, I believe we're here on good footing. Mr. Franklin stated a minute ago that he believes that foreseeability is enough. Case law says it's not. Neighbors Drilling, what I have underlined in my reply brief and cited extensively in my motion for summary judgment, clearly says foreseeability alone is not enough. A moment ago, Mr. Franklin just told you that the way that he gets here in this case, that it's so fact specific, is that it's the foreseeability in combination with the per se position of the pickup truck being parked illegally on the roadway. My client had no control over that vehicle. That has been made clear. There is no duty to control. In case law, as I've briefed in both of mine, generally speaking, there is no legal duty to control another's conduct at all. And he has put no evidence forth either in the case law that he has cited during today's hearing or in his brief to show otherwise. That's why this motion is a matter of law motion. There is no general duty to control somebody else. My client was the driver's child. In the limited exchanges where there is a special relationship between a parent and a minor or a child, that child is a minor. It doesn't go the opposite direction, and there is no duty to control here. Again, it's tough to tell from the pleadings. I'm trying to be cautious here. My client owed no duty to Sky to control his behavior too. Did no duty to the person seeking relief, Mr. Yates, or at least his estate. We've heard about the duty to warn. Your Honor, I'm interested in the case law myself. I have briefed, and on the second page, it begins on the second page of my motion for summary judgment. I have tried to highlight and show this court where a passenger was held responsible for the driver's conduct, where there was some duty to warn, where this is the case I'm looking at specifically. I got the wrong brief in front of me. Page 5, I'm sorry. The limited exception is a case particularly out of the Tyler Court of Appeals in Adams. And in that one, this is the one I was telling you about earlier. The passenger of the driver of the vehicle was traveling while smoking a marijuana cigarette. The passenger spilled a drink in his lap. There was some active contribution to the negligence by the passenger and asked the driver for a napkin, not to pull it over. And the driver subsequently struck. It was a novel set of circumstances. And Mr. Franklin said something that I want to highlight, and then I'll be quiet. I do like hearing myself speak sometimes. But the way he distinguished your analogy in the HEB parking lot to this moment was he said that the passenger in those HEB parking lot scenario could be held liable because they were actively involved in the backing up of the vehicles. That doesn't make any logical sense. My client was not actively engaged in any part of the operation of the vehicle here. Her focus was on the intoxicated man in the street trying to get him in. And again, the factual details here don't matter so much. This is a matter of law issue. But she had, I mean, the way that Mr. Franklin distinguished your analogy doesn't apply here. He said that there was an act that as a passenger in a vehicle backing up in an HEB parking lot, I've got a 9-year-old. We went to HEB last night. He took no active role in backing up that parking lot. I don't care if he was 25 or my mother's age when we go to parking to it. Passengers don't take active roles in the operation of a vehicle. If they were to, if a passenger reached over and somehow held on to the steering wheel, I agree, that might be a different situation, but my client was in the back seat and those aren't the allegations. The duty here is clear. It is improper to hold the passenger of a vehicle responsible for its operation, and there's no way to caveat this situation away from that. My client didn't have some sort of special control over the driver, over the Mr. Yates outside the vehicle, and it's therefore inappropriate to have a Wilson County offended or concerned by the idea that a backseat passenger is somehow responsible for that vehicle's operation. That's what I've got.
And are they responsible for the operation or just have a duty in some circumstances to warn the driver? I mean, obviously they don't control the driver, but I don't think I wouldn't expect anyone's contending that if the mother had been alerted of the danger and could see that it would coming, that she'd say, no, I'm just going to stay here and leave Sky Yates to take his chances.
In Your Honor, that duty to warn, as I've pointed out in my initial motion, Texas doesn't recognize that duty to warn. And I've got case law on that. That's what's been briefed. The general rule is that you don't owe duties to other people. That's why it's one of the necessary elements for a plaintiff to prove in a cause of action. And so no, I mean, not only could she not control the vehicle, but the duty to remonstrate or warn, my lexicon's grown bigger from this case, doesn't exist in in Texas. It's not recognized. There are, as I told you a moment ago in the Adams case, where the passenger was held responsible. It wasn't because of a duty to warn. It was because of the passenger's active contribution to the set of circumstances. Those facts don't match this.
Brief response, Your Honor.
Yes, and then we need to move on. Go ahead.
What Mr. Good just represented to you as an officer of the court is totally wrong. The Lofton versus Martin case, Norman case that I'm going to supplement by Friday, this 508 Southwest 2nd 915 is all about Texas's common law duty to warn, and it's a car wreck on a 24-foot Texas 2-lane highway just like we have here. So with all due respect to Mr. Good, it's, you know, it's wrong what he just represented to you. He's simply trying to win. The court, what you just observed, Your Honor, is right on. This whole issue for Sierra basically boils down to duty to warn. And the facts are there with all due respect. And my client would respectfully ask you to so find. Thank you, sir. That's all I have.
Okay. All right. I'll take this under advisement and let Mr. Franklin have until Friday to submit anything he wants to submit. And do you want any chance to reply, Mr. Good?
Yeah, if they're that clear cut, I would love an opportunity to see what they say. I haven't found any of those in his briefing. So to the extent necessary, can I have until the following Tuesday? And if I have no reply, then I'll file an advisory.
Yes. Okay. All right. The two of you are excused. Have a good day.
Thank you, Your Honor. Appreciate you.
All right, where do we stand in the Atascosa County case? Monsiváis?
Your Honor, we agreed to reset that case while you were not present.
Well, I was here. I just had my.
Oh, okay.
I just had my camera off.
Okay. I didn't know if you were taking a break or whatever.
Good thing you weren't talking bad about me. Okay.
We were not. We would never do such a thing. We reset that by agreement for February 24th. He wanted time to hire a lawyer. And I briefly met with him to see if we could reach an agreement, but that wasn't happening. So we reset it.
All right.
And then on the other case, we'd like to reset that one also. The Frio County case that I have with Mr. Corrigan and the Roberts.
All right. Zamzow?
Yes.
Until when?
Do we have anything? And I didn't know what the court had available. Do you have anything the week of?
Okay. I just show up and download the dockets and whatever is given to me.
So I talked to the boss, Lori.
Know if it's already full, things like that.
Right. So I was going to ask Ms. Riley if there's anything open the week of March 15th for the Zamzow in Frio County.
Any day that week.
You have available any day that week?
Yeah, 15, 16, 17, 18, any of those are available.
All right. Does anybody, Porter or Katie and Grady, do y'all have any preference on that week? Where'd they go?
Can I call my client just real quick and see if I can raise him, make sure he doesn't have any conflict? I'm okay any of those days.
All right.
If you get it settled, just post that to me in chat with cause number, name, date. That's all you need to post, just those 3 items, and you're excused after that.
Okay, Porter, I'll gonna go on mute, and then you let me know, and we can post it in the chat.
Sounds great.
Okay. All right, the O'Connor and Chapa case. How long for temporary orders, Ms. Roberts? All right, Ms. Roberts.
Your Honor, I think that was our motion, which.
Oh, your motion, okay.
So we want to drop it, of course, because I don't have a plan.
Your Honor, we also had a motion for temporary orders as well.
Okay, so how long to hear it?
I think it could take 30 minutes.
Okay, what are you asking to change on temporary orders?
We're asking to get some temporary orders so that my client has the actual custody, care control of the child.
Okay, and are you asking to restrict the mother's possession of the child?
There's currently a protective order in place, Your Honor, and we would like to keep that protective order in place. And she could have some visitation, but we'd want it to be supervised.
All right, I'll mark you down for 15 minutes. I mean, if there's a protective order in place, while it's in place and until something's been resolved to show it does or does not need to be in place, that would be appropriate to keep it there or to keep it like that. Okay.
Mark me down for a 1-minute response.
All right. Alvarez, still 60 minutes.
I think so, Your Honor, although I would be okay with a 30-minute announcement if Mr. Adams thinks we can get it done in that amount of time. I've considered, what I'm going to put on, and I believe he may just have only his client. I'm not sure what his views on that are, but I could get behind a 30-minute announcement, Your Honor, at this time.
Okay, well, all right. And the matter of the marriage of Martinez, Mr. Pena, Starling, are they still conferring? Yes, okay. And Sacramento Garcia, what was your time announcement?
No more than 15 minutes, Judge.
That's
All
correct.
right. We'll take that up, and then we'll take up Mr. Padilla and Ms. Roberts' case. All right, let me grab that file.
Lori, can you hear me?
Yes, I can hear you.
On the O'Connor and Chapa for Frio County,
Yes.
was that reset?
No, Katie and Mr. Padilla are going to have a hearing on that in just a
Okay.
few.
Okay. All right,
The
thank you.
Santos case is being reset to 2/16.
Yes, ma'am. I got that. Thank you.
Judge, I have to take a break for like 15 minutes and Jennifer's going to pop on. I'm going to make her host or co-host. I don't want to lose all my breakout rooms or whatever, but I have some people I think still in the breakout room.
Okay, go ahead.
Thank you.
Okay, who all needs to be sworn in the Garcia estate?
Stephanie Garcia, Blanca Martinez, and Henry Garcia, Judge.
And are they all available or present?
They are, and Mr. Henry Garcia is under Bernstein and Bernstein on Zoom.
Okay. All right, I see Miss Blanca Martinez, Stephanie Garcia. Would you unmute yourself, please, ma'am? And also Mr. Henry Garcia? Yes.
Okay. Yes, sir.
All right, and there's Stephanie Garcia. Will each of you raise your right hands? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do. I do.
All right, all three took the oath. Okay, who all is going to be speaking? Mr. Ecke and is ad litem and Mr.
And I will be doing it, Judge.
Okay, all right. And everyone's ready?
My first witness, I call Stephanie Garcia.
Okay, and Mr. Ecke, you're ready?
Yes, Judge, I'm ready.
All right. Go ahead, sir.
Ms. Garcia, please state your name for the court.
Stephanie Marie Garcia.
And how did you know the descendant Sacramento Garcia Jr.?
I'm a niece of his.
And is it true that Mr. Garcia passed away on or about February 16th, 2020 in Wilson County, Texas at the age of 75?
Yes, sir.
Is it also true that Sacramento Garcia Jr. had a fixed place of residence and was domiciled at 7300 FM 1303 Floresville, Wilson County at the time of his death?
Yes, sir.
To the best of your knowledge, did he have a will?
Not that I'm aware of.
Did he ever mention to you that he was going to have a will or get a will completed?
Not that I'm aware of.
Are you familiar with his marital history?
Yes.
He was married to a Nora Garcia, is that correct?
Correct.
And she predeceased him?
I'm sorry?
She predeceased him?
Yes.
And then he was also married to an Angie Flores, and she also predeceased him, is that correct?
Yes, sir.
Besides those two, was he married to anyone else?
Not that I'm aware of.
Did the decedent have any children?
Yes, sir.
Would that be Joe, Bonnie, and Henry Garcia?
Yes, sir.
And besides those three, did he ever adopt any other children?
Not that I'm aware of, sir.
And are Joe, Bonnie, and Henry all still alive?
Yes, sir.
Do you stand to inherit anything from Mr. Garcia's estate?
No, sir.
Has anyone promised you anything today in exchange for your testimony?
No, sir.
I pass the witness, Judge.
No questions, Judge.
All right, your next witness.
I call Blanca Martinez.
Go ahead, sir.
Ms. Martinez, please state your name for the court.
Blanca Esther Garcia Martinez.
And how did you know the decedent?
He was my first cousin.
And were you here to hear my questions to Ms. Stephanie Garcia?
Yes, sir, I was.
Would any of your answers change from how Ms. Garcia testified?
No, sir.
Your Honor, I pass the witness.
No questions, Judge.
All right, go ahead.
Mr. Henry Garcia,
Yes, sir.
can you please state your name for the court?
Henry Garcia.
And how are you related to Sacramento Garcia Jr.?
My father.
And is it true that he passed away on or about February 16th, 2020 in Wilson County, Texas at the age of 75?
Yes, sir.
Is it also true that he had a fixed place and was domiciled at 7300 FM 1303 Floresville, Wilson County, Texas at the time of his death?
Yes, sir.
Is it true that your father did not have a will?
Yes, sir.
Is it true that you, Joe, and Bonnie are all the sole heirs of Mr. Garcia?
Yes, sir.
Is it also true that you, Joe, and Bonnie are all in agreement that you serve as independent administrator and that all three of you signed waivers?
Yes, sir.
Is it true as far as you know, you are not disqualified to serve as an independent administrator?
Yes, sir.
Your Honor, at this time, we ask that Mr. Henry Garcia be appointed as independent administrator to serve without bond, and this is not a taxable estate, so we ask that no appraisers be ordered.
Okay, and have the other heirs filed their written consents?
They have, Your Honor.
I'm sorry?
They have.
Okay, all right. And is that everything?
Yes, Judge.
All right. So you're asking me just, and Mr. Recchi, do you have anything additional?
Judge, I submitted a report of the attorney ad litem in this case in June of 2020. I filed an answer. I was appointed on April the 6th of 2020. I filed an answer on April 27th. I have reviewed the copies of the documents that are filed with the court. I did contact Mr. Bancroft, who at the time was lead counsel for the applicant. And I also contacted an attorney named Christopher Rodriguez, who was representing some of the children of the decedent's wife who died before him. I interviewed all 4 out of 5 of those children and Ms. Martinez, who testified today, and Ms. Garcia, who testified today. They all of them were in agreement that the only 3 biological children of the decedent were Henry Garcia, Bonnie Sarver, and Joe David Garcia, and that the decedent did not take in and adopt or treat as his own children any other people. He did have some close relationships. He did operate a neighborhood bar in Floresville
Yes.
And so he had a pretty
Actually,
close.
out near Cañada Verde, northwest of town, but go ahead.
Okay, there you go. And so he was well known, and so his marital history was pretty obvious. I did run LexisNexis searches, but all the information that I uncovered from the witnesses and from independent sources verified that Henry, Bonnie, and Joe were the only 3 kids, and therefore the only 3 heirs of the decedent. And so with that, I would rest.
And why was this transferred to district court?
I think, Judge, at the time that Mr. Rodriguez was representing the children of the decedent's wife, I think Judge Jackson thought that it might be contested.
Okay. All right then.
But I don't think they ever filed any contest.
All right, then I'll find that Frank, Bonnie, and Joe are the 3 lawful children and heirs of the decedent, and I will appoint Mr. Frank Garcia, the independent executor, or not executor, independent administrator of the estate. Henry, I'm sorry.
Thank you, Judge.
Thank you, Judge. Will you be excused?
All right. Okay, now, did you submit orders on that?
We did e-file proposed orders, and then I have my client here that will be able to sign and get submitted to the court today, Judge.
Okay, all right, then I will sign those. If you want to post them to me in chat, I can sign them in chat. Grab them and then sign them also.
Thank you, Judge.
All right.
Grant, will you give me a copy of that order?
I will.
Okay, thank you, Judge.
Sorry, I called you by the wrong first name, Mr. Garcia. Have a good day, sir.
No worries. Thank you.
Okay. All right, Frio County case. O'Connor versus Shapa.
It's actually Cantu. That was my mistake,
I'm
Your
sorry.
Honor.
Okay. All right. What witnesses are you expecting? And I'll say that Mr. Padilla's announcing not ready, and I will overrule that. Is that correct, sir?
Yes, sure. Yes, on both counts. Yes.
Okay. All right.
Okay.
What witnesses do you have?
Yes, I have my client.
And is he there with you?
He is, Your Honor.
All right. Do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay. All right. And your name, sir?
William Patrick O'Connor.
All right. Go ahead, Ms. Roberts.
I live at 905 East Colorado, Pearsall, Texas.
Okay, and Ms.
I
Roberts,
can't hear
say something I can't.
at all.
I didn't hear any questions at all. I still,
live at-
ma'am.
I'm sorry. We only have a one laptop, so it's kind of difficult sometimes.
Okay.
I asked, where do you live?
I live at 905 East Colorado, Pearsall, Texas.
And how did you come to own this home?
My parents gave me this home in 1985.
How many bedrooms and bathrooms does it have?
It has 4 bedrooms and 3.
I can't hear you, sir.
It has 4 bedrooms and 3 bathrooms.
Okay.
Are you currently married?
Yes,
To whom?
to Eliza Cantu.
When did you marry?
We met in July of 2009.
Do you have any children?
Yes, we have 1 daughter. 5 years old.
What grade is Paige in?
I couldn't hear that.
Okay.
We have 1 daughter, Paige Lynn. She's 9 years old. She's in the 4th grade.
Who has been Paige's primary caretaker?
Myself.
At the end of last year, did you seek a protective order against your wife?
Yes, I did.
Is there currently a protective order in place protecting your daughter and you from your wife?
Yes, there is.
How is it going in the home since this protective order?
Very well. My daughter is happy. She's doing well in school. She's doing her normal hobbies, jumping on the trampoline, brushing the dog. We play ball daily. We walk the dog daily. We go to church every Saturday. We sing in the choir. She's a very happy little girl since the order was placed.
Where does Paige sleep?
Paige sleeps in her own room, in her own bed, and in the house.
Are you asking the court to be named the temporary sole managing conservator with the right to determine the residence of Paige?
Yes, I am.
Do you have any concerns about Paige and your wife being alone together?
Yes, I do. I'm concerned that if she's alone with Paige, she will be emotionally abusive, possibly physically abusive, drinking, possibly taking drugs around Paige. This is why I got the protective order.
No further questions, Your Honor.
All right, Mr. Padilla.
One quick question, Judge. Sir, before the protective order were you and your wife living together?
We were living in the same house, but she moved out 14 months ago.
We'll pass the witness, Judge.
Anything else for this witness?
No further question, or no, Your Honor.
All right, any other witnesses?
No, Your Honor.
All right, Mr. Padilla?
No, Your Honor.
Okay.
I'm no more witness.
All right, and what are you asking for at this time, Ms. Roberts?
We're asking for temporary sole managing conservatorship with the right to determine residence and education of Paige.
All right, and contact between the child and the mother?
In the protective order, my client asked that there's no contact. However, he asked if Paige wants to, she can contact her mother.
I'm not going to put it on the child. I mean,
Okay.
what happened? Is this a fisticuffs between parents that got a protective order, or did she attempt to murder them with a machete? What happened to get a protective order?
There were several things. Mostly it was she's drugged Paige across the front yard. She's been emotionally abusive towards Paige, and we're concerned with her and possible her drug use, and that's what got the protective order, Your Honor. It was a 2.5 hour, 3 hour hearing. I was only there for about an hour, hour and a half of it.
Okay, Mr. Padilla?
We would ask for some visitation, Judge, even if it's supervised. For the mother.
We'd also like to ask for a toenail. We've filed a motion for a toenail and fingernail drug test.
That was not set
in front of
today,
me?
Judge. No, Judge.
That's
It's
set for
not set
today?
for today. No, Judge, it isn't.
Okay, I will make Ms. Roberts' client the temporary sole managing conservator. Make the mother the temporary possessory conservator. And I'm going to ask the parties to confer in a breakout room. You ought to be able to go back to your breakout room. If not, I'll get you into a different one about whether there's some kind of supervised visitation. And with the idea being that if the mother can show that she's addressed any drug issues that there may be, that we can start moving back towards more of a regular visitation. We don't have to build all that in, but just at least telephone and or video conference contact with the child. Again, it doesn't have to be unsupervised with a 9-year-old, but not interfered with.
Okay.
So I'll let the two of you confer. Let me just go ahead and see if I can put you into. All right, well.
Judge, I got it covered.
Okay, good, because a while ago, earlier this morning, I could, like 30 minutes ago, I could see the breakout rooms, and now I can't. So,
Thank you, Judge. Appreciate it.
right.
Thank you.
And when do we need a entry date for this?
Sure. Can you give me about 2 weeks, Your Honor?
Yes, I mean, get with, not me, get with Miss Riley on dates.
Okay,
Okay, Judge. Thank you so much, Judge.
thank you.
Do you want us to report back to you, Judge?
If you have it worked out, no. If you don't have it worked out, and I need to make a decision, yes.
Okay. Thank you,
Okay.
Judge. Appreciate it.
Thank you.
All right. All right. Almarez, let me grab that file.
Yes, Your Honor.
Yes, Mr. Pena, do you have an announcement?
We do, Your Honor. We have an agreement. We need about 10 minutes or so to prove up the divorce.
Okay, let's go ahead and get that done right now. What county was that in?
It's Wilson County.
Okay, all right, I see. All right, in the matter of the marriage of Martinez?
Yes, Your Honor. I'm going to go ahead and allow Ms. Martinez to come sit at my chair, and hopefully you'll be able to hear my questions.
All right, and Ms. Starling, are you ready? Hold on,
Your
Mr.
Honor, we're ready.
Well, I'm not sure the other side is.
Sorry, Judge. I think I didn't see my client in, so I think I accidentally kicked him out when I called him, so he's going back in.
Okay. All right, let's hold on just a moment then. Okay, and what name or number is your client under?
The CVW 2000194.
No, I mean, what, I was asking Ms. Starling what name or telephone number her client's under on the screen, or is he there right now?
So I don't see him. My client's number ends in 2260. It's a 210 number.
All right, there's a gentleman who's muted on an iPhone. Is that him?
Yeah, yes, it is.
Okay, and what is his name?
Julio Martinez.
All right. Go ahead, Mr. Pena.
I call Ms. Matilda Martinez.
Okay. And let me ask Matilda and Julio Martinez to raise your right hands. Do each of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
Okay. Go ahead, Mr. Pena.
Would you please state your name for the record?
Matilda Luna Martinez.
Are you the respondent in this cause of action?
Yes,
Is Julio Martinez a petitioner in this cause of action?
yes,
Have you resided in the county of Wilson for at least 90 days and the state of Texas for 6 months?
yes,
Are there children of the marriage or any expected?
no,
Regarding the fault, it is a no-fault ground, is that correct?
yes,
The marriage has become insupportable because of discord and conflict of personalities, which destroys the legitimate ends of the marriage, and there's no chance of reconciliation, is that correct?
yes,
Were you married on or about April the 10th, 2019?
yes,
Were you separated on or about February the 5th, 2020?
yes,
Now, you have reached an agreement with regard to the division of the assets with your husband, is that correct?
yes,
And that agreement has been reflected in the Rule 11 agreement for final orders. Is that correct?
Yes.
Now, you've had an opportunity to read that.
Yes, sir.
You understand it.
Yes.
Okay. With regard to the division of the real property, in this case, there's a mobile home and real property at 137 Mill Encinos in Atkins, Texas. Is that correct?
Yes.
You own this jointly?
Yes.
All right. Now, you have agreed with your husband that you are going to allow him to essentially try to refinance this property by September 27th, 2021. Is that correct?
Correct.
And he's to obtain a release of you should he do so. Is that correct?
Yes.
All right. Should he not basically be able to do that by that time, it is agreed that the property would be sold by a licensed real estate agent.
Yes.
In the event that he is 45 days late in the payment of this particular debt, he is in agreement that you will have the exclusive right to list the property, that being the mobile home and the real estate and the real property with a real estate agent. Is that correct?
Right.
Okay. With regard to the division of the property regarding you, you are to get all sums of any cash on hand, matured, unmatured, accrued, vested, or otherwise together, with all increases thereof, the proceeds therefrom, and any other related to any profit sharing plan, retirement plan, CAC plan, pension plan, employee stock option plan, 401k plan, employee savings plan, accrued unpaid bonuses, disability plan, or other benefits existing by reason of your past employment, present employment, or future employment. Is that correct?
Correct.
And you're also asking that that particular asset also be given to your husband with regard to his past, present, or future employment. Is that correct?
Yes.
Now, you are to be awarded a 2012 Chevy Camaro,
Yes.
a 2014 Chevrolet Sonic,
Yes.
all household furniture and furnishings, fixtures and goods, and art collectibles that are subject to your sole control and possession,
Yes.
including a white dresser, white metal bench, peach metal rocking chair, red family checker cooking book, 3 light green ceramic pumpkins, 1 tan colored chair, 1 metal wall clock, a 26 by 26, farm frame, and 4 light green ceramic Christmas trees. Is that correct?
Correct.
All jewelry subject to your sole control and possession,
Yes.
and all sums of cash or other interest with regard to bank savings, institutions, etc. Is that correct?
Yes.
With regard to your husband, he's to be awarded the 2004 Chevrolet Silverado 1500, correct?
Yes.
And as you, all household furniture, furnishings, fixtures, object collectibles, basically awarded to him as described above, which would be the vehicle, all clothing, jewelry, and other personal effects in his possession are subject to his sole control. And of course, all sums of cash in his possession are subject to his sole control, including funds on deposit together with accrued unpaid interest in back savings institutions, financial institutions, accounts stand in his sole possession and control. Is that correct?
Yes.
And with regard to the delivery of the property that's been awarded to you, Mr. Martinez will make all good faith efforts to locate the items described above in 3A through I, and that you will have the right, or he has the obligation to surrender the property to you on February 6th at 10 a.m. at 137 Mill Encinos in Atkins, Texas. Is that correct?
Yes.
Regarding debt, you're to take on the Kohl's credit card, Wells Fargo credit card, all debts and liabilities incurred solely by you, and any debts that you incurred solely after March the 18th, 2020.
Yes.
Not correct. Okay. There are, regarding the debts and charges liabilities to your husband, there are many, A through U, an Academy credit card, Bell's credit card, Best Buy credit card, Big Lots credit card, Conn's loans, Firestone credit card, Hill Country loans, Home Depot credit card, and RS debt, and Kohl's credit card, Lowe's credit card, Macy's credit card, One Main loan, Security Service FCU loan, Target credit card, TG Maxx credit card, Tractor Supply credit card, Zell's credit card, JCPenney credit card, Midas credit card, and Texaco credit card. Is that correct?
Yes,
And all other liabilities and charges that he's incurred as of March the 18th. Is that correct?
that's correct.
All right, you're asking this court for a name change. Your Honor, we would be asking for a trial amendment to change her name to Matilda Montoya Luna.
All right, any objection?
No objection, Your Honor.
And
Yes, sir.
you have, I'm sorry, Your Honor.
Go ahead, Mr. Pena.
Thank you. You have had an opportunity to go over this with me. I've explained it to you. Is that correct?
That's correct.
And you understand all of it?
Yes, sir.
All right, you have signed this particular Rule 11 agreement that you know is binding and enforceable. Is that correct?
That's correct.
I have no further questions, Your Honor. Pass the witness.
I have no questions for this witness.
All right. Anything else, Mr. Pena?
I have no questions. I believe
What's that?
we'll be asked of Mr. Martinez.
All right, Mr. Pena, you broke up. I couldn't hear you.
I believe Ms. Starling is going to ask questions of Mr. Martinez. I would
Okay.
defer to
Ms.
her.
Starling?
Yes. Mr. Martinez,
Yes, ma'am.
we have gone over all the pages in the Rule 11 agreement, correct?
Correct.
And you understand the provisions regarding refinancing the house by September 27th, 2021, correct?
Correct, ma'am.
And you understand the division of debt, as well as that there is certain items that Ms. Martinez wants you to attempt to locate, and you're going to attempt to locate those. Is that correct?
That's correct.
And is this, I had to sign off on the Rule 11 agreement for you because you were unable to do it on your phone. Is that correct?
Correct.
And did you give me permission to do that?
Excuse me, ma'am?
Did you give me permission to sign your name to the Rule 11
Yes, I did,
agreement?
ma'am.
And that Rule 11 agreement is your agreement. And you understand that these are the final terms of the divorce.
Yes, ma'am.
I have no further questions.
Your Honor, may I address another issue?
Yes.
All right, Ms. Martinez, you understand the certain documents that must be executed, and I want to lay them out for you. A special warranty deed with encumbrances for royalty of partition, a deed of trust for assumption to secure partition, and a real estate lien note. Is that correct?
Yes.
And you understand that's part of what both the parties will have to execute in order for the property of the sale to work, the refinance of the property to work, or that the property must be sold under certain conditions. Is that correct?
Yes.
I have nothing further, Your Honor.
All right, anything else from either side?
Not from the petitioner, Your Honor.
Okay, and how long do you need to get this written up for an entry date?
Your Honor, we will try to get it done within 20 days, if that will be good with the court.
Okay, if you'll just get with Ms. Riley or Ms. Poppy to get a date, and if you can agree on a date for an entry date, just post it to me in chat and I will release you.
Very good, Your Honor.
All right, anything else?
Nothing further.
No, Your Honor.
All right. Ms. Cavazos, do you need a break before we start the Alvarez case?
Just a couple minutes.
Okay, well, let's come back at, let's call it 11:10. We'll be in recess until 11:10.
Thank you.
Thank you, Your Honor. May we be excused?
Mr. Pena and Ms. Starling,
Yes,
I can
sir.
work out dates with y'all.
As soon as you post the date in chat, you're excused.
Very good.
Thank you.
Will the 23rd work for y'all, or the week of the 16th, one of those dates?
Let me look right quick. I believe the 23rd would work.
Okay, 23rd is good, if that works for Ms. Starling as well.
Yeah, the 23rd is fine.
No, like I said, usually we keep.
All right, I'll put y'all down for that date then.
Thank you.
And if y'all want to post that in chat as well, just like the judge reviews that and updates his docket as well.
Very good. We'll do that.
Thank you.
Thank you.
And Mr. Martinez, you can mute yourself and then you can log off. We're done for the day.
Ma'am?
And then I said you can mute yourself and you can log off. You can leave the meeting because we're done. We're done for the day. And then within the next 20 days, I'll go over like the actual divorce decree with you. Mr. Pena is going to write it and send it over to me to look at.
Okay,
Thank you.
Thank you.
I'll be in touch.
we'll be in touch.
Okay, Kathy. Can you hear
Do
me?
you want me to put that in the chat?
Yeah, would you?
23rd?
Yeah,
I can do that.
23rd. Yeah.
Mr. Pena, can you send me the
Copy-
Rule
copy.
11-2?
Absolutely. I'll have it sent in just a few minutes.
Thank you.
You're welcome. I'm assuming the court excused us. I didn't hear him.
You know, now that you say that, I do think you said when we had the
I
date.
did. I said, as soon as you post the dates in chat, you're excused.
Very good. Thank you, Judge.
Thank you, Your Honor. You too.
Okay, I think we're done.
All right. Are we ready in the Alvarez case?
Yes, Your Honor.
Okay.
And Mr. Adams is my opposing counsel.
All right, Mr. Adams? There he is.
Yes, Your Honor.
Okay, and who all will be testifying?
Judge, I'm going to have two very short witnesses. I mean, they're going to be very, very short. I don't anticipate my side taking more than 15 minutes or so. It's going to be David Almaraz and Lori Rios Maldonado. David Almaraz is the petitioner, my client.
Yes, I read briefly the motion and the response and the motion to strike. All right, Lori Rios Maldonado. All right. Yes, Mr. Adams.
And we're ready, and I anticipate calling my client Victoria, who is the mom of the child.
Okay, and is she present? Victoria Rios, okay.
Yes, she is, Your Honor. I don't see her. There she is. Okay.
Yes. All right, let me ask everyone who's going to be a witness, that's Mr. Almaraz, Ms. Rios Maldonado, and Ms. Victoria Rios, to raise their right hands and unmute. All right, do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do. Yes, sir.
Ms. Maldonado?
Victoria.
Right, on Ms. Rios Maldonado, I did not hear you if you made a response. Okay, we can see you're trying to make a response, but your microphone is not picking up. It is unmuted. It went from mute to unmute.
Problem with your microphone, apparently.
Yes. I mean, I'm going to mute you again and ask you to unmute one more time. Let's just see if that makes a difference. Okay, and you're muted right now, which cuts off your microphone, but. And I just hit the ask to unmute button again, so you should get a message popping up. All right, now you're unmuted. We still can't hear you. All right, Mr. Srala, does she have access to another electronic device?
She's shaking her head yes. I'm not sure. I can, if push comes to shove, we can just proceed and I won't have to call her. I was going to ask her just a couple of questions anyways. But if she can log on with a telephone or something like that, then we'll proceed with her.
Okay. All right then. So are both sides ready?
Yes, Your Honor.
Yes, Your Honor.
All right. And go ahead, Mr. Srala.
Thank you, Judge. Just a brief opening. May it please the court?
Go ahead.
Judge, we're here today to tackle with the question of whether or not to extend a temporary restraining order that was signed by Judge Ellison on January the 15th into a temporary injunction. We submitted our pleadings with the court, and the evidence today will show that there were concerns with the mother of the child, the respondent, Victoria Rios, her fiance, I guess, Carlos Anthony Ventura, we believe to be a dangerous and violent man. He's been the subject of 3 prior protective orders. He was charged with aggravated assault with a deadly weapon on or about 2014. And we believe that he has struck this child, who is a 5-year-old child, the subject of this suit. What strikes me as very important, Your Honor, is the fact that Ms. Rios, when served with our temporary restraining order, simply ignored it. The temporary restraining order, the language at issue, ordered her not to expose the child to Carlos Anthony Ventura, also known as Nico, who is her fiance, because he's dangerous. And she simply ignored it. The evidence will show that when my client asked her if she wanted to surrender the child to him in order to help her come into compliance with that TRO, she refused. So with that, subject to Mr. Adams making, I guess, his own opening statement, I would call my first witness, but I'll defer to Mr. Adams if he wants to make an opening.
I would like to make an opening statement.
Go ahead, sir.
I represent the mom, and it is true that she has been, she and Carlos Ventura, we refer to him as Nico. That's what everybody calls him, okay? And I'm going to refer to her as Victoria. She's the mom. They met, and back in April of 2019, they moved in together in August of 2019. They decided that they wanted to have a kid, so she got pregnant in April of 2020. And on December the 23rd, little over a month ago, she had her baby. And his name is, come on, smart aleck. I'll tell you his name in a minute. They had a little boy. And lo and behold, and they, today on her birthday in December of 2020, he proposed to her, and they're now engaged to be married. He helps her not only with Aaliyah, who's the subject of this hearing, but as I said, he is the father of Xavier Ventura, who was born on December the 23rd of 2020. And so now they go and tell all these lies about my guy. They claim that, oh man, they allege in the thing that he had a sexual assault involving a deadly weapon, which is totally not true. It is true that way back in 2015 or 2013, he did get charged with an assault involving a deadly weapon. He got charged and it was dismissed. In fact, he's presently in the process of getting it expunged because it was a false charge. They allege, so they want to claim that he's this bad guy. They want to claim that he has hit the child. He has spanked the child. He's never bruised the child, never done anything to the child. Mom, who, as I said, has the new baby and is the mother of the Aaliyah, the child of this thing, depends on him to help her with those two children. And now they go in and get this court order that says he has to leave the house. He can't be anywhere around Aaliyah. And so when they came to talk to me the day after that he had been served, then mom had to take the child, Aaliyah, both children, up to Austin to be with the grandmother, her grandmother, so that they could obey the court order. And dad had to stay, Nico had to stay here in the apartment where they live. All of the allegations that they've made are false and not true. All of them are hearsay. And now they want to make it permanent to keep Nico away from his fiance and his child and the other child of Victoria, who is Xavier. This is just a travesty of justice, Judge, that this thing was ever issued. Because if you look at it carefully, the affidavit, you can see that it is clearly all hearsay. We'd also tell you further that the Lori Rios Maldonado, the grandmother, in other words, the mother of the stepmother of Victoria, is the one that's creating all of these problems. And she has called Child Protective Services out. Child Protective Services went up to Austin and have talked to Aaliyah. And basically they have told my client that, hey, this is ridiculous. And if there was a problem, Child Protective Services would be doing something and taking care of this case. So now also I would point out to the court that Mr. Srala has asked for a change of venue, and we agree with it because this case needs to be in Bexar County where they all live. And so the only thing that the court is going to do today is just decide whether or not to extend this spurious temporary restraining order until we can get to Bexar County and do whatever. And so that's where we're at. That's what's going on. Thank you.
Judge, one thing that I would add is that CPS is indeed looking into this. Mr. Adams is correct. And it's my understanding that CPS investigation is not complete, that they have not made any determination as to whether or not there was reason to believe or whether or not to issue some other finding. I'm told that they are waiting on multiple police reports from the San Antonio Police Department that have apparently been called out to Victoria's home.
Okay, but we don't have anyone from CPS here?
No, we don't.
All right. Where's Mr. Ventura?
I'm sorry?
I just saw somebody raise their hand. Yes, sir.
I subpoenaed Bradley, Mr. Bradley, who is with CPS.
Oh, well, then that's great. Then he is here. He's the one that I was referring to that has told me that he's not yet completed his investigation. And it's my understanding, apparently now the evidence will show that they are waiting on some police reports that apparently evidence the police coming out to Ms. Rios's home were in connection with her and Mr. Ventura, Nico.
All right. And sir, what is your name?
Sir, my name is Keith Bradley with Child Protective Service.
Okay. KIETH?
Yes, sir.
All right. And Mr. Adams, you said you subpoenaed him, or who subpoenaed Mr. Bradley?
I subpoenaed him.
Okay.
And the reason is because if there was anything that was even remotely suspicious about this, they would have done something. And for the court to have gone in and issued this restraining order when CPS isn't even saying there's anything there is ridiculous. That we need to get rid of the restraining order, hand it over to Child Protective Services if they find something.
Okay. All right. Let me ask the attorneys to meet in a breakout room with Mr. Bradley, just so you can find out what he's going to have to say. And because you're telling me that rather than just we all find out at once, let me just.
Well, he has talked to Mr. Bradley, Mr. Srala has. In fact, he gave me Mr. Bradley's name and he had talked to him first. He knows everything he's going to say.
All right. Well, let me ask the two of y'all, the three of y'all. Mr. Bradley, you should have received a meeting, an invitation to a breakout room.
Yes, sir, I did.
All right, let me ask y'all just to talk there briefly. And before you go, Mr. Adams, where is Mr. Ventura?
Mr. Ventura is at home right now, and I can get him on the Zoom if need be.
All right, because I'll let both the attorneys know my concern is the safety of the child and not so much the technicalities of the affidavit. If the things in the affidavit are true, then I have a great deal of concern about what's going on with the child. If the things in the affidavit aren't true, that's a completely different kettle of fish. So, I mean, that'll be the main thing I would be concerned about.
Yes, Your Honor.
Okay, so I'll let y'all confer and just let me know whenever you're ready.
Thank you.
Okay, Judge. Thank you.
Ms. Rios Maldonado, were you able to get your microphone working, or do you know?
Yes, sir.
Okay, it's working. All right, thanks.
Judge, I'm not sure if we still have the floor, but we're back.
Yes, okay, so where do we stand?
Okay, well, he's going to testify. Do you want me to tell you what we talked about, or do you want me to just say?
No, I mean, I didn't know if anything had changed. We just need to go ahead and plow through the hearing?
Yes, sir. Yes, sir.
Okay, all right. Your first witness?
Yes, Your Honor. I'm going to call David Almaraz.
All right, go ahead.
I want to make sure he's off mute.
All right, Mr. Almaraz, I muted you a while ago.
Okay. Mr. Almaraz, can you hear me?
Yes, sir.
Can you state your full name for the record, please?
David Scott Almaraz.
And you are the father of Aaliyah Almaraz, right?
Yes, this is correct. I am.
And Aaliyah is 5 years old.
Yes, this is correct.
She's going to be turning 6 in a couple of weeks. Am I correct?
Yes, sir.
And the mother of the child is Victoria Rios. Is that correct?
Yes.
Okay. And when you came to me, you had some concerns about Victoria and her boyfriend, Carlos Anthony Ventura. Is that true?
Yes, sir.
What were the nature of your concerns, just generally speaking, sir?
Physical, emotional, and psychological abuse.
By whom?
Victoria and Carlos Anthony Ventura.
Okay. Has your daughter, do you have concerns that your daughter is being spanked and or hit by either Victoria and or Carlos?
Yes, sir.
Did your daughter describe to you what it feels like when she gets hit?
Yes, sir, she did.
Okay. What did she say that made you think she may have been hit?
Objection, hearsay.
Judge, if you let him answer, we're not offering this for the truth of the matter. We're offering it to demonstrate or to ask the court to infer from this statement that the child was hit. Okay.
I'll overrule the objection.
What was it that the child said that made you conclude that she may have been hit?
She said that Nico's hand feels like a rock.
Okay. And are you concerned about the child being spanked by either Nico or Victoria?
Yes, sir, I am.
Okay. Have you observed any bruises on the child's bottom as a result of the corporal punishment?
Objection, Your Honor. Since he is not, may I take him on voir dire to see whether or not he was ever present for any, what he alleges may have occurred?
Judge, I asked him what he observed, not that he, I'm not saying he was there when it happened.
We don't, children get bruises just from falling and whatever.
Okay, Mr. Adams, I'll overrule your objection and let you take him on cross-examination later.
Mr. Almaraz, you can answer my question, which was, did you ever observe any bruises on the child anywhere?
No, sir, I did not, but Lori Rios Maldonado says she did.
Okay, thank you.
Yes, sir.
Are you aware of whether or not Mr. Ventura has been the subject of any prior protective orders by other women?
Yes, sir.
How many times did this occur to your knowledge?
3 times, 2 different women.
Objection, Your Honor. This would be hearsay. Where would he be getting such information? And we deny that that exists, except for when a divorce was filed back, but we'll go into that later. So we object as hearsay.
Judge, if I can respond, he's looked at, and I'll question him about this, of course, but he's looked at the actual pleadings in the court pleadings, protective orders, because he gave them to me. So it's not hearsay. He's basing it on viewing of court records.
All right, I will overrule the objection, but I mean, you're going to have to show what you have, so.
Yes, sir. Yes, sir. Yes, sir. Mr. Almaraz, did you view the actual protective order that was issued by Kelly Nicole Spencer?
Yes, sir, I did.
And did you view her affidavit, which described violence committed against her by Carlos Anthony Ventura, Nico?
Yes, sir, I did.
Okay. And are you also aware in a similar way of two protective orders, of one other protective order filed by Kate Aaron Murphy?
Yes, sir, I did.
Objection, Your Honor. There is no court order concerning whoever there is that they're alleging.
All right, Mr. Adams, I don't know what the situation is at all. I mean,
Right.
I'll let him answer the question and you can put on controversial evidence.
Okay.
So you are also aware of a protective order secured by Kate Aaron Murphy?
Yes.
Did you lay your eyes on that protective order?
Yes.
Okay. And these were court documents that you've seen, correct?
Yes.
Okay. And have you also seen court records of whether or not Mr. Ventura was charged with aggravated assault with a deadly weapon?
I did. Mr. Strala, in the interest of this being temporary orders, I think that Mr. Adams has stipulated that happened, and he said that it was dismissed. So do you have any evidence of a conviction or deferred adjudication, or that it was 1244?
I do not. I think it may have been dismissed because the witness was afraid to testify, but that goes to
Your Honor. Here.
All right. So I'll ask you, you've got that in evidence that for the purpose of this sort of hearing, I'll ask you to move on.
I'll just move on, Your Honor. Thank you. Okay. After our protective order had been issued, after our restraining order had been issued, did you ask the court to restrain Victoria Rios from having the child around Nico?
Yes, sir, I did.
And subsequent to that, did you have a conversation with Victoria Rios about the restraining order?
No, she wouldn't speak with me.
Okay. Do you have any knowledge of whether or not she allowed the child to remain around Nico after the issuance of the restraining order?
Yes, I do.
Objection. It would be, he has no, how is it he would have personal knowledge?
I'll overrule the objection and let Mr. Strala see what his evidence is.
Yes. What is the basis for your knowing that? What you said you were aware that she, did violate the restraining order. How do you know that, David?
Well, I went to the apartment where they lived with the police, and she refused to speak with me or to abide by the restraining order. And they stayed there in the house for almost 24 hours.
So you identified your daughter as being there at the apartment at that time?
Well, no, sir, I did not see her, but Nico answered the door. Victoria came out, but she wouldn't speak to me. She wouldn't abide by the order.
But it's your belief that Victoria and Aaliyah were there with Nico?
Yes, sir. It is my belief.
Okay. What do you want the court to do today, David?
I would like the temporary restraining order to be made permanent or extended at least.
Okay, thank you. Pass the witness, Your Honor.
Go ahead, Mr. Adams.
Thank you, Your Honor. Mr. Alvarez, my name's Ray Adams. I just have a few questions for you. Now, you and Victoria were living at your parents' house starting in 2011 or 2012. Is that correct?
Not 2011, 2012.
Okay. And on more than 6 occasions, you hit her, choked her, kicked her, busted her lip. Is that true?
No, sir.
You never hit her?
Sir, we did get into it, but not 6 times. And she was also part of the, she hit me and busted my lip as well. but it was not 6 times. No, sir.
5 times?
I would say 4, possibly 5, not 6.
And isn't it true that you were frequently intoxicated?
Yes, sir, that is true back then, but I am a reborn Christian and I do not drink alcohol or do drugs.
And you were using drugs back then, right?
Alcohol, yes, and cigarettes.
How about other types of drugs?
Marijuana, yes.
Okay. And it's true that you hit your mom and shoved her through a wall. Is that correct?
I shoved her into a wall, not through a wall.
And the police were called.
Yes, sir, that is correct.
And you were intoxicated at the time.
Yes, sir, it is a point of my life that I am very ashamed of, but as I mentioned, I do not drink anymore and I am a changed, reborn Christian in the eyes of the Lord. Praise the Lord.
And it's true that in either April or May of 2019, that you pulled Aaliyah off of her bicycle because you got mad at her, causing her arm to be bruised with a handprint on her arm. Is that true?
No, sir.
Did you pull her off of her bicycle?
No, sir, she can't even ride her bicycle. At least at that point in time, at April 19th, she could not ride her bicycle on her own. She still is scared of the bicycle. She doesn't ride it.
So have you ever pulled her off of the bicycle?
I might have helped her to get off of the bicycle, but I didn't pull her off of the bicycle.
Now, did you try to call Aaliyah yesterday?
Yes, sir, I did.
Did Victoria let you talk to her?
Not in the initial call, but then she told me she would have her call me. So yes, sir, I did get to speak to her.
So you talked to Aaliyah yesterday, right?
Yes, sir.
What did you tell Aaliyah?
I asked her how she was. I told her I loved her, asked her what she wanted for her birthday, told her I already got her a couple things, but that I wanted to have some more information so I could get her something else.
Did you tell her not to trust her mom?
I told her that Nico was a bad man because they have continually been trying to coerce her to defame my character, to belittle me.
So you told her that Nico was a bad man, is that correct?
Yes, sir.
Did you tell her not to believe her mom?
I don't recall, sir. I don't recall that.
Did you say anything about her mom to her?
I can't recall, sir.
Did you tell her that Lori, the step grandmother, was trying to help you get custody?
No, I did not tell Aaliyah that.
Did you tell her that you were trying to fix it up so that Lori can see her?
I did not tell Aaliyah that. No, no, sir.
Did you? Okay.
I did reassure Aaliyah that her grandparents love her very dearly. And I told her not to worry, that it will be okay and that she'll get to see them.
Did you tell Aaliyah, not yesterday, but in the past, that all cops are bad?
No, sir, I did not tell her that.
So the only evidence that you think that maybe Mr. Ventura had bruised her, Aaliyah, came from Lori, is that correct?
No, we actually, when all of this happened, we heard a conversation from Victoria with my mother, and Victoria's own voice, she said it, she confirmed it. While me, my father, my mother, Mr. Maldonado, and Mrs. Maldonado were all sitting around a table.
And when was that?
I can't recall the exact date. It was in the later half of December of 2020.
So right after she had her baby?
No, before that. Victoria was not there in the room. She was on the phone.
And where were you?
I was amongst next to my mother, father, and Lori Rios Maldonado and Daryl Maldonado.
Now, how often do you see your daughter?
On the first, third, and fifth weekend of every month, if there is a fifth weekend.
And those are the only times that you see her, is that correct?
Yes, sir.
So you personally don't have any firsthand information about any of this, is that correct?
I object, Your Honor, that misstates the evidence. I understand it's cross-examination, but I want to get that on for the record.
And overrule the objection. I believe I remember what the testimony is. The witness can answer.
Can you repeat the question, please?
That's okay. Just a moment, Your Honor. I pass the witness.
Just real quick. Yes, Your Honor. Just one more question for you, David. When you testified that you heard Victoria speaking on the phone, what did Victoria say that you heard?
Can you give me a second? Everything's going really fast in my mind right now. Can you even repeat what the initial statement made by the other opposing lawyer was?
What did she talk about?
I'm gonna
I think
object.
you were, yeah.
Mr. Adams, your objection?
My objection is leading.
Sustained.
I'll just ask another question, Your Honor. When you were speaking with opposing counsel about whether or not the child had been whipped and whether or not you had observed a bruise, I think you testified that you overheard Lori say something. You overheard Victoria say something while she was on a phone at another location, correct?
Yes.
Do you remember what Victoria said that you heard?
Well, she defended Mr. Ventura in the spanking, and I believe Victoria said it wasn't even a real belt.
Okay. Pass the witness, Your Honor.
No further questions.
Your next witness?
Yes, I'm going to call Lori Rios Maldonado.
Go ahead.
Hello, Lori. Can you state your name for the record, please? She's on mute.
All right, ma'am, I've asked you to unmute your device.
Yes.
Lori, can you state your full name for the record, please?
Lori Rios Maldonado?
Are you the maternal grandmother of Aaliyah Amadas?
Yes, not
Okay.
biological.
Okay, not biological. Okay. You are Victoria's mother, is that correct?
I've raised her since she was 10, yes.
Okay, you're her stepmother then.
Yes.
Okay, got it. I'll get right to the point, ma'am. Did you have a conversation with Victoria about Aaliyah being whipped with a belt?
Yes.
What was that conversation? Can you
I have the text message. I had Aaliyah all the time. I raised her for 4.5 years, practically. I had her for a visit and I was giving her a bath and I saw a bruise, a line going across the top of her rear end. And it was a bruise and with red around it. And I asked Aaliyah what happened, and she said Nico spanked her. And I asked Victoria about it. And well, actually, me and my husband both did. I told my husband, and then he wanted to confront her and ask her about it and let her explain. And then when we asked her about it, she got upset and went and told Nico. So they both got mad and left. And then she sent me text messages later saying that she spoke with Aaliyah and that the spanking was, she did say it wasn't even a real belt, is what she said, which I don't know what that means. I do have the text messages.
Okay. Have you seen anything in the way that your stepdaughter Victoria acts that would lead you to believe that she's fearful of Nico herself?
Everybody's seen a change in her. She doesn't, it's like she has to cater to him, basically. She's never been one to like really get attached to anyone, even when she was with David for the years she was with him. She doesn't get clingy, and now she is. He's with her all the time. He comes in and she's constantly taking him food or drinks. He makes her drive everywhere. Just a lot of odd behavior. We're not allowed to take pictures of him, which is really odd. He yelled at my 13-year-old for trying to take a picture of him at a family gathering. And then he yelled at my husband, and that's when my husband got upset and started all this. They think I started.
Okay. Are you aware?
And I did not call CPS. David did. And David would probably shake his head and say, yes, you did. I did not call CPS. That was his choice because she did not relinquish Aaliyah after she was served.
Okay. Are you aware within the last year of whether or not the police have been called out to Victoria's apartment where she resides with Nico?
Objection, Your Honor. There'd be no way she would know that.
Except that Victoria told me.
Ma'am, there's been an objection made. All right, I'll overrule the objection. We'll have to see what the answer is.
You can answer, Lori.
Actually, Carlos told me. I got a call on March 10th, I believe, from Nico. And when I answered the phone, he said, hey, have you heard from Victoria? And I said, no, why? And he said, well, she's going to have to find another place to live. And I said, okay, that's not a problem with us. She's always welcome at home. And he said that she had pulled a knife on herself and that he had to call the police on her, but then she took off before the police got there. And then I asked him how long ago this had happened, and he said about 10 minutes ago, and then also told me that he had her phone. So I was wondering how she was supposed to call me. He's asking me if I'd heard from her. I felt like he was trying to jump ahead of the situation and tell his side before she could say her side.
Okay.
And then about maybe, I don't know, 45 minutes or an hour later, maybe longer, I don't know. I got a call from Victoria's phone. I thought it was him, but it was her. And she just said, hey. And I said, hey. And she said, I'm going to be coming over and bringing a load of stuff with me. And I said, okay. And she said, then I'm going to have to come back and get the rest. And I was like, okay. I had Aaliyah for spring break. And then this was the week after spring break that got extended because of COVID. And Aaliyah had been with me for like 8 days or so.
Okay.
Victoria walked in with bags of stuff, told Aaliyah that they were going to be staying here. Aaliyah got all excited. Then she left to go get a second load. And then when she came, when about an hour and a half later, 2 hours later, I finally got a text from her, and she said that her and Nico were both on their way back to get the stuff that she had dropped off. And Aaliyah was already in bed. So then the next morning I had to explain to Aaliyah why her mommy wasn't here and that she wasn't going to be staying here, that they were going back over there.
Do you have concerns about the stability of Aaliyah under Victoria and Carlos's care?
Very much.
Okay.
I never thought I'd be in this position.
Is it hard to have to testify against your stepdaughter?
My God, yes. She's treating me like I've done everything. But I've done everything for her, and she knows that.
Your Honor, I'll pass the witness.
Adams.
Thank you, Your Honor. Now, you said there was this bruise that you saw on Aaliyah.
Yes.
When was that?
I don't remember. I'd have to pull up my text message.
You can't, it was last year or year before, or what?
It was last year.
Okay, early part of last year, middle of last year?
I can't remember. I know, well, it had to be early part.
So the early part of 2020 is when this bruise occurred. Is that correct?
Yes.
And did you report that to Child Protective Services?
No, I just wanted to tell Vicki to let her take it to, I figured if there was something going on, Vicki would know and she would take care of it.
Why? I just asked you if you reported it to CPS.
No.
Okay. And then you say that Nico called you on March the 10th of 2020.
I believe it was the 10th.
Okay. And he said that he had called the police?
Yes.
To report what Victoria had done?
Yes. That he couldn't deal with her anymore and she needed to find another place to live.
All right. And then they reconciled and moved back in together. Is that correct?
Yes.
Are you furnishing funds to Mr. Alvarez for these attorney's fees?
My husband did pay for his attorney's fees.
Adams?
I think it's very relevant to show that Mr. Almer, that they're furnishing all the attorney's fees money for Mr. Alvarez, and that he's the dupe that's being pushed forward to try and get at Victoria.
All right. The question's already been asked and answered. I'm not going to strike the answer. I'll ask you to move on, sir.
Yes, sir. I have no further questions.
All right, Mr. Trella?
I have nothing further of this witness, Your Honor.
Okay, any other witnesses?
I would like to call Mr. Bradley, Keith Bradley.
Is he still in the breakout room?
No, he's in the courtroom, Your Honor.
Okay. Sorry. All right, would you unmute your microphone, please, sir?
Yes, sir.
And do you swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear and affirm, so help me God, sir.
All right, thank you. Go ahead, Mr. Swallow.
Thank you, sir, Your Honor. Mr. Bradley, are you an investigator for CPS, Child Protective Services?
Yes, sir, I am.
And were you called upon to investigate some allegations concerning the child, Aaliyah Almaraz, age 5?
Yes, sir, I have been.
Okay. And what have you done pursuant to that investigation, the overview?
Well, sir, we initially, I will call the reporting person and speak with them to get more clarity on on the allegations of what they did see or what they didn't see or what they've heard. I'll speak to the friends and neighbors. I've checked the school that Aaliyah attends, went to the apartment complex, spoke with the apartment manager, and I attempted to speak with Mr. Ventura, Ms. Victoria, and the child, but they were not there.
Okay. Has your investigation revealed evidence that the police have been called out to the apartment occupied by Miss Rios, Victoria Rios, and Carlos Anthony Ventura?
Yes, sir. When I spoke with the apartment complex manager, she said that the police have been out. The last time was when they were served, and she didn't know what the other ones were for. And so I have to request those records through San Antonio Police Department.
But you're concerned that there were other calls, right?
Yes, sir.
Okay. And when did you request these records from San Antonio Police Department?
I did that Friday.
Okay. Is your investigation complete?
No, sir, it is not.
Have you developed any conclusions about whether or not there would be reason to believe or ruled out at this point in time?
No, sir, I have not. I still need to go over the testimony from, we had to do a request to Travis County for a courtesy worker to go out and interview the mother and the child. And I have to go over everything with them to see if there was any indication if the child made an outcry or anything. But so far, she has not reached out to me, because if the child had made an outcry, we would have had to have implemented a safety plan. But I still need to talk with the courtesy worker.
Okay. Pass the witness, Your Honor.
When was this first reported to Child Protective Services? What was the date?
The intake was called in January 22nd, sir.
January 22nd. And so that's when you first heard about this case got opened, right?
Yes, sir.
Would it be fair to say that if the department had any concerns, that y'all would already be doing something?
If the department had concerns with the child?
Yeah, I'm sorry.
Concerns with the child, sir?
If the department had
the department, yes, sir. Yeah, if the department had any concerns, yes, sir, we would have, because it's always about the safety of the child. And if we had had any concerns for the safety of the child, we would have implemented a safety plan. Yes, sir.
And that has not been done. Is that correct?
No, sir, it has not.
Thank you, sir.
But
it's
just quick follow-up. But as you've testified, your investigation is still outstanding.
Yes, sir, it is.
And those circumstances could change, could they not?
Yes, sir. I'm just waiting to see what's said on the police reports. Yes, sir.
Thank you. No further questions, Your Honor.
One last question. And the person who called the department to lodge a complaint was David Alvarez?
Yes, sir.
Thank you. Nothing further, Your Honor.
Nothing further, Your Honor.
All right. So you have no witnesses, Mr. Adams, or you have nothing further for this witness?
I have nothing further from this witness.
Okay. Any other witnesses, Mr. Shralla?
No, Your Honor.
Go ahead, Judge. First time I've done that. Go ahead, Mr. Adams.
Okay. Thank you. I'd like to call Victoria Rios Maldonado at this time, Your Honor.
Go ahead.
State your name for the record.
Victoria Ann Rios Maldonado.
And you're the mother of Aaliyah?
Yes, sir.
Now, have you ever witnessed, who is Carlos Anthony Ventura?
He is my fiance.
And when did y'all first meet?
We first met back in April of 2019.
And when did y'all move in together?
August of 2019.
And y'all have continually lived together since then?
Yes, sir.
And then you got pregnant, a planned pregnancy in April of 2020?
Yes, sir.
And that child was born on December the 23rd of 2020?
Yes.
And what's the child's name?
Xavier Ventura.
And then when did, now you call Mr. Ventura Nico, is that correct?
I do, yes, sir.
In fact, everybody calls him Nico, right?
Yes, sir.
And he proposed to you on your birthday, December the 26th of 2020?
Yes, sir.
So y'all are going to be getting married?
Yes.
Okay. Now now you were previously with David Almara, is that correct?
Yes.
Were y'all ever married?
No.
How long were y'all together?
I would say maybe 2.5 years.
And did y'all get divorced?
Never married, no divorce.
Never married, y'all were just together, okay.
Yes. Mhm.
And did he ever hit you?
Yes.
Did he ever choke you?
Yes.
On how many different occasions?
The choking at least twice. Hitting, I mean, multiple times. All the times where he was intoxicated.
Did he ever bust your lip?
Yes.
Kick you?
Yes.
Did you witness him hitting his mom?
I did.
On how many different occasions?
Just once.
Was he intoxicated at the time?
Yes, sir.
Or has he ever harmed your daughter?
No, not that I know of.
And did he? Now let's come back to Nico here for a second. They're trying to allege that he spanks your daughter and leaves bruises on her. Does he do that?
No, sir.
Has he ever spanked your daughter?
Yes.
And do you spank your daughter?
Yes, I do.
Have you ever left bruises on her?
No, sir.
Now they are also trying to claim that he locked her out on the patio. Has he, to your knowledge, ever locked your daughter out on the patio with the dog?
No, sir.
Has Nico ever done anything to your daughter Aaliyah that would lead you to believe that it's unsafe for your daughter to be around him?
Absolutely not. Nothing.
So you trust him?
Absolutely. Yes, sir.
Okay. Now, were you aware that he was married before?
Yes.
To Kelly Spencer?
Yes, sir.
Were you aware that they got divorced in 2015?
Yes, sir.
And were you aware that in that divorce, she had sought a protective order?
Yes.
Okay. And has he ever exhibited anything towards you that would lead you to believe you need to be fearful of him?
No.
Has Nico ever hit you?
No.
Has he ever So you feel safe with him, is that correct?
Yes, I do.
Now, it is true that he called the police out to the apartment back on March the 10th of 2020. Is that correct?
Yes, sir.
Okay. And do you know what happened that day? Briefly.
Sorry, go ahead. Briefly, we got into a very heated argument. We were both really stressed out, and it got pretty ugly, and I ended up leaving because I didn't want it to escalate. So I left.
And were you aware that he had called the police?
Yes.
And then y'all worked it out and got back together that same day. Is that correct?
Yes, sir.
Have there been any other incidences like that?
No.
I pass the witness.
Go ahead, sir.
Thank you, Your Honor. Ma'am, are you aware that your child describes Nico's hand as feeling like a rock?
Yes.
Does that concern you that your child described Nico's hand that way?
I mean, she's a child. Spanking hurts, so no.
Okay. You don't think that's an indication of the force with which Nico may have struck the child?
No.
Did you ever see Nico whip the child with a belt?
Yes.
Okay. How many times how many licks would he typically give your child when he hits her with a belt?
Well, when he hit her, it's only been once with the belt, and it was just twice.
Okay. And are you aware that per the testimony of Miss Lori Rio of your stepmother, that bruises were observed on the child's bottom in 2020?
Yes.
And she confronted you about that, didn't she?
Yes.
And your response was to defend Nico rather than address what had happened to your child. Isn't that true?
Yes.
Have you ever seen, or strike that, let me phrase it this way. Are you aware that Nico has left the child in a car because she couldn't unbuckle her 5-point harness car seat?
Yes, I was present during that time as well.
Did you think that was okay?
Yes.
Okay.
She was not left alone.
She was in the car.
Yes.
Who was with her in the car?
Me and Nico were outside of the car. The door was open.
Okay. Are you aware that Nico has locked her on the patio with the dog?
He has not locked her out in the patio.
Okay. Now the cops have been called out to your apartment there, where you live with Nico, on numerous times in the last year, haven't they?
Just once.
Yes. And that's the one that you described
Yes.
when you had a fight with Nico?
Yes, sir.
But he didn't put hands on you at all. Is that your testimony?
That's correct.
Okay. Have you ever spoken to Kelly Nicole Spencer about what happened to her?
No. No, sir.
Have you ever spoken to Kate Aaron Murphy about what may have happened to her?
No, sir.
Okay. After the point in time when you were served with the temporary restraining order restricting the child from being around Nico, did you allow the child to be around Nico since that time?
Yes,
So you violated the temporary restraining order, didn't you?
I did. It was sprung up on us so fast in the evening. It was almost 8 o'clock at night. I have a new baby. We It was just sprung up on us too fast, but then the following day we did abide by it. And I mean, he even walked from the attorney's office after we left.
Okay.
Mm.
Forgive me if I've asked you this already, but I'm trying to make sure I cover everything.
Yes,
Are
sir.
you aware of the 3 protective orders that have been prior issued against Nico?
I'm aware of the protective order. He doesn't have 3, just the 1.
Well, are you aware that Kelly Nicole Spencer filed for and did receive a protective order secondary to her divorce with him? You're aware of that one, right?
Yes, sir. Yes.
Okay. And are you aware of the allegations that were made in that public pleading?
Yes, sir.
Okay. One of them was that Nico turned a knife on himself at one point. Isn't that true?
That's what the report says.
Okay. Are you also aware of whether or not Kelly Nicole Spencer received a military protective order against Nico?
Yes.
So that's now 2 protective orders that you're aware of, correct?
Yes.
Okay. So when you said before you're just aware of the 1, were you just mistaken?
It just the whole divorce protective orders and all that. That's the one that I know of and I'm aware of.
Okay. And are you aware of another protective order issued to protect Kate Erin Murphy?
I've heard of that one, yes, but there was no protective order made.
Then.
No court order.
And what was the time frame when you were together with David Almaraz?
Mm-hmm.
What was that time frame? 2012 to when?
That was 2012 through 2015, right after Aaliyah had been born. We tried to work things out, but
I see. But your testimony about acts committed by David Almaraz would have been prior to 2015. Isn't that true?
Yes.
Okay. Pass the witness, Your Honor.
All right, go ahead, sir. Anything else?
They've asked about the 5-point harness. Tell the court about that.
So there is a clip at the top of the harness that's fairly easy to undo. At that time, she had already learned how to undo that. It's something that, she was excited about doing. And so when we got back to the apartment, we got out of the car and we said, all right, Aaliyah, you can do it. Let's do this, and she just, I don't want to do it. And we were trying to cheer her on. Come on, girl, you can do it. And it was 5 minutes. And finally we were just like, all right. So we just undid it for her.
Okay, so what they're complaining about was the fact that y'all were trying to wake the kid out. So the kid knew how to unlock herself, right?
Yeah. Yes. Mm-hmm.
But she was refusing to do it.
Right. She was being a little stubborn. Yes.
Now there's this so-called incident out on the patio. Does Aaliyah know how to unlock the patio door and go out on the patio?
She does, yes.
Does she go out there on occasion?
Yes. Mm-hmm. Yes.
And then after she's out there, does she know how to open the door and come back in?
Yes.
Okay. Have you ever seen? Have you or Nico ever locked her out on the porch?
Never, sir.
I pass the witness.
I have nothing further, Your Honor, of this witness.
Right. Any other witnesses, Mr. Adams?
Well, Judge, you said that you'd like to hear from Mr. Ventura. So if, with the court's permission, I'm going to get Victoria to go take the baby and take care of the baby and let Mr. Ventura come testify.
All right, please.
Your Honor, Nico is currently out walking the baby. He's not here at the moment.
How far away is he?
I'm not too sure. I mean, we're in an apartment complex, but I can reach out to him and see how far he went.
Okay, can you call him?
Yeah, absolutely.
Okay, please call him and have him come back, okay?
All right.
I need to run a brief errand, and then we've got the other case to start afterwards. I'm gonna take about a 20-minute recess. I hope to be back at 12:45, and then we'll get this finished up and jump into the not Intervest, but Apperson case. Apperson versus EOG. So I'll be back in 20 minutes.
Thank you, Your Honor.
Thank you, Judge.
Your Honor, Nico is about a minute away. He's right outside the complex, so he'll be here shortly.
The judge took a recess for like 20 minutes, so he'll be back about 12:35.
Oh, okay, perfect.
Okay.
Unmute.
Now that puts us in.
All right, I'm back.
Okay, Your Honor.
Good afternoon. Afternoon. Okay, and are you ready to proceed, Mr. Adams?
Yes, Your Honor.
Okay, and are you Carlos Ventura? You're muted.
Yes, sir.
All right, would you raise your right hand, please? Do you swear or affirm that the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Go ahead, man, sir, Mr.
Thank you.
Adams.
Now, Mr. Ventura, you're also known as Nico, is that correct?
Yes, sir.
I'm going to refer to you with the court's permission as Nico, if that would be okay, or would it?
That's fine.
Now, let me back up a little bit. Where are you employed?
I'm employed at CNF Technologies.
And what do you do for them?
I'm a network engineer and developer.
And do you have to have any special clearances as a result of this?
Not in my current position, no, sir.
Okay. Are you applying for a position that would require you to have a special clearance?
I'm sorry, could you repeat that, sir?
Okay. Have you applied for a position that would require you to have a special clearance from the government?
Yes, sir.
And so what you do is government work?
Correct. Yes, sir.
And how long have you been working for the government, or with these people that work for the government?
With this company, I've been working for them for, since April of 2019.
Okay. And now, how long have you been with Victoria?
I've been with Victoria almost 2 years now.
Now, now you realize they've made these allegations against you. And I'd like to go through these allegations with you, okay? First of all, they claim that you have a violent and dangerous history. Is that true?
No, sir.
They claim, describe your relationship with Aaliyah.
My relationship with Aaliyah is great. I see her as a daughter, and I do a lot for her. I love her, and I count myself as having 2 kids here.
Okay. And is it your responsibility to take care of Aaliyah at times?
Yes, sir.
Has she been left alone with you by Victoria at times?
Yes, sir.
Okay. Have you ever spanked her with a belt?
Yes, sir.
How many times?
I spanked her once with a belt, sir.
Okay. Did you cause a bruise on her bottom when you did that?
No, sir, I did not.
Now, do you remember offhand the date on which you spanked her on the bottom?
I do not remember the date, sir, no.
About how long ago was it?
It was at least a year ago, year to year and a half.
Okay. Did the grandmother accuse you of bruising the child?
Yes, sir, she did accuse me.
And did you tell her that you did not?
I did tell her that we did not, or that I did not bruise her.
Right. Now, have you also spanked the child with your hand?
Yes, sir, I have.
And has Aaliyah ever told you that your hand feels like a rock?
I heard this afterwards, but she hasn't told that to me directly. No, sir.
So, but Aaliyah never told you that?
No, sir, she hasn't told me that.
Is now Aaliyah, is she an outspoken child?
Yes, sir. Very
Okay.
much.
So she pretty much tells everybody everything?
Yes, sir.
Okay. Now, when did you hear that Nico's hand feels like a rock? When did you first hear that?
I don't remember exactly. I think it was sometime early last year.
Okay. And as a result of that, did you change the way you spanked her with your hand?
Yes, sir.
And how did you change it?
I was definitely more careful about it, because of that sort of, those sort of accusations.
Does her mom ever spank? Does Victoria ever spank Aaliyah?
Excuse me?
Does Victoria, ever spank Aaliyah?
Sometimes, yes, sir.
And what does she spank her with?
With her hand, sir.
Okay. Has Victoria ever told you that you shouldn't spank Aaliyah too hard?
No, sir.
Now, have you ever locked Aaliyah out on the patio?
No, sir.
When we've already been told about how she was in the harness in the car, and that y'all were trying to, and is she able to take herself out of the harness?
Yes, sir, she is.
Okay. Now, they claim that you left her in the car and that she could not undo her 5-point harness. Did you ever do that?
No, sir.
The only incident was where she knew how to unlock the harness, and y'all were trying to get her to unlock it, right?
Yes, sir.
Now, they have accused you at first of sexual assault involving a deadly weapon. Have you ever been charged with sexual assault involving a deadly weapon?
No, sir, I have not.
Have you ever been charged with assault involving a deadly weapon?
Yes, sir, I have.
And when was that approximately?
That was late 2013.
Okay. And who was the person who was the complainant in the case?
It was my best friend at the time.
A guy?
Yes, sir.
And what happened?
He was trying to steal my gun and ammunition from my bedroom.
And what did you do?
I tried to stop him from leaving my bedroom.
With your gun and ammunition?
With my gun and my ammunition, yes, sir.
Were you able to get it away from him?
I was for a time, yes.
And later on, was a charge filed against you for that?
A charge was filed against me for it, yes, sir.
And what happened to those charges?
Those charges were dismissed, sir.
Okay. Do you know why they were dismissed?
As far as I know, from conversation with my attorney at the time, the, I guess, complainant had written a letter refusing the charges.
And sent that to the prosecutor?
Yes, sir.
Okay. And are you in the process of getting that expunged?
Yes, sir, I am.
Now, they claim that there are 3 protective orders against you. So let me back up. I'm going to mention some people here. Did you ever know a woman by the name of Kate Murphy?
Yes, sir.
And when did you know her?
2013, sir.
And how did you know her?
I had dated her at the time.
Okay. Did she ever get a court-ordered protective order against you?
No, sir, she did not.
Okay. Now then, did you know a woman named Kelly Spencer?
Yes, sir.
Were you married to her?
Yes, sir.
What year did y'all get married?
2014, sir.
Why did y'all get married?
We got married because she was pregnant and I was pressured to marry her by her family.
And after you got married to her, what did you find out about the pregnancy?
I found out that she had been cheating on me and I didn't believe the child was mine.
And then when did y'all divorce?
Our divorce was finalized in 2015.
And after you were divorced, were believing that the child was not yours, did she file a termination of your rights in that child?
Yes, sir.
And you signed off on that, right?
Yes, sir.
But nobody ever did any paternity tests, right?
Correct. There was no paternity test.
Now, she alleged in her divorce petition, she was seeking a protective order. Did she ever hit you?
Yes, sir, she did.
How many different times?
There were at least 2 different occasions that I can remember.
And how many times would she hit you on those occasions?
One of them, she hit me once, and the other, she hit me about 3 times.
Did you ever hit her?
Yes, I did on the occasion where she had hit me 3 times.
And did you ever hit her any other time other than that?
No, sir, I did not.
And after the divorce, you've never seen Kelly Spencer since?
Correct.
Do you know a woman by the name, did you ever know a woman by the name of Esther Rodriguez?
Yes, sir.
And when did you know her?
I knew her at the very beginning of 2019.
So this was before you had met Victoria.
Yes, sir.
And how is it that you knew Esther Rodriguez?
I dated her for a brief period of time.
Did she ever hit you?
Yes, sir, she did.
On how many occasions?
On 1 occasion, sir. Excuse me.
And as a result of that, did you break up with her?
Yes, sir.
Did you ever hit her?
No, sir, I did not.
So the only protective order that's ever been issued against you would have been by Kelly Spencer at the time she filed for divorce, right?
Yes, sir.
Would you ever harm Aaliyah?
No, sir.
I pass the witness.
Excuse me?
Mr. Schroeder.
Thank you,
I
Judge.
pass.
Oh, okay.
Yes, sir. Does it concern you, Nico, that Aaliyah describes your hand as feeling like a rock? Does that cause any concern with you at all?
Yes, sir, that does concern me.
I mean, one could infer from that implies that you've struck her with your hand, doesn't it?
I don't believe so. If by struck with your hand, you mean punched or something, definitely not.
Okay. And are you aware that Aaliyah at least perceives that she?
I'm sorry, the connection's kind of cutting out.
I'm sorry. I'll keep
Hello?
I'll keep trying.
No, it's good. It kind of went for a second.
I'll keep trying. Are you aware that Aaliyah at least perceives that you've locked her out on the patio?
No, not until now.
In fact, you've locked your prior girlfriends out on the patio also, haven't you?
No, sir.
Are you aware that whenever the child was in the car struggling with the 5-point harness, that the child was screaming for you and for her mother?
Yes, sir.
Okay, that's not something that Victoria talked about on her direct testimony, is it?
I don't know, sir.
Okay. Do you think it's appropriate to leave a child in a harness when she's screaming like that, to be let loose?
I think since we were right outside the car and she was under direct supervision, you know, she ended up undoing the seatbelt on her own.
Okay. Are you aware that Victoria testified to the opposite? She testified that y'all got in there and undid the harness for her.
I'm not aware of that.
Okay. Now, there have been, talking about Kelly Nicole Spencer, the woman who you were married to, and you've acknowledged the one protective order that she had against you, right, through the court system?
Yes, sir.
There was also a military protective order that expired on January 15th, 2015. Isn't that true?
When was the date you said?
It expired on January 15th, 2015. A military protective order.
I'm not aware of the exact date, but yes.
Okay. So you're aware of the military protective order?
Yes, sir.
In fact, whenever you were going through your divorce with Kelly and she applied for the court-issued protective order, part of her allegation against you was that you weren't complying with the military protective order. Isn't that true?
I did comply with the military protective order, so that's not true.
Indeed, you came around her in 2014 when you were subject to the military protective order, despite the military protective order. Isn't that true?
No, sir.
Didn't you come around her on or about October 15th of 2014 and slap and hit Miss Spencer?
Wait, I'm confused here. You said October what?
October 15, 2014, on or about that date. And this is according to the sworn affidavit of Kelly Nicole Spencer that was attached to her affidavit to a protective order. I'm asking you whether or not you slapped and hit petitioner on or about that date, the petitioner being Kelly Ann Spencer. Kelly Nicole Spencer.
If I don't know the exact date, but that sounds right.
Okay. So you slapped and hit her, and then she goes on to say that after that, you grabbed a knife and came toward her. Do you recall that?
No, sir.
She then says you proceeded to hurt yourself with the knife and threw yourself to the ground. Are you denying that?
I deny that. Yes, sir.
Are you aware that this was the basis for her receiving her protective order against you?
I am not aware of that.
So you didn't receive notice of her affidavit back in 2015?
I received notice of an affidavit, but there were no specific allegations in it that I am aware of.
So you didn't read it?
Asked and answered, Your Honor.
Overruled.
Did you read it, sir?
Excuse me?
Did you read it?
Yes, sir.
Okay. Then you would also know that she says that you admitted to her that you had been in jail before.
Yes,
Is that
sir.
true? Okay.
Yes, sir.
How many times you been in jail?
Once, sir.
For what?
For the charge in 2013.
What charge was that?
That was the assault with a deadly weapon charge.
How long were you in jail for that, sir?
I'm sorry, I didn't question.
How long were you in jail for that, sir?
I don't remember the exact number of days. I think it was a week and a half or two.
Okay. Are you aware that Kelly Nicole Spencer also accused you of trying to set fire to her apartment?
No, I'm not aware of that.
Are you also aware that she alleged in her affidavit to get her protective order that there was a history of mental disorder requiring shock treatments in your family.
I'm not aware of that.
Are you aware that she told you that she told the court rather that she believed that you were mentally unstable and that you had an intent to hurt her if you had an opportunity?
I am not aware of that.
Now, this is the same Killian Spencer who gave birth to Evelyn Nicole Spencer during your marriage to her. Is that true?
Yes, sir.
And this is the child that you voluntarily relinquished your rights to. Am I correct on that?
Yes, sir.
Okay. Now you mentioned Esther Rodriguez hit you from time to time, correct?
No, sir.
Did she hit you once?
Yes, sir.
Okay. You also mentioned that Kelly Nicole Spencer hit you on at least one occasion, right?
Yes, sir.
You also, now did Kate Erin Murphy ever hit you?
No, sir. She did not.
Okay. Why do these women keep hitting you, you think?
I don't know, sir.
So could it be that you're violent toward them?
No, sir.
Could it be that you take liberties like spanking their children when perhaps you shouldn't?
No, sir.
Now, when the police were called to your apartment back in early 2020, do you recall that?
Yes, sir.
Did you call police?
Yes, sir.
Why did you call the police on that day?
I don't remember exactly, sir.
What was the dispute you were having with Victoria Rios on that day?
I don't recall at this time, sir.
You don't recall at all?
No, sir.
Okay, you don't recall any circumstances about that? I mean, such as did Victoria hit you?
No, sir.
Did she push you, shove you, grab you, anything like that?
No, sir.
Did you push or shove or grab her, anything like that?
No, sir.
So it was just an oral argument that you had with her then?
Yes, sir.
It did cause her to take Aaliyah and leave, didn't it?
No, sir.
Are you aware that she testified that she left on that day?
I say no because Aaliyah was not with us at the time.
Okay. Are you aware that she left you on that day?
Yes, sir.
Then y'all reconciled apparently, and she came back.
Yes, sir.
But there was no violence, is your testimony, right?
Yes, sir.
Okay. Where's Aaliyah today?
Aaliyah is, I believe she's at her grandma's house, but there were talk that she might go to her aunt, but she's in Austin.
She's in Austin. How long has she been in Austin?
She's been in Austin since last week.
Okay. Have you seen her since January the 15th?
No, sir.
Okay. Did you ever have any altercations with Kate Erin Murphy?
What do you mean, sir?
Any altercations, any fights?
Yes, we had oral arguments. Yes, sir.
Y'all had several arguments, didn't you?
Yes, sir.
And she ended up calling the police on you a couple times at least, didn't she?
Yes, sir.
And were you ever arrested as a result of that?
No, sir, I was not arrested.
So can you kind of understand with your history with these various women? I mean, there's at least 3 of them prior to Victoria that you've had altercations with. And we know of at least 3 protective orders between those women. Can you understand why Mr. Alvarez might have concerns about you being a violent guy?
I can understand that. Yes, sir.
Your Honor, I'll pass the witness.
Mr.
No
Adams?
questions.
All right, do both sides rest and close?
Yes.
Yes, sure.
argument?
Yes, Your Honor. I think the evidence in this case speaks for itself. Mr. Nico would tell the court that he's not a violent guy, but we've got on the record of at least 3 protective orders issued against him, one of them being a military protective order. And we've got evidence that the child says his hand feels like a rock. He's not admitted to hitting her with a fist or anything like that, but he has admitted to spanking her with a belt. His grandmother has found that to leave a bruise on him, on the child. We've got various altercations with various women. He even understands why David would consider him a violent threat to his child. And I won't go through them one by one, but I know the court has been paying attention, and there have been multiple inconsistencies, not only between Nico's testimony and Victoria's testimony, but also testimony that Victoria gave wherein she contradicted herself. You know, she at first said that she was only aware of one protective order. Then she admitted that she was aware of the other 2. That's one inconsistency I'll underscore for the court. The other inconsistency is that when Victoria Rios testified about leaving the child in the car in the 5-point harness, she made it sound like it was just kind of a little game almost that they were playing. They were standing right outside the car. And then she said that she went in after some minutes and that she unbuckled the child. Well, we now know from Nico's testimony that, well, in fact, the child was screaming and that didn't concern him, and that the child, he said, got herself out of the 5-point harness. Now, these may seem like insignificant details, Your Honor, but I mean, it's inconsistencies in the story. I think they're making this up as they go along. And I think that concerns my client. It concerns me. And I believe it may concern the court. The allegations against Mr. Nico from Kelly Nicole Spencer are violent and hideous. She said he turned a knife on himself. He denied that, but it's sworn, and it was the basis for the protective order that he agreed to. So I don't think he can run too far from that. And I would say, Your Honor, that if they're inconsistent about these various facts in telling their story, I don't think we can be assured that they followed the restraining order, number one, and nor can we be assured that they would continue to follow it if the court leaves it in place. So I think if the court does leave it in place, we're going to have a real issue in terms of ensuring compliance with a court order, Your Honor. I would ask that the court maintain the restraining order, convert it to a temporary injunction, and that if Ms. Rios, that is Victoria Rios, and Nico prove an inability to comply with the court order, I think the court would be left with no choice but to ask that Victoria Rios surrender custody of the child at that time to David Almaraz, Your Honor. So we're going to ask that the restraining order be made a temporary injunction at this time, Your Honor. Thank you.
What happened to the allegation of aggravated sexual assault that was described in your client's affidavit?
I think that was a misprint, Your Honor. He thought it was a sexual nature, but then we got the paperwork and it turned out it was just aggravated sexual assault with a deadly weapon. So I don't think we're alleging at this time that any sexual assault occurred. I do recognize that that was in the affidavit. That is incorrect portion of the affidavit, Your Honor. I acknowledge that.
Mr. Adams?
Your Honor, according to the temporary restraining order, it specifically says prohibiting Victoria from possessing the child, Aaliyah, in the presence of Carlos Ventura or allowing any contact between the child and Carlos Ventura. As the testimony has shown, Mr. Ventura, Nico, has lived with with Victoria since August of 2019. There have been no incidences at all, except for the one time where they had a verbal argument and he called the police. Now, the only allegations that they used to get this bogus temporary restraining order was they tried to claim, number one, that he has a violent and dangerous history, that they claimed that he had bruised her with a belt, and they tell us today that they don't list the date in the affidavit. Today, we find out that the allegation supposedly was early 2020, so almost a year ago. Child Protective Services not called. Nobody thought that was anything, or Child Protective Services would have been called or something would have happened. He's denied bruising the child. He did say he spanked her one time. And then they talk about this, Nico's hand feels like a rock. Many times children will describe the way they feel. You know, if you get hit with a rock, it hurts. So if the hand hits you, spanks you, it hurts. So it can feel like a rock. We don't know what the child meant by that. We do know that Victoria spanks the child. He has spanked the child with his hand, but he's denied doing that. In the affidavit, they claim that he locked her out on the patio. He's denied that. So has Victoria. We've all heard the story about the harness. The kid can undo the harness herself. They were trying to get her to do that. So all of that is bogus. Then they turn around and they want to make a big deal about this. They want to say that it was a sexual assault involving a deadly weapon. He explained what happened about that. And the fact that all those charges were dropped. Now they want to make a big deal out of back in 2015. Hey, his ex-wife, who he was with for a short period of time and had we believe to be not his baby by somebody else, that there was a protective order. Whoa, and so judge, because of that old protective order, there must be something wrong here. They don't tell us anything he's done in the last, with Victoria. Nothing, zero, to nada. But hey, there might have been something back then. Did they bring Kelly in to testify? No. They claim an Esther Rodriguez. Did they bring her in to testify? No. They claim a Kate Murphy. Did they bring her in to testify? No. They're just trying to stir things up. And what they want to do is they want you to keep them, to keep the child away from Victoria because they all live together, and thereby force the court to then hand the child over to David Almaris, who has admitted on many occasions to hitting Victoria, beating her up, beating up his mom, being intoxicated, having used drugs. I mean, has a horrible, horrible past that but then he comes in and he says, oh, by the way, though, we can all change. We can all be better. But Mr. Ventura, nah, he's bad. He's horrible. And they can't give us anything he's done. So I would request the court to do away with this restraining order. And if we already know that Child Protective Services is doing an investigation, if they find anything, they'll take care of it. There's nothing there, and they haven't proven anything today. So I'd ask the court to please do away with the with this restraining. Thank you.
All right, anything else, Mr. Straw?
No, Your Honor.
All right. I will not extend the TRO and make it a temporary injunction at this time. Attorneys will send me an order stating that. And have you already had an order signed on your agreed motion to transfer?
Not yet, but we'll get that to you as well, Your Honor.
Okay, you can either e-file it or you can submit it in chat.
Thank you, Judge.
All right, Mr. Cavazos, do you need a break? And y'all are excused.
Thank you.
Do you need a break before we start the next case? No. All right. So, Mr. Wiemeyer, Apperson versus EOG. You're still muted.
Thank you, Your Honor. With respect to the defendant group, we're ready to proceed. I do have an outline in the form of a PowerPoint presentation that, if it pleases the court, I'd like to share screen and maybe visit through as we go today.
Go ahead.
And I was just going to count noses and toes here to make sure we have everybody back. I don't think we're missing anybody. Mr. Ellis, can you share screen, please, today's presentation?
Martha?
Your Honor, can you see that all right?
Yes.
Okay, never mind.
And Mr. Ellison, we can hear your audio feed. Your Honor, what we're here on today is a motion for summary judgment. That's a traditional motion for partial. It's premised on statute of limitations grounds. And here there's a collective defendant group with approximately 14 or more defendants. In terms of just the procedure, what we did here against the claims of 20 plus plaintiffs is file the partial traditional motion for summary judgment on our affirmative defense of limitations. And all of the collective defendant group has joined in the particular motion that were filed for my particular clients. And so that's all right before the court today and ready for decision. To just start, the Cosgrove versus Cade Texas Supreme Court case, that's been a very important case that touches on our oil and gas legal field. The quotes there, I think, as we go through today's presentation, bear very materially on the court's decision. In that case back in 2015, the Texas Supreme Court said, quote, "The virtues of legal certainty and predictability are nowhere more vital than in matters of property ownership, an area of law that requires bright lines and sharp corners." The court said, as with latches, the fundamental premise of limitations is simple. Quote, "If you snooze, you lose." And in this particular situation, these plaintiffs didn't snooze by a year or 2 years or 5 years or 10 years. These defendants snoozed by over 20 years. And as you look at the particular declaratory relief that they asked for in their motions for summary judgment, they snoozed by as long as 75 years. Just as the Texas Supreme Court said in Cosgrove versus Cade, here the plaintiffs snooze, and what we've proved by the uncontroverted evidence is that the plaintiffs lose. Have the next slide, please, Mr. Ellis. This is just an excerpt from our amended answer that shows at paragraph 7, we pled statute of limitations as a defensive bar. With respect to the legal analysis, I understand that the court very frequently is called on to apply cases like Cosgrove versus Cade and to apply statute of limitations, but I'm going to go through the elements just very quickly, and I can't imagine that there's any disagreement out of the plaintiffs on this. But at the next slide, this is a quote out of a case, the State of Denman. That's a San Antonio Court of Appeals case that we'll talk about later, but this is a fairly recent 2011 case that's binding precedent on this court. And what the court there says is that a defendant who moves for summary judgment on the affirmative defense of limitations must conclusively prove the elements of the defense. Thus, a defendant moving for summary judgment based on limitations must prove as a matter of law, 1, the date on which the limitations period commenced, that is, when the cause of action being asserted accrues, and 2, that the plaintiff filed its petition outside the applicable limitations period. So as we talk about the uncontroverted and incontrovertible evidence today, those are the two elements that I bear on behalf of my clients when I come and ask you for a judgment as a matter of law dismissing these claims as untimely. Have the next slide. Let's talk about that first element. When does the plaintiff's cause of action here accrue? What the Texas Supreme Court case in Exxon versus Emerald tells us is that causes of action accrue and statute of limitations begin to run when facts come into existence that authorize a claimant to seek a judicial remedy. When a cause of action accrues is normally a question of law. And so kind of one of the themes that I want to emphasize as we go through the uncontroverted evidence today is when did the plaintiff's causes of action accrue? That is, when did limitations begin running because facts came into existence that authorized these plaintiffs to seek a judicial remedy from this court? When did that happen? Next slide, please, Mr. Ellis. This was mentioned on the preceding slide, but I think it's incredibly important in terms of just emphasizing how ripe this case is for a decision as a matter of law right now. The timing of accrual of these plaintiffs' causes of action is a question of law for this court. It requires resolution before we ever get to any trial in this case. And so the standard that we measure here is when, as a matter of law, did facts come into existence that authorize these plaintiffs to come and ask this court for their judicial remedy. Sometimes when we come to court, there are fact issues, and the fact issues do not bear on necessarily on when the accrual occurs. The fact issues get into if they've alleged accrual based on the discovery rule or based on fraudulent concealment. And so there are certainly fact situations where a cause of action's accrual date is deferred. The way that comes about is if there's discovery rule issues or if there's fraudulent concealment issues. In our reply papers, we've directed the court to the case authority that's not controverted here by the plaintiffs, that if you're going to come in and plead discovery rule or ask for deferral based on fraudulent concealment, they have to affirmatively plead that to the court, and they have to come in response to this motion for summary judgment and support that with evidence. Here, the court is not burdened with any analysis of deferred accrual of causes of action, that is potential fact issues, because the plaintiffs have not pled any deferred accrual, and they haven't brought the court any evidence to support deferred accrual, and they haven't even argued deferred accrual. There's also a separate concept of tolling of the statute of limitations. That is, once a cause of action would have accrued, there's a host of different ways that it could have tolled after that. And again, that can sometimes be fact intensive, but here the plaintiffs bear the burden to plead a tolling and to bring in evidence of a tolling. They do neither one. They do not argue in any of their responsive papers or their live pleadings that any of their causes of action here were deferred or tolled. So this, again, just emphasizes that this is a very clean case that, consistent with the Exxon Texas Supreme Court case, must be resolved as a matter of law. So I mentioned there's two elements. The easy element is when did they actually come to the court with their petition? This is a file stamped copy of the original petition that the plaintiff started the case with. And you can see at the file date at the top right-hand corner that they first filed on July 24th, 2018. So in terms of when they came to court, we know what that is. That's July 24th, 2018. So what we're going to get into after this is the actual evidence to say for the 4-year period prior to July 24th of 2018, had some facts come into existence that authorized the plaintiffs to come for their judicial remedy earlier. There's a little bit of a nuance. I don't want to bog down on it, but I do think it's important to point out at the next slide. This is the plaintiff's response to our motion for summary judgment. In their footnote 5, they concede that 4 of the plaintiffs came even later. And so just for ease and reference, I'm going to treat the argument as though everybody filed at the same time on July 24th of 2018. In fact, 4 of the plaintiffs came later than that. And in fact, one of the defendants, my client, Stephen Bressler, in his capacity as trustee, came significantly later than that too. So those are certainly nuances, but in terms of the across the board matter of law relief that the defendants here have shown themselves entitled to, I don't want that nuance to confuse things. And Your Honor, I should point out, if at any point today the court has a question, it inquires about a case that says something, inquires about a piece of evidence, I welcome any kind of interruptions because, again, I think this thing is incredibly clean, incredibly ripe, and the grounds here could not be more clear.
No, I'll ask if I have them.
Thank you, Your Honor. There's 3 different statute of limitations matters that we've moved on here. These are excerpts out of our motion for summary judgment. A is that the plaintiff's breach of contract claim against us is barred by limitations. B is that the plaintiff's money hadn't received claim is barred by limitations. And C, we moved on the basis that the plaintiff's declaratory judgment action is barred by limitations. And so those are the 3 different causes of action that these plaintiffs have asserted and that we moved on, saying that they're untimely as a matter of law, and that the facts underlying them had come into existence more than 4 years before they filed this lawsuit. The breach of contract claim, in meeting that one, as to all of the defendants now, except for EOG, what the plaintiffs have said in their response, which I've excerpted here, is that they no longer sue these defendants for breach of contract. And so, and this is a direct quote, that plaintiffs, quote, do not have a breach of contract against DDR Gaddy or any of the other non-operated defendants. So with that response, we're satisfied that our motion for summary judgment on limitations grounds as to breach of contract at this point is mooted. And so at least for the non-EOG defendants, in light of this judicial admission and concession, we don't need any action out of the court as to that one. So that really just leaves us 2 causes of action to talk about: declaratory judgment and money hadn't received. This comes straight out of the plaintiff's live and final petition. This is the declaratory judgment action that they have brought to court. This is the entirety of it. This is everything. And what the plaintiffs told the court is that, pursuant to Texas Civil Practice and Remedies Code, section 37.001, plaintiffs seek a declaratory judgment that plaintiffs are the owners of their proportional shares of the term royalties granted in the Frells Tract, as described above, and that their interests in those term royalties have been held by production and remain in effect. Plaintiffs further seek a declaration that they are entitled to recover their proportionate shares of royalties in all units that contain a portion of the Frells Tract. Just for clarity and ease of argument here, I've divided these into just request 1 and request 2. So the first sentence is what I call request 1, and the second sentence is what I call request 2. So request 1 is what I want to emphasize and go through in detail first and marshal out the evidence. That is, they're asking this court to declare them the owners of the term royalties granted in the Frells Tract, and that they've been perpetuated and remain in effect. These interests come out of 3 deeds that were executed between the years 1960 and 1962. Those deeds recite that the term royalties that are conveyed in them continue as long as there's production in commercial quantities in effect for a term of years, and as long thereafter as there's production in paying quantities. Under the Texas, the chapter on the Declaratory Judgment Act, 37.004 is the substantive statute. And so what these plaintiffs have come to the court with is they've said, we're asking this court for a statutory remedy. We have a statutory action against all of these defendants. And under subsection A, They all claim to be persons interested under a deed or will or written contracts or other writings whose status or other legal relations are affected. So what they've come to and that we've moved on is their ask for a statutory remedy under 37.004. So under a declaratory judgment action, when have facts come into existence that authorize these plaintiffs to request a judicial remedy? There's many cases that say this, but we just chose this one. There's a nice clean quotation that discusses it. Declaratory judgment actions are intended to determine the rights of parties when a controversy has arisen before any wrong has actually been committed and are preventative in nature. Historically, challenges to improper governmental action have sought declaratory relief. A person seeking a declaratory judgment need not have incurred actual injury. And so our evidence here will actually establish that these plaintiffs incurred their alleged injuries years before they filed any lawsuit. But in terms of measuring when a declaratory judgment action accrues, it's not even when an injury occurs, such as might be the case with a breach of contract action. The actions are often preventative in nature, and it's just when a controversy has arisen. This slide, basically, I just want to talk a little bit because there's going to be different concepts that comes out of the evidence to help kind of frame factually what we're talking about here. And if the court can see the yellow box that actually closes off to the right that's labeled Frel's Tract.
Yes.
What's inside the yellow box that closes is 488 acres. And that's what has been referred to as the Frel's Tract. It's about 488 acres on the nose. If you look to the west side of this plat, you see a yellow line that extends off of the closing box. And that's what we've called the road tract. In total, if you measure the acreage that's in that yellow road tract, it's about 4.15 acres. And then there's a particular piece of the road tract that is especially important here. And that is inside the red lines. And that piece of the road tract is about 1.84 acres, 1.85 acres, give or take. The red outline is what's called the Schnitz-Rydell unit. And so there's a number of different motions for summary judgment that discuss all sorts of reasons why, just as a factual matter, as a matter of law, the plaintiffs cannot establish that the term royalty interests that they claim from those interests in 1960 through 1962 remain perpetuated today. I'm not going to get into those today. I think it's beyond. The only reason I set this up is because when they ask this court to declare that they're the owners of those interests, the question the court has to answer when it meets its obligation to determine this as a matter of law, the accrual as a matter of law, is when did the facts come about to put them on notice that they needed to do this? And before we leave this, there's two wells that are in issue that we visit about. In the yellow box that closes, up at the very top left-hand corner, you'll see a solid black dot with an 11,617. That's the Frel's well. And with respect to the collective defendant group, we don't disagree at all that that well produced up until the year 1997. Just call it February of 1997. So through the year February of 1997, there was production on the Frel's Tract. The court can see that well is in the outline. The other well that we'll be talking about is the Schnitz-Rydell unit well. And if you look inside the red boundaries, there's a black dot. If the court can see that black dot, that's the Schnitz-Rydell well. And so to just briefly summarize, after February of 1997, when the Frel's well, the well that's on the Frel's Tract, stops producing, what the plaintiff's whole case here is about is that from March 1997 to the present, or at least until 2014 when other production was established, that one single sole only well in the world is the well that they point to as the producing well to perpetuate the Frels tract that we see outlined, the 488 acres off to the east. The problem they have is that it's not on the Frels tract. And so they try to rely on concepts like pooling to attribute that production to the Frels tract. And so that just kind of factually is what is going on in the case. And now I want to talk about when the plaintiffs had causes of action that had occurred.
And let me ask you, Mr. Weimer, this can't be the first time it's ever come up, whether you're entitled to your share of royalty if the land is pooled and the well isn't physically drilled on the land that you actually have the royalty interest in.
Yes, and this actually gets into, it's relevant today to talk about when cause of action accrued, but let me just talk about that to meet your question. Here are the matter of law problems that are addressed in the other motions for summary judgment with the plaintiff's arguments. And I don't want the court to be confused. They don't have to win one or some. They have to win every single one of these matter of law points. And as a pure, uncontradicted question of fact, they lose on all of them. The first one is that road, the 1.85 acre road that's inside the red outlines, the source deed calls that a road for easement purposes. They have filed a motion for summary judgment trying to tell you that even though it says for easement purposes, that what it really is a fee simple conveyance. So first they have to convince you that that deed is wrong, that it's not an easement, that it's really fee, so that they could rely on that being in there. Then they tell you that as to two of the three deeds, which don't even describe the road tract that they claim through, that the court should just read into two of the three deeds and decide that it includes the road tract, even though that's an easement. Then they tell you that even if they did have a fee road instead of an easement, and even if their deeds did describe the road and two of the three don't, that the instruments which do not provide for perpetuation by pooling, that you should read into the instruments that they can be perpetuated by pooling. The Frels mineral lessors, through whom the defendants have title, they did execute a deed in 1962 that said that the term royalty conveyance could be perpetuated by pooling, that is by production off of the Frels tract but pooled with it. The problem for them is that none of their three deeds was that deed. Their deeds, unlike the one executed in 1962 contemporaneously, don't say anything, not one word about being perpetuated by pooling as opposed to requiring production from the tract itself. Even if they get past all of those problems, the court is aware that pooling is a creature of contract and that pooling has to be strictly performed. The next problem they have is a pure matter of law that they lose on, is that the pooled unit for the red outline tract describes specifically that the pooling was only for the Edwards Lime Formation. After 1992, the court will hear that Carbon illegally completed into a different interval, lied to the Railroad Commission, and then went forward and filed dozens and dozens of false reports, which are punishable as felonies in the state of Texas, and not only did not truthfully tell the Railroad Commission that they had completed into a brand new and different field that wasn't in the Edwards Lime, but even worse, they continued to report the production as being out of the Edwards Lime. And so every single month when they filed their production report, that alone is a felony under the Texas Penal Code and under the commission guidelines. But that's the next just pure matter of law problem that these plaintiffs have, is that even if you wanted to say there's a unit there, the production after the year 1992 was never from the formation for which there was actually a unit, and nobody in the world could have known it because Carbon lied to the world, lied to the Railroad Commission, committed felonies, and reported it falsely. Even if you get past that problem, in the year 1997, a lawsuit has come about. The Frels mineral executive, the owner of the mineral rights in the yellow block and under that road, files a lawsuit against Carbon and says, this Frels well up in the top left-hand corner has not been producing profitably, and there's no production paying quantities. You're holding this on rank speculation. I want my entire oil and gas lease back. And they filed a lawsuit to that, and that's in our evidence that we'll go through today briefly. But in response to the lawsuit, it was settled. There was a settlement agreement. And what Carbon did was release the entirety of both the 488 Frels tract and the 4.15 acre road tract. And we'll show the court the release of everything. And so even if you get past all the other obstacles, as of the year 1997, these plaintiffs have a fatal bar to their claim because there's nothing to pool with. The pool designation unit associated with the Schnitz-Rydell unit well initially described pooling only as to the Edwards formation and pooling only of the leases. And as of 97, because the mineral executive Frels insisted on it, all of that was released. That obviously is also a very clear matter of law point that is fatal to all these plaintiffs' claim, and that's teed up as a matter of summary judgment as well. Even if they got past all of that, as a matter of law, and this is in the evidence that I'll show the court in a moment, that 1.85 acre road tract, a brand new oil and gas lease was executed on that in the year 2010. And it was not, they never ratified that 2010 oil and gas lease. There was a new designation of unit that was created associated with the brand new oil and gas lease in 2010. They didn't ratify that unit. And there's piles of cases that talk about MPRIs, Rittischlacher being one of them out of the Texas Supreme Court, that are very clear that MPRIs are the masters of their own dilution. And so for them to participate in the 2010 oil and gas lease on the 1.85 acres and to participate in the new 2010 unit that's filed associated with that, as MPRI owners who don't own under the tract with the well list, they would have had to have ratified. And the law says they have to do it promptly. And so you can ratify by, they could have filed a lawsuit in 2010, or they could have ratified by sending in a ratification instrument, just like the old 1964 designation of unit associated with the Schnitz-Rydell well. The evidence is going to show, and it can't be argued, back then they did ratify that unit. They filed instruments of ratification. But as to the brand new lease in 2010, there was no ratification whatsoever by them. And so their claims fail as a pure matter of law on that basis too. But let's just assume they overcome all of those matter of law, crystal clear bars to any recovery. They still have to prove that the Schnitz-Rydell well was producing and paying quantities. And there's challenges to experts on this, and the court will see at the appropriate time when we get into the Robinson motions, if we ever get that far, that the idea that that well was producing and paying quantities is just absurd. The well was upside down. It's uncontroverted so, and the only analysis that they offer from any expert was on a different type of well, and he swore that he never even considered costs whatsoever. And so obviously, as the court knows, in any production paying quantities analysis, you look at revenue against the recurring costs. And the expert they bring on the PPQ issue never even analyzed costs and was very surprised to learn at his deposition that the well had a horsehead pump jack, that it needed electricity, that it had saltwater disposal, that it had taxes. And I mean, I can go down the list, it's the length of your arm, but again, this is exactly why the Rule 166A procedure exists, is to eliminate meritless claims for which there is no disputed fact issue to burden and waste the time of a jury, especially in this age of COVID, so that these types of matters can be handled inexpensively and in an economic way that avoids a waste of party and judicial resources. You can see all the counsel that's on this hearing and have been involved in this thing. The longer this case sits around, while as it is barred by both statute of limitations as we visit today and the other matters, the more expense and waste on court resources this thing creates. Mr. Ellis, may I have the next slide? This is a judicial admission out of the plaintiff's petition. This is their live petition. This is at their page 14. The Frels well, the only production that they ever had on the actual Frel's tract. Here they tell the court that as of February 1997, that ended. And so from February 1997 forward, all we're talking about is the Schnitz-Rydell well in that pooled unit. I told the court earlier that the reason that the pooling stopped and that the lease went away was because there was a lawsuit. The mineral executive said, I want all of my minerals back. You have not been a good steward of the leasehold interest in this carbon. Give it back. Exhibit M is the unchallenged compromise and settlement agreement where Carbon agreed, we've been a bad steward of your leasehold. You get it all back. And that's signed as of March 27th of 1997. This next one meets your question, Judge, about, this can't be the first pooled unit case. Here is the release of oil and gas lease. This is our Exhibit H to our motion that Carbon followed up with and placed a public record. You can see the recording information on the right-hand side. And that really gets to the accrual date of these plaintiffs' cause of action. As of March 27th, 1997, it was placed a public record that the Carbon oil and gas lease as to the 488 acres and as to the 4.15 acre road tract had been completely and utterly released. All depths, all well, everything was gone at that point in time. There was nothing for these plaintiffs to be participating in as a matter of pooled production or otherwise. This is the deposition from the Carbon president, Bob Brandt. He was asked, now at exhibit number 15 is a copy of the release of lease that was executed in conjunction with the compromise and settlement agreement to the Gaddy lawsuit. Is that right? Yes. And the Gaddy lawsuit is discussed in the compromise settlement agreement that is exhibit number 14. Yes. Ever since you executed this release for Carbon, has it been Carbon's position that the term mineral and royalty interests that are the subject of this case here all terminated? Yes. No objections, no fuss. It was the operator Carbon's position that as of March 1997, these plaintiffs' interests had terminated. And so as a matter of law, as of March of 1997, these plaintiffs' claims accrued, and they could have come to this court asking in 1997 for a declaration of their rights and legal status under Chapter 37 of the Texas Civil Practice and Remedies Code. They did not. I expect in opposing counsel's response to this, he'll say, well, we didn't know, or we were lulled into inaction, or there's a reason that we didn't sue back in 1997. The only place, accrual is a question of law. The only place the I don't know or I was lulled into inaction comes into play is if they had pledged some kind of a tolling of the statute of limitations, such as fraudulent concealment or discovery rule, or some kind of tolling as opposed to deferral. And there's a whole laundry list. But again, here, they've never pled anything like that. That cause of action accrued as a matter of law in March of 1997, when that release was placed of public record. I have the next slide, please, Mr. Ellis.
And would that have been a cause of action? I mean, when would the term mineral interest have expired if there had been no production?
March of 1997, Your Honor. At the actual,
I mean, if there had never been any production.
Oh, that would have been back in the 70s, Your Honor. You're testing my math. I think it would have been.
Okay, but a long time before.
Yes, Your Honor.
Okay.
But again, the reason that March of 1997 is so important is that there was a well producing on the Frel's tract, and that well goes offline as of February of 1997. And so for decades, there was production from the Frel's tract, but as of February of 1997, that ends. And we've shown you where the plaintiffs in their petition conceded ended in February of 97. And so they're only relying, from that point forward, this is from page 14 of their petition. At that point forward, the only well in the world that they have to rely on or talk about is the Cnty-Dist well. The problem for them is that as of 1997, and there's all sorts of other problems that we've talked about, but as of 1997, that lease that covered the 1.85 acre road tract that was in that unit was completely released. And furthermore, the other problem is that with respect to the unit, even if you ignored the release, The unitized production was only for the Edwards Lime Formation. And Carbon swore to this. At Bob Brandt's deposition, he swore that they falsely reported to the Railroad Commission that there was production out of that well from the Edwards Lime. And he swore that that was not true, that what they should have done was report to the commission they had completed into a brand new interval, into a wildcat, which could, there's argument over Austin Chalk or Eagle Ford. But what's not in contest is that nobody could have looked at the public records from the Railroad Commission of Texas and told that there was no pooled production out of the Edwards lime at that point in time. If I get back to my slide 19, and when I tell the court that the plaintiff's cause of action accrued in March of 1997, you don't have to take my word for that. The plaintiffs have conceded that for you. This is a judicial admission out of their second motion for partial summary judgment. They moved for summary judgment on the basis that the plaintiffs, this is a quote from their motion for summary judgment, plaintiffs' term royalties were not extinguished by the 1997 release of the oil and gas lease covering the Frells tract. They asked for that declaratory relief today, but it's tardy. They could have asked for that exact declaratory relief as of March of 1997. And as they will tell you, they were placed on constructive notice that the Frells lease and the 1.85 acre lease had been released as a matter of law as of March of 1997. They have all sorts of papers filed saying, as a matter of law, once that thing hits the public records, they are put on notice of it. It gets even easier for Your Honor, Judge Wilson. This is Exhibit K, an unchallenged exhibit that we've put into evidence. And Fred Shields and Company over on the recipient line, that's one of the plaintiffs that is suing all of these 14 plus defendants. The date of this correspondence is October 6, 2011. And here the operator Carbon is telling the plaintiff why their interest has expired. It says on October 23rd, 1956, Frells entered into an oil and gas lease with Shell. That's true, we've seen that. At the time of the lease, Frells had entered into a number of term royalty deeds effectively conveying all of their mineral interests for a term of between 15 and 20 years, and so long thereafter as there was production from the lands. That's true as well, we've shown the court that. At the end of the term, as may be extended by production, the royalty reverted to Vlasta Frells. On January 1st, 1964, 1.85 acres covered by the lease, this is that road track inside the unit that we've talked about, was pooled into the 80-acre Schnitz-Rydell unit. On March 27, 1997, Carbon Oil Company released the Frells lease, effectively ending all production attributable to the lands covered by the Frells lease. We've shown the court both the settlement agreement that caused it and the publicly recorded release that's referred to there. The end result is that on March 27, 1997, the term royalty deeds expired and all minerals reverted to Vlasta Frells. Through an oversight, Carbon Oil Company erroneously continued to pay royalties to those owners of the term royalty in the same manner as if the Frells lease was still in force and effect and pooled in the Schnitz-Rydell unit. On August 17, 2010, Carbon Oil Company acquired a new lease from the heirs of C.W. Frells and Vlasta Frells, covering the 1.85 acres within the boundaries of the Schnitz-Rydell unit. That's true. We've shown the court that as well. The lease has since been pooled into the Schnitz-Rydell unit and all royalties attributable to the pooled acreage credited to Doreen Frells. That's actually also true. And so as of October of 2011, it wasn't just public records. What we've brought you here is direct evidence that the plaintiffs knew of their controversy, that a controversy existed. And again, I expect that opposing counsel is going to go, well, this was only one of my plaintiff clients. The rest of my plaintiff clients may not have necessarily known about this. But again, they haven't pled discovery rule or fraudulent concealment or tolling. And so the idea of what we should have known or could have known isn't relevant here. It's just whether the controversy exists, period. But here, again, we have a writing that confirms that as of August 17, 2010, it was Carbon's clear position that everything had terminated. And we've already shown the court the sworn testimony without objection out of Carbon's president, where he said it was their position as of 1997 had terminated. but it gets easier for your honor. This is Exhibit S that's come in without objection. And this is a letter that's sent on behalf of over half of the plaintiffs to Karn in June of 16 complaining. And the block there is the list of all of the plaintiffs that are in this case. I counted it earlier. I think it's like 14 or 15 of these plaintiffs. And what they say is that in the late 1990s and up until approximately 2004, the Dohertys were receiving royalties from Karn Oil Company from this interest. The records contained in this office indicate there was a Schnitz-Riedel unit for which royalties were paid. According to the Railroad Commission records, the Schnitz-Riedel unit continued to produce through 2014. It does not appear the Dohertys have been paid royalties for the respective interests in many years. Please let us know why the royalties have not been paid. If you believe the interest may have terminated, please provide documentation as to the rationale for that decision. If you have any questions, please call. What comes out of the plaintiff's own hand here is the admission that, consistent with the president's testimony, that all of the pooled production had ended as of 1997 and that the plaintiff's interests had all ended as of 1997. And that for a time after that, there were payments mistakenly made. Out of these plaintiffs, what they're saying is that since 2004, we haven't been paid anything. And so as the court takes up the question of when did the cause of action accrue, when did the controversy arise, where they could have come and said, we want a declaratory judgment that our interests exist, obviously that would have, at the absolute latest, come about when their royalty payments were cut off because their interests terminated. You don't have to take our word for it. You can take the plaintiff's word for it. May I have the next slide, please, Mr. Ellis? Well, actually, before I get to that, as we talk about constructive notice, this is the 2010 oil and gas lease that is referenced in Karn's letter earlier. You can see the recording information. This was placed in the official public records of Karnes County, Texas. It's dated August 17, 2010. This was the brand new lease on the 1.85 acres that these plaintiffs have never ratified. To participate on a pooled unit basis, it's obviously the law in the state of Texas that an MPRI would have to undertake an affirmative act to ratify. To this day, in the year 2021, these plaintiffs have never purported to ratify the 2010 lease where they could have participated on any kind of pooled unit basis. But this is the brand new lease because the other lease and the other participation of the lease in the unit had gone away. Again, we asked Karn's president about this, and he establishes the controversy arising decades ago. This is a sworn testimony, all, again, with no objection whatsoever out of opposing counsel. Is Dream Frells the lessor of the new lease in 2010 that Karn took covering 4 acres in the roadway? Yes. And I'll just note, again, this is public record. This is nothing in the dark. It's in the official public records of Karnes County. And from the time that lease was taken and including the pool for the unit that was formed in 2010, did you pay Ms. Frells a unitized share of production from that well? I believe so. And it talks about through an oversight, Karn erroneously continued to pay royalties to the people that were pooled in the Schnitz-Riedel unit. Is that what it says? Yes. So after that was discovered at some point, you stopped paying that, stopped doing that. Isn't that correct? I believe that's correct. So once the mistake that Karn was making in paying royalty to owners of the 1.85 acres that had been originally pooled in the shell unit, that stopped. Yes. Once you found out that it was being done, I believe that's correct. And so what Karn's president says is when they discovered the error of the continued payments in 2010, they got a brand new lease on the 1.85 acres from the mineral owners, and that they stopped paying these plaintiffs whose interests had terminated as of 1997. Certainly by August of 2010, when these plaintiffs are cut off of royalty payments and when a new oil and gas lease over the road tract has been placed in public record, they had a cause of action that had accrued, and they could have come and asked this court for this exact declaratory relief that they only come to the court on for the first time in the year 2018. I said earlier, you don't have to take my word for it, take the plaintiff's word for it. This is also judicial admission out of their second motion for partial summary judgment. This is footnote 4 out of the plaintiff's pen. Karn apparently stopped paying the term royalty interest around 2011 based on the mistaken belief that the 1997 release had extinguished the term royalties. At the time, Karn was unaware of the Texas Supreme Court's decision in Wagner versus Brown and Shepard, 282. See discussion info. What these plaintiffs tell the court in footnote 4 is that by 2011, they had all been cut off of all royalty payments. They have not received a nickel of royalty since the year 2011. Actually, it's earlier in time than that. But if you take their judicial admission here from footnote 4, they've not received a nickel of royalty since 2011. And they say that it was because Karn was mistaken. As a legal matter and factual matter, they're dead wrong on that. But in any event, as of 2011, facts had come into existence, giving rise to controversy that would have authorized them to come to this court within 4 years of 2011 and ask for the exact relief they only get around to asking for in 2018. Have the next slide. They didn't even file within 4 years of the new production coming about. This is out of the plaintiff's Fifth Amendment petition, another judicial admission, that as to the new production by EOG, this came about from the Lynch unit in March of 2014, and that they haven't been paid on the new production either. If you take March of 2014, you add 4 years to that, you are still months away from when some of the plaintiffs filed a suit against some of the defendants in July of 2018. So let's get to the specific ask they make of this court. At paragraph 91 of their Fifth Amendment petition, declaratory judgment, they say the plaintiffs seek a declaratory judgment. The plaintiffs are the owners of their proportional shares of the term royalties granted in the Frells tract, as described above, and that their interests in those term royalties have been held production and remain in effect. They could have sued on this exact request to this court under Chapter 37 in March of 1997. They could have sued on this exact request in August of 2010 when a brand new oil and gas lease is taken on the 1.85 acres. They could have sued on this exact request in 2011 when Karn cut them off of all payments for the reason that their interests had terminated. They could have sued within 4 years of 2011 when Karn is even writing, explaining that the interests have terminated, but they didn't. They sat on their heels. And just as the Texas Supreme Court says in Cosgrove versus Cade, if you snooze, you lose. Add the next slide, please, Mr. Ellison. All right, so what statute of limitations is the legal statutory mechanism that says, sorry guys, you're too late? It's 16.051 of the Texas Civil Practice and Remedies Code, and it's the residual limitations period. What the residual limitations period says that for every action for which there is no express limitations period, except an action for the recovery of real property, must be brought not later than 4 years after the day the cause of action accrues. With respect to that limited exception for actions to recover real property, I'm going to show the court what the Texas Supreme Court says that means, and that applies in no way, shape, or form here as a matter of law under Texas Supreme Court clear precedent. But I would note on that point that the plaintiffs don't even argue that that exception has any application here. And so just in terms of giving the court comfort that the decision here being rid of this untimely claim is 100% sound, I'm going to show the court, how the exception, when it can come into play in other situations that aren't this one. But under the residual period, I just want to emphasize that every action for which there is no express limitations period has 4 years. So if you go to 16.03, those are going to be your tort actions that have a 2 year.
Right.
If you go to 16.04, those are going to be your contract actions that have 4 years. And here under declaratory judgment, in the way that they've pled this thing, it's the residual catch-all that applies to it. In the state of Texas, it's not that some causes of action have a limitations period. It's not that a lot of them have a limitations period. It's that every single one of them has a limitations period. Let's go to the next slide, please, Mr. Ellis. Here is where the plaintiffs, again, making this very easy for the court, the plaintiffs judicially admit themselves into 16.051. This is directly out of the response to our 8th motion for summary judgment. I've highlighted the section I think disposes of this. It says Texas statutes include no limitations period for declaratory judgment actions. That's exactly our point, is that we can't look at 16.03. We don't look at 16.04. Because there's no other statutory limitations period for DEC actions, that statutory remedy is covered by the catch-all in 16.051 as a matter of law. May I have the next slide, please? According to these plaintiffs, 16.051 has to be ignored for some inexplicable reason here. And they could come and ask the court for this exact declaratory judgment relief 100 years in the future, and it would be timely. That does not accomplish the bright lines and sharp corners that Cosgrove versus Cade says out of our Texas Supreme Court that we have to have. If you push opposing counsel on this point and you ask them, could you bring this declaratory judgment 100 years from now, or is it barred by limitations? He will tell you, yeah, I can bring this exact case in 100 years from now. There's no statute of limitations that applies to this case. And that is not the law in Texas. So what have we done by way of our evidentiary burden of showing the court as a matter of law, when did facts come into existence? Well, we've shown the court that it accrued in March of 1997. No question these plaintiffs could have come in 1997 with their lawsuit. We've shown it was 2011 at the latest. And again, they've pled no discovery deferral or fraudulent concealment deferral or tolling. They do nothing to controvert that they could have sued in March of 1997. Their response does nothing to controvert that they could have sued in 2010 or 2011. They could have asked for this same relief in 2011 at the latest, as they concede in their footnote 4 when they say they were cut off of royalty payments based on Carbon's understanding of the effect of the release of the 97 lease. Have the next slide, please. This is a case that comes out of our San Antonio Court of Appeals. It's binding authority on this court sitting in Karns. And the plaintiffs completely misunderstand the case. And I think if you read their short response, that their fundamental lack of understanding as to how the declaratory judgment statute works and the residual catch-all of 16.051 works is exposed here. What the court in Denman was doing was a litigant brought the court a will and said, I want this will interpreted as a matter of law, and I want my rights declared under it, and I want the court to declare that under the will, I win and I get X. And so what the San Antonio Court of Appeals did in this 2011 case, it said, well, there's been an untimely objection here. There's been a defense of untimely. When did this cause of action for declaratory judgment to construe the will accrue? And the court says, in the absence of a statutory limitations period for the specific claim asserted, the residual 4-year limitations period in section 16.051 applies. And in the sentence above the second highlighted piece, it said, thus sought to construe Denman's will. There is no statutory limitations period in the Texas probate code for bringing a will construction action. So the court said, is there anything that says by what time frame this will interpretation needs to be brought? Probate code doesn't say anything. We're required in this DEC action to apply 16.051. They knew of the controversy more than 4 years coming asking for DEC action. They're late. This case is no different. The court here can go look at the Texas property code. The court's not going to find a statute of limitations in the Texas property code that applies to the ask that the plaintiffs have made under the Declaratory Judgment Acts here. And so just as the San Antonio Court of Appeals went and looked in the probate code, this court can go look elsewhere, and it's not going to find anything. And you don't have to take my word for that. You can take the plaintiff's word for that, because at the earlier slide in the response to our motion, I showed you where they said out of their hand, this is out of their pen, quote, Texas statutes include no limitations period for declaratory judgment actions. So there's no place for the court to go look here and on the case that they've pled. Okay, again, the plaintiffs don't argue about this except in action for recovery of real property. It's nowhere in their response that they say that applies here or would save them from 16.051. But unless the court has any concern or question on that, I just want to explain what that is. It's not controversial. It's not hard. It's the trespass tri-title statute. This is a Texas Court of Commissions of Appeals Court. The Texas Supreme Court did adopt this. And so this is binding precedent in the state of Texas, just as if the Texas Supreme Court had issued it itself. And what the Texas Supreme Court adopts in Karl versus Sedegast is that it is now well settled upon authority in this state that the test whether an action be won to recover real estate within the express exception of this article is whether the titles asserted by plaintiff, whether legal or equitable, will support an action and trespass to try title. And so that exception is for the Texas trespass to try title statute that's contained at Texas Property Code, section 22.001. I realize I didn't put the entire pleading out of the plaintiffs here, but they did not sue for trespass to try title. There's no trespass to try title. There's no chapter 22 of the Texas Property Code pled. They haven't given an abstract of title. There is no abstract of title in this case now that discovery is closed. Trespass to try title's not in play here. Here's another Texas Supreme Court case from 1959, Miles versus Martin, that accords with the one I just showed you earlier. Whether a suit is won for the recovery of real estate within the exception of that article does not depend upon the form of the pleadings, but upon the nature of the title asserted by the plaintiff. The title which he asserts will not, therefore, support an action of trespass to try title, and the suit is not won for the recovery of real estate. And there, in our reply papers, I provide a long string side of cases that say this exact same thing. Again, this is not controversial. The plaintiffs didn't argue this in the response, but it's in the 16.051. I wanted to make sure the court had no concern there and that the question was answered. Here is the Texas trespass to try title statute. It tracks that exact language out of the exception in 16.051 that says it is that statutory mechanism at chapter 22, section 22 is the method for determining title to other real property being the specific carve out in 16.051. Have the next slide, please. Why is there that exception in 16.051 for trespass to try title? Has our Texas Supreme Court just decided that title is some special species that can just be litigated in trespass to try title 100 years down the line and it's timely? No, there's an entire statutory scheme that specifically meets the trespass to try title statute, which is title by adverse possession. And so you can look, for example, 16.024 is the 3-year limitations period. 025 is the 5-year limitations period. 026 is the, I believe that's the 7-year, and 027 is the 25-year. And so with respect to that exception under 16.051, here's how that would work if this were a trespass to try title case. A plaintiff would have come and sued in trespass to try title under section 22 of the property code. They would have been required to meet the strict pleading and proof requirements that go with the trespass to try title action, which includes very particularized pleading and which includes an abstract of title and being able to show through that abstract of title superior title. In response to that, we could have come back and answered under 16.024, 025, 026, 027 under a title by adverse possession, again being the carve out in 16.051. But again, that's not this case. That's not what the plaintiffs have pled. And Martin versus Ammerman, that's a case we've had hearings in this court where that case has been applied in the past. And it talks about what a unique species of statute and what an onerous statute trespass to try title is. That it comes from 1840. And it talks about there is strict pleading and proof requirements applicable to trespass to try title that do produce harsh results. And here, and here's a case, citing another one, holding that Hunt's failure to timely file his abstract showing chain of title was fatal to the trespass to try title action he pled, whether or not the case turned faction on the question of boundary. The plaintiffs have never pled trespass to try title. They've never tried to meet that onerous burden, and they can't. Okay, so with respect to the first, what I call first request from plaintiffs under declaratory judgment, they say we want to go back and have events all the way back to 1945 interpreted and construed. We want a declaration as of what happened in 1997. We want a declaration that in 2010, when the new oil and gas lease comes about, that we're not, our interests haven't terminated. Those all accrued more than 4 years before they filed a lawsuit. This is what I call second request. Just for the sake of completeness, they ask, quote, plaintiffs further seek a declaration that they are entitled to recover their proportionate shares of royalties in all units that contain a portion of the Frells tract. I think a fair reading of this pleading is that that's no different than first request. In these responsive papers, they in the response to our motion for summary judgment, the plaintiffs say, well, this is a little different. Second request is actually you saying that we're owed these royalty damages. Well, the court under declaratory judgment can't, even if you could construe that in that fashion, Chapter 37 doesn't allow this court to be judge, jury, and executioner and award damages against the defendants. Damages have to come about through some other common law remedy or some other statute. But declaratory judgment doesn't let the court just go in and hand out damages to these plaintiffs. This is just one example. Again, there's piles of these cases that accord with this. But it says Safety did not bring any claims under the TTCA, but rather is asserting claims under the Uniform Declaratory Judgment Act. Safety's petition requests, among other things, damages. The UDGA, however, does not permit an award of damages. Therefore, Safety must seek damages under a different authority. So if the plaintiffs tell you today in their argument that request 2 is some species of we're entitled to damages, that doesn't work. What they're asking for is we're entitled to title, and then that may daisy chain into a later claim of damages. But the point here is that they can never get the first daisy chain event because they're late by decades in coming to the court with the ask. Have the next slide, please, Mr. Ellis. I just don't want the court to have any confusion on this. In the responsive paper, it's a very short response that the plaintiffs filed, 11 or 12 pages. They say, in spite of the fact that DDR Gaddy and the other non-operator defendants have themselves counterclaimed for declaratory relief, DDR Gaddy asserts that the plaintiffs may not bring such an action. That's just wrong. I don't know why they told the court that. What I'm showing the court right now is DDR Gaddy and Stephen Bressler's second amended petition. We didn't make any declaratory judgment request. What we did do is in response to their declaratory judgment request, ask for attorney's fees under the statute because they're dead wrong and they know they're wrong and they're late. I didn't counterclaim for any declaratory judgment despite them telling the court that we did. And this betrays their lack of understanding as to when a cause of action accrues. My claim for attorney's fees under Chapter 37 did not accrue until facts came into existence authorizing me to ask for those attorney's fees. My claim for attorney's fees accrued and the facts came into existence authorizing me to sue them for attorney's fees upon them throwing the declaratory judgment rock at my clients in a formal pleading. And so, again, this just illustrates how a claim for attorney's fees accrues and that it accrued in response to their DEC action. Their DEC action accrued in 1997 when facts came into existence authorizing them to come to the court asking for relief. I have the next slide. So that is why the declaratory judgment action is barred. And if you want to talk about has there been prejudice to the defendant group by this tardy, is it just a matter of lost evidence or lost witnesses? Bob Brandt, the president of Carbon, he testified to some kind of a dementia problem. He's lost memory. People have died and they're in the hospital. If you look at their motion for summary judgment, they tell the court that key documents have been lost based on this delay, and that with respect to production records and expense records and that kind of thing, that's no longer available to the court. They tell that, I mean, that's out of their pen. That's prejudice by delay. But furthermore, there have been tens of millions of dollars in federal income taxes paid by these defendants. That is all the function of these plaintiffs' delay. There have been millions of dollars sent to the United States Department of Treasury that would not have been sent to the United States Department of Treasury had these plaintiffs gotten off of their laurels and filed a lawsuit in a timely fashion. Had they not snoozed, they wouldn't lose. They also sue for money hadn't received and unjust enrichment. Money hadn't received an equitable action, and everybody in the case concedes that a claim for money hadn't received accrues based on 2 years after the cause of action accrues. And so the question for the court is, when did their claim for money hadn't received accrue? Well, you can take them again out of their own pen and their own judicial admission and concession. They've already admitted in their responsive papers that at a bare minimum, chunks of their claims for money hadn't received are time barred. They say plaintiffs agree that they cannot directly recover from DDR Gaddy and the other non-operating defendants for royalties paid to them more than 2 years before plaintiffs filed suit against them. Well, is there evidence in the record that that those claims accrued outside of 2 years? There sure is, and it comes again out of their own pen. May I have the next slide, please, Mr. Ellis? This is their expert. This is their affidavit at Exhibit 7A. And what their expert swears is that the records show that the defendants received some of those royalties more than 2 years before the July 24th, 2018. And so again, the plaintiffs here concede and judicially admit that their money hadn't received claim accrued more than 2 years before they filed this lawsuit. Their claims are time barred under 16.03 of the Texas Civil Practice and Remedies Code in the cases that have interpreted it as applying to equitable actions. What they want to say is that as to these defendants, though, there wasn't one accrual, but that every single month of production is a new accrual. The problem that the plaintiffs have is that there's not one single published case in the entire state of Texas, in the entire history of the state of Texas and its jurisprudence, that applies the statute of limitations in a money hadn't received context as they tried to do here against the non-operator defendants. And I would ask Mr. Kilday, when he has his opportunity to present his argument, what case applies statute of limitations in an accruing, continuing fashion as you try to do here against the non-operator defendants? May I have the next slide, please, Mr. Ellis? And let me just speak to that point real quick. What they cite are cases that involve a statute or a contract. They cite cases that say that if a contract requires periodic payment, then those are separate limitations period. They concede here that they have no contract with the non-operator defendants, and they cite to no contract with defendant EOG. And so with respect to, I want the court to look carefully at the cases that they bring you to see if they bring you a single one that involved an equitable claim for money hadn't received that was not premised on a contract between the parties with periodic payments. They have none. We've read every single case they cited. There's none in any of the 11 pages of argument that they have in the cases cited, none whatsoever. They cite to the 91-402 Texas prompt pay statute and say that that creates a continuing payment obligation. That statute would apply to a payor. There's no argument in this case that any one of the non-operator defendants are payors. And so as they want to say that the money hadn't received claim accrued on a continuing basis, what they point to is a statute that doesn't apply to the non-operator defendants. And they point to cases that discuss contracts between parties, but they must concede, as they pointed out in the very first section of my argument, that there is no contract here between any of the plaintiffs and any of the non-operator defendants. So this brings us to our 166A standard. 166A doesn't say that once we've come and met our obligation of showing factually when the claims accrued and the period of limitations applicable to them, that the court should think about giving a summary judgment, or that maybe it's appropriate. What 166A says is that the judgment sought shall be rendered forthwith if the deposition transcripts, the interrogatory answers, and other discovery responses referenced or set forth in the motion response, and the pleadings, admissions, affidavits, stipulations of the parties, and authenticated or certified public records, if any, on file at the time of the hearing or filed thereafter and before judgment with permission of the court, show that, except as to the amount of damages, there's no genuine issue as to any material fact, and the moving party is entitled to judgment as a matter of law on the issues expressly set out in the motion or in an answer or any other response. The judgment at this point, us having met our evidentiary burden, shall render forthwith. And with respect to the other, the money hadn't received, that sort of thing, again, if declaratory judgment is poured out as a matter of law as untimely, they can never satisfy the threshold predicate of any of their other claims for damages or royalties or everything else. So again, in terms of the daisy chain, that completely eliminates any kind of liability by anybody here, period. The first one is they've got to prove that under their interpretation of things that they're right. And because that's time barred here, they never get past step one as to any of the others either. I think I'm maybe 2 slides away from being done here, and I'm going to shut up. But I just want to reemphasize again the Cosgrove versus Cade in the Supreme Court, where they say the virtues of legal certainty and predictability are nowhere more vital than matters of property ownership, an area of law that requires bright lines and sharp corners. As with latches, the fundamental premise of limitations is simple. If you snooze, you lose. Here, these plaintiffs snoozed by approximately 20 entire years. And since that, people have died, Memories have faded and succumbed to dementia. Documents have been lost by their own admission, and literally tens of millions of dollars have been produced and paid based on the title certainty that existed. And 20 years is too late to come in and ask for a declaratory judgment title reset. And as a matter of law, the court must decide this question in advance of trial categorically as a matter of law. And two, there's no fact issue. You can look through the plaintiff's 11-page response. Nowhere do they say, no, these guys are wrong. Our claims actually accrued at this date in the future. They don't say that. They don't dispute anywhere in the 11 pages of briefing our evidence in terms of when their declaratory judgment claim accrued. They don't dispute anywhere as to when the money hadn't received claim accrued in their late. I was going to finish with the run through here just factually about how the other motions for summary judgment that are out there. Again, Your Honor, I mean, there's like 8 different ways that they have to ask this court, and they've got to win on all 8 of them. Ask this court to just say, forget what factually happened here, forget what the law in the state of Texas is. We're just going to do it the way the plaintiffs want. And if they can convince the court on all 8 of them, they get to go burden a jury on a production and paying quantities analysis where there's only one expert that performed one, being the defendant's expert, and their expert didn't. So we think that the case is ripe at this point in time for a decision as a matter of law that is untimely and is consistent with Rule 166. It's consistent with the evidentiary showing, and it will achieve precisely the economic and efficient disposition of this case that 166 is created for. I do very much appreciate that. That was an hour of listening to myself, and I appreciate Your Honor bearing with me as we went through some pretty dense stuff and getting kind of the first step into, what basically a trip back in time to 1945. But thank you for the court's courtesy.
All right, we're going to take about a 15-minute break before we start again. Let's call that 2:50. We'll see y'all at 2:50, and we will get started with
Thank
the
you, Your Honor.
plaintiff's response.
A call cannot be completed as done. Hello.
Hey, I got a problem. I got to jump back in this hearing, but I want you to try to figure something out for me.
Trust, you're live, Bubba.
Yep. Thank you, sir. Doug Kilday, can you hear me?
I can indeed.
Yeah, I knew you were hiding behind that screen. Hey, I don't want to take the risk of talking over you once you start your argument. I am going to have just a little bit to add on the movement side.
Sure.
You
want to go ahead and go first?
Yeah. I just want to let you know that it would be very brief, but just to kind of situate EOG in the mix here.
Okay, super. Thanks for letting me know.
Okay.
All right, I just think I heard that Mr. Truss is up next.
Yes. Is everybody back?
All right.
Your Honor, if you're ready, I'll get started.
I'm ready.
Okay, I guess I better start my video. I'm super tech savvy here. So I do not have a PowerPoint and I do not have an hour's worth of material for you. I assume that everybody will be pleased to hear that. But I think it's important, since I represent EOG and the issues aren't all overlapping identically, to just situate EOG within this motion. I think you understand the position of EOG in the lawsuit. We are the operator. We do not have a stake in the monies that are being fought over here. It's either properly paid to the defendant group, as it has been for many years, or it's properly paid to the plaintiff's group, and it's never properly paid to EOG. And so we are in the case because there are claims that are not subject to the motion for summary judgment, including the one of the prompt pay statute, that are particularly brought against EOG as operator and would not apply to the co-defendants, although that's a little bit unclear from the original pleading. But now in the response to the summary judgment, the plaintiffs have made clear sort of what they're alleging against each sort of group. And there's the non-operator defendants that Mr. Waymire was speaking on behalf of, and then EOG. Now, EOG did join in the motion on limitations ground, and they did, and properly so. For reasons I don't quite understand, but may be cleared for me, the plaintiffs don't believe that EOG effectively, well, I guess they don't contest that EOG joined the motion. They just don't believe the motion covered EOG, and I think it certainly unquestionably does. The pleadings were ambiguous as to exactly which claim was against, but the declaratory judgment is extremely material to my client and the obligation to pay. And the breach of contract action, now Mr. Kilday has said on behalf of the plaintiffs, is only against EOG and not against the co-defendants. So the money hadn't received claim wouldn't apply to EOG. But as to those other two, the declaratory judgment and the breach of contract action and the Chapter 91 claim, all those are against EOG. Now, the Chapter 91 claim is not subject to the motion for summary judgment. That's the prompt pay statute. I'm sure Your Honor is very familiar with. And that we did not make that subject to the motion for summary judgment because as a threshold issue, the declaratory judgment that Mr. Kilday seeks to establish his right to payment and the validity of his client's interest, he would need to establish that to be a payee under Chapter 91-401. And so while that claim is not in the summary judgment, it will fall like a domino from the effect of this motion for summary judgment. So the declaratory judgment in that way is extremely relevant to my client and the disposition of the declaratory judgment claim. And I don't have any substance to add on that count. The breach of contract is a little confusing. So the plaintiffs have now said that cause of action only applies to EOG and that it's not time barred, notwithstanding that the case was filed more than 4 years after EOG established production. And they rely upon a number of continuing obligation cases. And they cite them. A lot of those cases you will see cited in the context of both a breach of contract action for failure to pay royalty, and also a Chapter 91 prompt pay claim. But all of those cases are based on a contract that actually provides for a continuing obligation of payment. The problem in this case is, what contract? There is no contract. You've been offered no contract that EOG purportedly has these continuing obligations to pay Mr. Kilday's clients. Now, as Mr. Waymire explained in detail, Mr. Kilday's clients' original deeds were subject to a then existing 1956 Frells lease. So if that is, and logic would seem to indicate that that might be the contract that they're trying to wedge into as the source of contractual obligations on behalf of the operator clients. If that's it, that contract was released in 1997. That's been well established. I'm not going to retread that ground. So there are no continuing obligations to pay anyone under that contract. And if it's not that contract, I can't even imagine what it would be. So there's certainly no cause of action for a breach of contract that's timely in this case. Can't even locate the contract, frankly. So and as I said, the declaratory judgment claim, we're riding coattails as well on that with the co-defendants. I don't have any additional substance to add to Mr. Waymire's arguments on that, and so that's all I've got at this point, Your Honor.
Go ahead, Mr. Kilday.
Thank you, Your Honor. I wasn't sure if other defendants wanted to say anything.
Oh, I'm sorry. Nobody else had spoken up. Who else wants to talk? Mr. Hyatt, Grable? You are next.
Okay. Thank you, Your Honor. I also would like to share screen with a brief presentation if it pleases the court. May I do so?
Go ahead. Go ahead.
Okay, thank you, Your Honor. As Mr. Waymire noted, and as we discussed a couple of weeks ago at the continuance hearing, our firm represents 25 plaintiffs who are term royalty interest owners in what's been known as the Frells Tract, what's been called the Frells Tract. And we're pleased to have the opportunity to speak to Your Honor today in response to the 8th motion for summary judgment filed by DDR Gaddy and Bressler, joined in by all other defendants. 25 plaintiffs. I think there's 13 defendants, including EOG, and then 12 non-operator defendants. So we've talked about this some already. This is the Frells Tract. It's called the Frells Tract because it's a tract of land that was conveyed to Mr. C.W. Frells and Ms. Vlasta Frells in 1945. And it's a contiguous 480-acre tract with an additional 4.15-acre road that veers off to the west and intersects a pooled unit that was subsequently formed called the Schnitz-Riedel unit. So that's the tract of land that we're dealing with here today. And the plaintiff's claims originate from 3 separate term royalty deeds that are in the summary judgment record as Plaintiffs Exhibit 1D, 1E, and 1F. Now, those are attached to plaintiff's second motion for summary judgment, but we have incorporated and relied upon that proof in connection with our response to DDR Gaddy's motion for summary judgment, their 8th motion for summary judgment. So I just want to briefly show those to you. They're deeds that were bought and paid for. They were sold directly by Vlasta Frells to a man named Ald, a 1/4 term royalty deed back in 1960. There was a second term royalty deed by Miss Frells to Mr. Mortimer back in 1960, and then a third 1/8 term royalty deed sold to a gentleman named T.C. Huddle. All of the plaintiffs are successors in interest to these 3 term royalty deeds granted by Mrs. Frells after her husband had died, granted to predecessors of the plaintiffs. So our claims originate from these 3 term royalty deeds granted back in the early 1960s. What do those deeds say? Each deed is a conveyance of a percentage of the royalty from the Frells tract. Not just the big block, but also the road, because each term royalty deed references that it's the same property that was conveyed to the Frells in the 1945 conveyance by John Hancock Insurance Company to the Frells. So it includes the road, and each term royalty deed is for a term of 15 years, and not just for 15 years, but and for as long thereafter as there's production in paying or commercial quantities. That's why we're here, Your Honor, because we contend that there has been continuing production from the Frells tract, taking all the way back from the 1970s when that 15-year period ended until and including 2014, which was when EOG began producing on its new leases on the Frells tract. So our rights are not contingent upon the effectiveness of a particular lease. Instead, they are a conveyance of term royalties from the Frells tract for that term of 15 years and for as long thereafter as there's production. So that's the key test in this case is, was there production? And was there production in paying or commercial quantities? If there was production in paying or commercial quantities, then the plaintiff's interests continue to this day. And that's our claim. We claim that there was, and there has been, and there is, and we are seeking to enforce our rights as term royalty interest owners. If, however, there has not been continuous production in paying or commercial quantities, then the interest may have lapsed and may have terminated. But that's the test. Was there production? Not did the lease continue, but was there production in paying or commercial quantities? That's the question. So looking back to the plat of the Frells tract, from this period up to 2014, the focus is on 2 wells. And Mr. Waymeyer pointed these out to Your Honor. There's one in the northwest corner of the box of the main portion of the Frells tract. There's another well that was put in directly adjacent to the property line of that portion of the Frells tract that's included within the Schnitz-Rydell unit. Just a few feet away from the property line, but it's on the Schnitz tract. Those are the 2 wells that we point to show production up through 2014. There's production history in the court's record showing that production, and that's Exhibit 2G, attached to the plaintiff's second motion for summary judgment and relied upon by the plaintiffs in response to DDR Gaddy's 8th motion. That production history shows this production continuing into March of 2014, then a 1-month gap, and then it picks back up in May. The last drops of oil coming out of this Schnitz-Rydell unit well were in June of 2014. But we say this was continuous production in paying or commercial quantities up through 2014. And EOG's production began in March of 2014. So there's an overlap.
And
So
which one of your exhibits is this?
This is Exhibit 2G, Your Honor, and it's attached to the plaintiff's second motion for summary judgment.
All right, I don't have that right now.
I'm happy to attach that in the chat, Your Honor. It's on the court's file, but I'm happy to provide that in the chat when I'm not share screening in just a bit. But that's Exhibit 2G. Yes, I will. So the plaintiff's claims, we have 4 claims. The first is a declaratory judgment claim to establish continued ownership, the entitlement to future royalties. That's a forward-looking claim. This is not a claim to establish anything about the past, about entitlement to be owed anything in the past. That's simply to establish those term royalty interests still exist today, and we are entitled to be paid royalties in the future. The claims for the past are claims that are asserted against EOG and the non-operator defendants. There's a debt claim. It's not styled as a breach of contract claim, but it's in the way of a debt for unpaid royalties because of our term royalty deeds that we are successors to. There's a debt claim against EOG for its legal obligation to pay royalties under those term royalty deeds. And then the next claim against EOG is the claim under the Texas Natural Resources Code, which is also an obligation to pay royalties. And then finally, as discussed today, there is a claim against the non-operator defendants for money had and received, seeking the remedy of unjust enrichment because they were wrongfully paid royalties, a portion of which should have gone to our clients, the plaintiffs. So those are the claims. Now, what are we here on today? We're here on an argument about the statute of limitations. Are these claims time barred? That's the question. The defendants have a high burden to show that these claims are barred by limitations. The Texas Supreme Court has held that the defendants have the burden to conclusively establish the defense of limitations, and that all evidence that's favorable to the plaintiffs in any way must be taken as true, and all reasonable inferences from the evidence must be resolved in the plaintiff's favor. That's the defendant's burden. The key distinguishing fact from what the plaintiffs are seeking to prove in this case from the cases cited by the defendants today is that these are royalty interests and they are a non-possessory interest, and they're not subject to a claim of adverse possession. This comes from the Texas Supreme Court, which has consistently and repeatedly held that a royalty interest, as distinguished from a mineral interest, is a non-possessory interest. Why does that matter? Well, Justice Greenhill, former named partner of our law firm, wrote in 1981 in the Madeley case that a royalty interest is a non-possessory interest to which the rules regarding adverse possession would not apply. Why does that matter? Well, if you can't lose the interest itself by way of adverse possession, that means the interest would continue. Now, does that mean statutes of limitations don't apply? No, of course not. There's an entitlement to be paid $1 of royalties from a month of production that needs to be brought timely or it's lost. And if, for instance, there were royalties that might have been due and payable to the plaintiffs in 2012 and no claim was timely filed either within 2 years as to the non-operator defendants or within 4 years as to as to Carbon, which was the operator at that time, then the statute of limitations would bar that claim for those dollars, for those royalties that might have been payable in 2012. But the royalty interest is not lost. The royalty interest is a non-possessory interest. The rules for adverse possession do not apply. So that royalty interest would continue in effect, would continue in force, notwithstanding that the plaintiffs may have lost their right to be paid a certain amount of dollars out of production in a certain month. So that's the key here. And we'll talk about the Madeley case a little bit more. The defendants rely upon Cosgrove versus Cade, which is a Texas Supreme Court case in 2015. This is not the Cosgrove case. This is the Madeley case. Cosgrove did not involve a non-possessory interest. It did not involve a royalty interest. It was a claim where someone was seeking to reform a deed. There was a contract that required a deed to be given, and the contract said that mineral rights would be reserved by the grantor. But then the deed did not reserve those rights. In other words, the deed granted fee simple title without the reservation of mineral rights. And the plaintiff in that case, seeking to reform that deed, waited longer than 4 years before bringing suit. And that's why if you snooze, you lose, because this was a possessory interest. This was a claim about a deed that everyone had. Everyone knew about it. Everyone saw it. It was recorded in the real property records. And if you snooze for more than 4 years on that claim, you do lose. And that's what the court held. The Cosgrove court held correctly that the 4-year statute of limitations was triggered by the date of that mistaken deed that failed to include a reservation of mineral rights. Here, in our case, the royalty interest owned by the plaintiffs is not subject to adverse possession, and the right to be paid royalties at a particular time, which can expire, that's one thing, but that's not what we're doing here. We're talking about whether the royalty interest itself has somehow expired by the lack of bringing an earlier claim. And that's simply, the law in Texas is very clear. It's been cited over and over again by Madeley and many other Texas Supreme Court cases that you simply can't lose a royalty interest by way of adverse possession. So if you snooze, you don't
Is that
lose.
what the defendants are arguing, or are they arguing that it expired on its own terms?
Well, they're arguing both, Your Honor. For purposes of today's motion, they're simply arguing the statute of limitations. And we'll be talking about many other arguments on February 8th, 9th, and 10th when we come back for
Okay,
the
I
other
see what you
summary
mean.
judgment hearings. But for today, it's just limitations. So the plaintiffs seek term royalties that were owed from production by EOG. We are not seeking the 2012, 2013, 2014 production by Carbon. Those claims probably are time barred, but we're not suing Carbon. We're suing EOG, and we're suing the defendants for the production by EOG. When did EOG first produce from the Frels Tract? That was in March of 2014. Well, when was their payment obligation? Their payment obligation at earliest was the end of July of 2014. How do we know that? We know that from the Texas Natural Resources Code, section 91.402A. The proceeds derived from the sale of oil or gas production from an oil or gas well located in this state must be paid to each payee, including our clients, by the payor on or before 120 days after the end of the month of the first sale of production from the well. Now, we don't know when the first drop of oil was sold. It might have been April, May, June, but we know when it was first produced, which was March. So at earliest, the payment obligation was triggered by July 31st, 2014. That's the earliest that limitations would have triggered for paying a claim for royalties. All of plaintiffs' claims against EOG are timely, and they were filed within 4 years. And this is coming from the Southern District of Texas, Your Honor, the Verde Minerals case in federal court, explaining very well this distinction that we're talking about, that the statute of limitations does not bar claims accruing with 4 years of the date when the plaintiff filed the complaint. This conclusion is consistent with those reached by Texas appellate courts in other cases brought by plaintiffs seeking to recover unpaid royalties. And then they cite the Dvorkin case. Verde filed this action on November 2, 2016, meaning the relevant period for purposes of the statute began on November 2, 2012. Just like here, our lawsuit was filed July 24th, 2018. So anything that was owed as of July 24th of 2014 is captured by our claim and is timely. And Mr. Waymeyer was correct to point out from the footnote, there were a couple of plaintiffs that were added later, all within 2018, but a couple of plaintiffs were added later, maybe 4 of them. And so as to those, they might have lost a couple of months of entitlement to royalty payments. And that's okay. We've got an expert who's done this on a month-by-month basis where she's identified exactly how much is owed for each month for each plaintiff. But other than those 4, all the other 21 plaintiffs filed suit on July 24th, 2018, and their claims are timely. So going back to that first production, that obligation to pay royalties at earliest July 31st, 2014, we filed the lawsuit on July 24th, 2018, within 4 years of that date. So as to defendant EOG, all of plaintiffs' claims are timely, but for those 4, which may have lost 2 or 3 or 4 months of entitlement to be paid, but they're timely as of 4 years prior to the date of their filings. That's what the Verde Minerals case holds. So what are the plaintiffs not asking for in this case? We're not asking for any royalties from Carbon. We're not asking for any royalties paid out of the Carbon production. Before EOG began drilling and producing on the Frels Tract, we're not seeking any payment for any amounts for that pre-EOG production. We're not suing Carbon, and we're not suing the non-operator defendants for that production. We're not seeking any royalties for more than 4 years before suit was filed. We're not seeking decades ago. And, you know, I heard histrionics about 75 years ago or 50 years ago or 30 years ago. That's simply a red herring. We are not seeking royalties from the 1990s. We're not seeking royalties from the 1950s. This is a claim for royalties dating back 4 years prior to the date when each plaintiff filed suit. All these arguments about decades ago are simply mischaracterizing the record and the law. So the record shows that Karn actually paid royalties to the plaintiffs until at least 2008. And I want to refer the court to some testimony by Mr. Brandt. Mr. Brandt was the president of Karn Oil Company. He's still the president of Karn Oil Company. This is at Exhibit 4, attached to plaintiff's second motion for summary judgment at pages 80 to 82. So we talked about this settlement with Gaddy and the release of the Frels lease. And I asked him, after that settlement and the release of the Frels lease, did the Schnitz-Rydell well continue to produce? And he said, yes. So there was continued production. Why did you continue to operate that well after terminating the Frels lease? He answered, for profit. Were royalties paid out of production from the Schnitz-Rydell lease? He said, I believe so. And were they paid after 1997? I believe so. Were they paid to all three of the landowners whose land was included within the Schnitz-Rydell unit? That's the Schnitz tract, the Rydell tract, and that little piece of the Frels tract. And he said, I believe so. Were royalties still paid to the term royalty interest owners after 1997? That's our clients. Answer, I believe so. Do you know how long Karn continued to pay the term royalty interest owners out of production from the Schnitz-Rydell well after 1997? He acknowledged he did not know exactly. Do you know how long Karn continued paying the Frels out of production from the Schnitz-Rydell well after 97? He said, I don't know. But regardless of when Karn stopped paying the term royalties, isn't it true that Karn continued to produce oil and gas out of the Schnitz-Rydell well continuously from 1997 until June of 2014? And the answer to that's yes, there was continuing production. Isn't it true that that production during that time was in paying quantities? He answered yes. And that production out of that well was sufficient to cover Karn's operating and marketing costs. Yes, it was, all the way through 2014. And production from the Schnitz-Rydell unit during that time was sufficient to pay Karn a profit after covering its operating and marketing costs. Answer, yes. And that was true during the entire time Karn operated the Schnitz-Rydell well from 1983 until June of 2014. The answer was yes. Now, he was not able to give a specific date for when royalties were paid, but we know it was at least through the end of 2008. And that comes from Exhibit 5E, attached to plaintiff's second motion for summary judgment. In December of 2008, royalties were paid. I'm sorry, let me go back to that slide. Royalties were paid. This is to Northern Trust, which is one of the plaintiffs in its trustee capacity. So royalties were paid to the plaintiffs at least through the end of 2008. Now, there's been a lot of discussion about the release of the Frels lease in 1997. There'll be a lot more discussion about that event in the cross motions for summary judgment that are set for February 8th. But what we know is under Texas law, the termination of a lease does not prevent a party from continuing to participate in a pooled union. That's the holding of the Wagner and Brown court in 2008. And so this argument, again, is a distraction. The fact that the lease was released, what you look to is, was there ongoing production? And was there payment of royalties? And did that continue? Did that production continue? And Mr. Brantz told us it continued at a profitable level until the spring of 2014. So we have more than a fact issue. We've got conclusive proof showing that these claims are timely. So what are the claims against the non-operator defendants? The court's heard it's a money had and received unjust enrichment claim. And we also have a declaratory judgment claim as to future entitlement. In other words, we don't want to have to come back to court each month. We want to have a judgment for what we're owed for the past under our unjust enrichment claim and under our claims against EOG going back 4 years. We also want a declaratory judgment to settle this issue going forward as to the future entitlement. So let's talk about that claim for money had and received and unjust enrichment. The Govinda Court in Texas Supreme Court 1986 held that generally an underpaid royalty owner has a remedy. You can recover from an overpaid royalty owner, and the basis for that recovery is unjust enrichment. the overpaid royalty owners not entitled to the royalties. This case has been cited many, many times, and it cites internal authorities that I omitted for purposes of brevity in this quote, but that's the law in Texas, is you can sue not only the operator, as we've done, you can also sue the mineral interest owners who were wrongfully overpaid under a theory of unjust enrichment. Now, what's the time period for that? If it's only as to the non-operator defendants, it's a 2-year claim. And we know that from the Elledge case, 2007, Texas Supreme Court, unjust enrichment claims are governed by the 2-year statute of limitations. And we've made clear that as to the non-operator defendants, that's all we're claiming is a 2-year look back. So the direct claims as to the non-operator defendants, those claims are timely as to royalties that were paid from July 2016 forward, with a couple of exceptions. Again, we've got 4 individual plaintiffs that were added to the lawsuit later in 2018. So their triggering date would be a 2-year look back from the date that they filed. And Mr. Waymeyer pointed out Mr. Bressler was also added in late 2018. So as to claims against Mr. Bressler, it would be a 2-year look back for whatever the date was for when he was added to the suit. But for the claims that we're asserting against the non-operator defendants, our claims are timely. The plaintiff's evidence about royalty payments shows the amount paid for each month. We've got an expert witness who's provided a detailed report with detailed spreadsheets. She provided an affidavit. This is Adalia Romanos. She provided an affidavit that's attached as Exhibit 7A in our response to the 8th motion for summary judgment. And her affidavit says that her calculations, which are appended to each report, show in detail the amount of royalties due to each individual plaintiff by well and by month since 2014. So that proof is available. That proof has been provided. That proof will be available for the trial court, and the claims are timely that we're asserting. So the plaintiff's claim for declaratory relief, now that we could shift gears to that, as I noted, is a forward-looking claim. And our 5th amended petition seeks to establish that we are the owners of our proportional share of the term royalties in the Frells Tract. Each plaintiff in its proportionate share is an ongoing owner of their term royalty share. And our interest in those term royalties have been held by production and remain in effect. And so since these are non-possessory interests, that claim would be timely at any time, so long as we can show that the interests indeed have been held by production. And here we assert that they have been, and we've got expert testimony as well as Bob Brandt's testimony, the president of Karn, the operator, to show that these interests were indeed held by production. And we're also seeking declaratory relief that we're entitled to recover proportionate shares of royalties in all units that contain a portion of the Frells Tract. That will be an important holding in order to establish our entitlement going forward after the date that judgment is entered in this case. So these claims are not, and they cannot be time barred. And that's because of the Madeley case and all the other cases citing it and all the cases before relating to a royalty claim. A royalty interest is a non-possessory interest, and it cannot be abandoned or lost on a claim of adverse possession. And so the claims for past royalties are timely. They're within 4 years as to the claims against EOG, within 2 years as to the claims against the non-operator defendants.
Okay, and is the Madeley case in your brief?
Yes, it is, Your Honor.
Okay, I didn't find it when I searched, but.
Well, excuse me if I misspoke there. I apologize. I thought that it was, but if it's not, we can certainly provide a copy to the court.
Well, no, let me just write this down. And what I'll do often is I'll go in and I'll highlight things I want to go back and look at. So 626 second, 726.
And it's at page 733, footnote 6, where the court discusses that. And it's been cited for that proposition many, many years.
Go ahead, sir.
And if the court would like, I'm happy to provide a copy of that that opinion. If it's not included in our brief, I apologize if I misspoke.
No, I can get it. No problem.
So the claim to establish entitlement to future royalties have not yet accrued and cannot be time barred. So the relief we're requesting, Your Honor, is simple. We request a denial of the 8th motion for summary judgment. It must be denied because the claims are not time barred. And I'm happy to answer questions, happy to discuss in further detail anything that's on the court's mind, and look forward to talking further on the 8th as to the other motions.
Your Honor, may I be heard in brief?
I don't have any questions. Go ahead, Mr. Weimeyer.
Thank you, Your Honor.
First, Your Honor, you're correct that with respect to the Poole case and the Madley case that appear to be the White Horse cases that he discusses today, neither one are discussed in the responsive papers. But Madley, I'm going to try to get my colleague John Ellis to put that into the chat feature so that you have it. His White Horse case bears in no way, shape, form, or fashion on any issue before the court. I'll read the court. I had to go through the whole thing to try to figure out what was relevant according to these plaintiffs. And here's what they have is footnote 6. I'll quote the whole thing. Lessors argue in the alternative, if their prior participation in the proceeds from working interest gas is classified as a true working interest, they have matured a limitations title to 1/2 the working interest gas. Lessors, however, candidly state that they believe their interest during this period should be more properly be classified as a royalty interest, which is a non-possessory interest to which the rules regarding adverse possession would not apply. With this, we agree, and we accordingly reject Lessor's alternative theory of adverse possession. We haven't brought the court a title by adverse possession motion under 16.024 or 16.025 or 16.026 or 16.027 of the Texas Civil Practice and Remedies Code. The reason for that is that those apply to trespass to tried title actions. That was the whole point here. And just as I argued in the opening remarks, Mr. Kilday has now confirmed that he thinks that because this is a non-possessory interest, this is some special brand of a title declaration he comes on, that he could assert 1 century from now. He could say, I want a reset button on this in 100 years. And this is-
I agree, Mr. Weimeyer, that's not a good idea, but that doesn't mean that's not what the law is.
Under 16.051, and in cases like In re Denman, the courts have said that the defendant's position here is what the law is, and that the catch-all applies to it. And so the idea now, this is the very first time that this is argued by the plaintiffs, that they want a forward-looking declaratory judgment, that in the future they have title. And to that, I say, that's absurd. I want to show you their petition. Everything they asked this court to declare by way of title and declaration is backwards looking, and is premised on events that happened decades ago. And I was accused of histrionics over 75 years ago. I'm going to show you out of the plaintiff's pen that they are suing and asking for declaratory judgment over things from 75 years ago. Mr. Ellis, can you pull up the petition? Let's just start at the factual allegations so that the court can see what is the declarations you're being asked to make and why. Background and overview. Let's keep moving forward, please. All right, let's get to the actual, again, the idea that this is forward-looking. At page 10, they start at the 1945 and the road issue. At page 11, they're talking about the 1956 Frells lease. At the bottom of page 11, they're talking about the term conveyances of 1960 to 1962. At page 14, the next section, they're talking about the Schnitz-Rydell unit that was formed in 1964. At page 15, they're talking about the reclassification that happened of the Schnitz-Rydell well in 1972. At page 17, they're talking about a 1982 designation of unit that they want construed. At page 22, they're talking about operations in 2010 and 2011 that they claim resurrected or perpetuated their interest. At page 25, they're talking about EOG's units in March of 2014, which predated the filing of their suit before 14 years. And from that, they go into the deck action that we've at paragraph 91 is where they want title declared based on these events that started in 1945 and continued until March of 2014, but they bring it decades late. Let's look very briefly. Mr. Ellis, can you pull up their second motion for summary judgment? I'm going to show the court exactly what they're asking the court to declare. And it is literally from 75 years ago. Let's start at the prayer. And then if we go to the prayer, this is their motion where they're asking the court to make declarations consistent with their pleading. Page 27 of 32 out of their prayer. They want the court to declare the following. This is their words. Declare the following. Plaintiffs are successors in interest to the original grantees of the term royalties in the Frells Tract. Production and paying or commercial quantities on the Schnitz-Rydell unit containing a portion of the Frells Tract Road perpetuates their royalty interest. That the 1945 deed to the Frells conveyed fee title to the road. They are literally asking this court to make a declaration under Chapter 37 about a deed from 1945. That the release of the Frells lease in 97 did not extinguish their term royalties or terminate their participation in the Schnitz-Rydell units. That their term royalties were unaffected by reclassifications of the Schnitz-Rydell well. That was the event that we showed the court from their petition happened in 1972. That the cessation in production on the Schnitz-Rydell well were temporary and did not result in termination of plaintiff's term royalty interest. That was what we just showed the court from their petition happened in 2010 and 2011. Every single one of the declarations that they asked for about the perpetuation of royalty interests pertains to events that occurred at the latest in the year 2011. And if you add 4 years to 2011, as 16.051 says you must, you're not timely. And let's just go back to the particular, if Mr. Ellis, will you start at page 9? I want to show the court that they are asking for declarations about 1945 acts. At page 9, consistent with the prayer for declaratory relief in their petition and consistent with the prayer in their motion for summary judgment, they want this court to declare that the 1945 deed conveyed fee simple title to the road. They're asking the court to go back 75 years for its declaration. Let's look at the next ask that they have. Page 12, please, Mr. Ellis. That the plaintiff's term royalty interests were not extinguished by the 1997 release of the oil and gas lease covering the Frells Tract. That's what they're asking this court as a matter of law to declare. If they're asking for a declaration here and they don't have a pleading to support it, then I don't know how they're making this ask. They're asking the court to make declarations, to come in under Chapter 37 and make a declaration that's covered by 16.051 as to something that happened in 1997. Let's look at the next ask for at page 15. They're asking this court to make a declaration that a reclassification of the Schnitz-Rydell well as a gas well in 1972 didn't cause their interest to terminate. If we go to page 17, I'm sorry, I want to get to the next heading. Page 20, here's the next declaratory judgment. It's not that they own title in the future. They want the court to declare that events that happened long ago didn't happen or happened in some different way and somehow their interest has been resurrected. At page 20, the F declaration they want is that they did not terminate as a result of any temporary cessation in production. Some defendants have asserted a temporary cessation in production during late 2010 and early 2011 on the Schnitz-Rydell well. That again is right back to their petition. And I think that's the last ask. Yeah, if you, and then you get down to their prayer. If you can unshare screen that, please, Mr. Ellis. So again, the idea that now they want a declaration that they have title in the future, what they're asking the court to do is declare title based on events that happened in the past. And we have shown the court that as a matter of law, that ask from the court happened and those claims accrued as a matter of law at 2011 at the latest. This whole business about we want title in the future has been manufactured since the filing of their response. It's not even argued in the response. And so I just wanted to put up the Fifth Amended petition leading up to the ask in paragraph 91 and the Second Amended motion for summary judgment that just show that that's flat out wrong. So again, I come back to there is a statute of limitations that applies to every single action in this state. And for adverse possession, that is asserted in response to trespass to try title, and trespass to try title is the single and only exception to the 16.051 catch-all that's contained in the Texas Civil Practice and Remedies Code. And the court has to look no farther than the N. Ray Denman case to see where the San Antonio Court of Appeals applied the statute of limitations under 16.051 to title under a will in exactly that fashion. And so again, I just can't state enough that the idea of adverse possession here is an utter red herring. The Madley case does say that yeah, you can't adversely possess an MPRI or a non-possessory interest, I should say. But that misses the mark of when did a cause of action accrue under the Texas Declaratory Judgment Statute to come in and ask the court to confirm that title was perpetuated. Here, that happened in 2011 at the latest. And again, if the court goes back and read these plaintiffs' response, they don't argue that it accrued later in time. And again, it's also an important distinction is that the idea that money had and received, that cause of action is continuing. They still have not cited or directed the court to one single case that says that. That's an equitable action. And they have sworn in their expert's affidavit that that action accrued more than 2 years before they filed this lawsuit. And with respect to the idea that it accrues in 30-day intervals or anything like that, they don't have a single case that says that or would support that notion. And I was just looking over my notes quickly. I also don't want this to be lost in the shuffle. The idea that there was production from the Frells tract, Mr. Kilday showed you production. That was from a well that was off of the Frells tract. That was from a well in which they tried to rely on pooling out of a lease from the year 1997 that ceased to exist. And so I don't want the court to be confused that there was continuous production between 1997 and the year 2014 from the Frells tract. Counsel will tell you there was not. They have to use a well that is off of the Frells tract, and there are at least 8 pure matter of law things that happened in the past from 2011 and earlier that do not allow him to do that. The Verde Minerals case that he cited, again, it doesn't bear on any of the material issues here, but lest the court be confused, that's a district court, that's a federal district judge's order. That's not any court of review. That's not any opinion that's even persuasive authority. It's not even a federal opinion that could be persuasive authority. It's a district judge's order. With respect to the Brandt testimony, he has shown you that the evidence he cited you was that as of 2008, they were cut off, that their interest was not recognized. They were told you don't own anything. And they didn't file suit within 4 years of 2008 when they were told, full stop, you own nothing. And again,
Mr. Wimmer, let me ask Mr. Kilday to address that point.
Certainly, Your Honor. The question is whether or not our rights are cut off by failure to bring a claim. And because it's a non-possessory interest, it's clear under the law that it is not cut off, and we could bring that claim at any time.
Okay, no, actually, I meant much more narrowly. If you had a perpetual royalty interest, that might be a very different thing. But if you're cut off from payment in 2008, your clients or some of your clients, do you agree with that happened?
My position, Your Honor, is that we are foreclosed and time barred from seeking payment of unpaid royalties from the era at the end of the carbon production. That if we wanted to sue Carbon for royalties that were not paid to us in 2012, we waited too long to seek those royalties. And we're not suing for that. And so that is a claim that is now closed. It's now time barred. We waited too long to seek compensation for the ongoing production that continued after they stopped paying royalties to us. But the test under the term royalty deed is simply, was there production in paying quantities? And the evidence shows that there was, and that perpetuated our interest, which gives us the right to file a claim looking back 4 years if it's against the operator, looking back 2 years if it's against the non-operator defendants. But that gives us that continuing production and paying quantities gives us the right to bring a new claim for recent production because our non-possessory interest has not expired. Now, if we're wrong on that, we're wrong on that. That's the subject of other motions. If the lease termination cuts us off, so be it. But we've got a motion for summary judgment on that issue, and the defendants do as well. That's not before the court today. What's before the court today is simply the statute of limitations. And as to the other issues that Mr. Waymeyer went through in the pleading about what happened in years past, no one ever took that position in the 1940s, 50s, 60s, 70s, 80s, 90s. After the 1997 release of the Frells lease, the plaintiffs were still getting paid their term royalties. Why would you bring a claim to when you don't have a controversy? Everyone agreed in 2000 that the plaintiffs were entitled to be paid. We were getting paid. And so there would be no reason for anyone to bring a lawsuit to test whether or not Wagner and Brown versus Shepard means what the Supreme Court says it said. Everyone was operating in that fashion. Everyone was paying royalties. Everyone was reporting production as unit production. And the same with these other issues about reclassification. No one was arguing back in the 70s that the reclassification of the well was somehow terminating the plaintiff's rights to be paid. The plaintiffs were getting paid. That's a new argument raised by these defendants in this lawsuit that seeks to rewrite 40, 50 years of history. And in light of that new argument being made in this lawsuit, yes, we're seeking declaratory relief that that new argument is not correct.
Your Honor, may I be heard in 2 minutes?
Yes, go ahead.
Appellate record from today's hearing is going to reflect that Mr. Kilday conceded his entire case with those remarks. He just told you that there was no controversy about the perpetuation of the royalty, that his claim would accrue upon creation of the controversy. And I showed the court in exhibits K and S and in Mr. Brandt's deposition at exhibit G, and he showed the court Mr. Brandt's deposition in his exhibit 4, that they were told and that it was the Carbon position that as of 1997, the interest had terminated. I showed the court the 2011 correspondence where Carbon said, your interests are dead. And that was the position, and they were cut off, according to Mr. Kilday, as of 2008. They weren't cut off because Carbon lost its checkbook or couldn't find his clients to figure out where to pay them. They were cut off because as of 1997, their interest terminated. And his cause of action to have a declaratory judgment about that accrued at that time, or certainly by 2011. And so his test here is exactly right. When did the controversy he seeks declaratory judgment over accrue? And the uncontroverted summary judgment evidence here is that happened no later than 2011.
All that's time barred because of that, Your Honor, is the claim for the unpaid royalties. We are seeking declaratory relief to establish the ongoing ownership of term royalties on a forward-looking basis. So the claims for unpaid royalties look back 2 years as to the non-operator defendants. That's timely. Looks back 4 years as to EOG. That's timely. And the declaratory relief that we're seeking is to establish entitlement to be paid future royalties going forward. And yes, they're addressing events of the past that have been raised by the defendants in this lawsuit, but we are not time barred from asserting declaratory relief as to our future entitlement. It's a non-possessory interest. It's not subject to adverse possession, and those claims can't be lost for a term royalty interest based on the passage of time.
And Your Honor, if I may have 60 seconds, what I would
go ahead.
When he says we raise those issues, this is straight out of his petition. I've shown the court the 5th amended petition where he brings to the court these grievances over events from 1945 to 2011. This isn't my argument. These are what he knows terminated his title, and he was told his title was terminated a decade ago. And just as a procedural matter, here the admissions on file at 166A speaks to the admissions. The admissions here conclusively prove that his controversy accrued take your pick between a decade and 7 decades ago. But we do have an ask under Rule 201 of the Texas Rules of Evidence that the court take judicial notice of its file for purposes of today's records and those admissions. And it looks like Mr. Truss has something to add, but would reiterate the request that's contained in our motion for summary judgment. The court agreed to take judicial notice of its file.
Your Honor, may I be heard?
Yes.
Yeah, so very
I'll
briefly.
take judicial notice of the entire contents of the file.
Thank you, Your Honor.
Thank you, Robert. Very briefly, there's some analytical sloppiness going on here, and it's a consequence of how this case was brought to the court and pled. Mr. Kilday is now telling you that he's only seeking forward-going declaratory relief. But what he's actually trying to do is, after his client sat on this problem for many years, and then a successful operator took over and started generating a good amount of revenue, they're trying to dispossess tens of millions of dollars backward-looking from EOG and the other parties that it's been paid to. And so to do that, Your Honor, he's got to establish that he has some contractual or statutory right to dispossess these other parties from the tens of millions of dollars that have been paid. He has still not brought the contract before you to show where EOG has any obligation to pay, much less any continuing obligation to pay, so that we can fix when accrual of his cause of action was under breach of contract theory. What he's done, and this is the analytical sloppiness, is he slid over into a claim that's not even before the court today. Section 91-402 under the Natural Resources Code, and he says, he cited that to you a couple of minutes ago and said, well, you just look here, it accrued 6 months after first production in March of 2014, so the end of July 2014. Your Honor, that's for a statutory claim. We're not moving for summary judgment today on the statutory claim. That has nothing to do with the accrual of a contract claim. He's given you no contract, and certainly no contract with any alleged continuing obligation to pay. So he's having to shift back and forth from these things to try to make his claim survive when it's crystal clear there is no contract that provides any obligation or ongoing obligation to pay, and that he's clearly seeking retrospective declaratory relief that could have been sought many years ago, and that without doing that, without establishing that he was a proper payee under the Natural Resources Code or some contractual obligation to pay, he's out of luck. Why was, Your Honor knows this, the Chapter 91 was enacted precisely because a lot of the leases in Texas didn't have provisions determining when royalty was going to get paid. They didn't have specific provisions about it's going to be paid on this day of the month and every other day. So the legislature had to step in and basically establish a cause of action or a contract where no contract existed. Now, Mr. Kilday can't have it both ways. He's trying to bring a cause of action under a contract, but he can't show you the contract, or under the statute. And we're not talking about the statute today. So I think this has been teed up. It's right. It's crystal clear that we're dancing on the head of a needle at this point, and so we think it's right for summary judgment as to the claims that have been presented to the court.
Anything else, Commander? Sorry,
Mr. Truss?
I beg your pardon?
Go ahead, Mr. Kilday.
Yes, I just want to be heard in response to Mr. Truss. With respect to my friend, Mr. Truss, maybe he wasn't paying attention, but we did show the court the term royalty deeds that were bought and paid for in the 1960s that give us that contractual entitlement to be paid royalties for out of the production from the Frells Tract for so long as there's production in paying quantities. So that is the triggering document that has been part of the real property record since the 1960s, and upon which royalties were paid to the plaintiffs throughout that time period. And I do want to note that when EOG contracted with Carbon to acquire its position, it acknowledged that there had been the production had perpetuated the interest, and EOG required Carbon to continue producing until they established production because they wanted to preserve the rightal lease as well. So EOG's trying to have it both ways here. They're trying to insist that Carbon continue its production in paying quantities to perpetuate the interests, and now they want to say somehow that that same production and paying quantities didn't perpetuate our interests, which were of record and there was real money paid to the Frells for those interests. So I think that the motions need to be denied. The claims are not time barred. There may be some other argument that we can talk about in a couple of weeks. We don't believe that they're barred for any reason, but certainly as for what's before the court today, we filed our claims timely and these motions should be denied.
Your Honor, I'm not going to get into the weeds of Wagner versus Brown to respond to Mr. Kilday's suggestion and show you how disingenuous it was, we'd have to get into the weeds of Wagner versus Brown. That's going to be a couple of weeks from now. So I'm gonna leave that for now. But at no point did EOG insist that Mr. Kilday's client's interest be preserved.
Your Honor, may I have the final word on my motion?
Yes.
I think he asked that the motion be denied, which is very strange because in his papers, it has to be granted as to at least broad swaths of this. So whatever that last ask on denied was, the papers say the motion's appropriately granted. And I would come back to the plaintiff's position here is asking this court to make brand new law and say that while every other single action, even possessory mineral title determinations have a statute of limitations, what they ask you is so special that somehow this is the only case that in all of Texas jurisprudence, they can bring at any time, at any way they please, and could even do it a century from now and still do so under a timely umbrella. That is not the law that's been handed down. That's not 16.051. And on review, no Texas Supreme Court is going to say that this is a special brand that 16.051 doesn't apply to, and they can do it anytime they please.
All right. And on that issue, Mr. Kilday, why shouldn't the 16051 post dates Sun Oil? So even if that was the correct law in 1981, that even if it is still the correct law, that there's no adverse possession, would limitations still apply?
Yes, Your Honor, limitations does apply, but we brought our claims timely. And again, the reason why we're asserting a declaratory judgment claim is to establish our entitlement to be paid royalties going forward, because they're not being paid to us now. And so we want a judgment not only to collect the money that should have been paid over the last 2 to 4 years, depending on which defendant, but we also want declaratory relief to establish that our term royalties remain in effect and that each plaintiff owns its proportionate share of those term royalties because they were perpetuated by production. That's the declaratory relief we're seeking in a nutshell. These other issues that have been addressed are new allegations to try to rewrite history that were brought in this lawsuit by the defendants. And Mr. Waymeyer's correct that it's now written in our 5th amended petition, but these are issues that have come up during the course of testimony and questioning and pleadings by the defendants that we just want resolved, that you can't come back 50 years after the fact and say, oh, wait, 1972, it was reclassified as a gas well, therefore you were cut off as of 1972. Well, that's not what anyone was saying. In 1972 or in the 80s or in the 90s, these term royalties were getting paid throughout that time period. No one, not the operator, not the defendant's predecessors, no one was taking that position at that time. So there wouldn't have been any basis for a dispute. And so those claims are not time barred. And as to doing a declaratory judgment to show your entitlement to be paid royalties in the future, claims that haven't yet accrued because we haven't yet been unpaid. We just want to establish going forward that we have term royalty interests that have not expired and that we're entitled to our proportionate share going forward. It's just that simple. So 100 years from now, Mr. Waymeyer likes to talk about that would be a very foolish thing to wait 100 years because you'd lose entitlement to 96 years of royalties. But if in fact there's production in paying quantities for 100 years, this is a non-possessory interest that wouldn't expire. And if we wanted to assert a declaratory judgment claim 100 years from now for entitlement to royalties going forward from that time, yes, that would be timely.
I just want to make sure it's not lost on anyone that Mr. Kilday just told Your Honor that he needs a declaratory judgment to establish his entitlement to next month's royalties, but not last month's royalties.
That's because last month's royalties is covered by our claim for damages.
And Your Honor, I just want with respect to him saying that the controversy didn't arise until we filed a pleading, Exhibits H, Exhibits K, Exhibits S, and Exhibits G prove as a matter of law, and it's uncontroverted, that the exact controversy he brings you in his pleadings existed at 1997 at the earliest and 2011 at the latest.
Okay, all right. I'm gonna sit here and I will get something out this week. if you would submit something that just says what you've agreed to. I believe that, Mr. Kilday, that there were a couple of things that you agreed that the summary judgment would be appropriate, or that we don't need the summary judgment because you're agreeing that the claims can't go forward.
I believe Mr. Waymeyer stated it properly earlier when he said that to the extent there was any confusion about whether we were seeking claims for more than 2 years ago, that's now moot. And so there's no need for the grant of a summary judgment order as to claims predating 2 years prior to the suit for the non-operator defendants. We are seeking what we are seeking, and to the extent that it could be construed otherwise, we are not seeking damages for any payments that were owed more than 4 years to the date that the lawsuit was filed as to EOG, and we're not seeking any damages for royalties that we allege were wrongfully paid to the non-operator defendants more than 2 years prior to the date suit was filed.
Your Honor, that's not what his petition says, and the scant evidence that he did bring in response to the motion is an expert report saying they're entitled to royalties going back more than 4 years than they filed suit. And certainly more
All
than
right,
2
so
years.
if y'all have something that's agreed, submit an order. I think it will be better, whether it's a dismissal, an acknowledgement, a stipulation, I don't care what you call it. I just think it would be better for everyone going forward if you have something succinct in the record, like with the judge's signature at the bottom, and not be trying to incorporate the court reporter's notes from this hearing and get the Court of Appeals to take notice of that.
We're happy to file an acknowledgement of what I just said, Your Honor.
Okay.
Your Honor, and you do have our reply paper.
Yes, sir.
Your Honor, I know what you want. I'll work with Mr. Kilday and Mr. Waymeyer on some sort of stipulation so we can at least delineate the areas of non-disagreement.
All right, that sounds good. Anything else? All right.
Your Honor, one thing,
Yes,
there was a proposed order on the motion for continuance that was submitted. There was not an agreement as to form on that order. It may be moot now that the court has heard this motion, and we'll hear the others later. But I don't know if the court wants to sign an order on plaintiff's motion for continuance, but we've submitted an order a few days ago, and I don't know if the court wants to discuss.
I believe I kicked one back asking if it was agreed to inform.
It was not.
You're welcome to submit something, that doesn't matter.
Yeah, we submitted a letter to the court with the back and forth on the forms of the various orders and with our proposed order.
I don't remember seeing that, so.
Okay.
And I did check my judge's queue earlier this afternoon. It was cleaned out. I don't know. There may be something in there now.
Your Honor, what's the best way to get that to you? We electronically filed it and were told by the court personnel that would be the best way to get it to you. Is there a separate means for getting that?
Just email it to the coordinator with a brief, just a one sentence note.
Okay.
Can
I attach it in the chat right now?
Oh, that's even better if you have it.
And Your Honor, we think our form of order is appropriate. If we can submit that as well, and the court can choose.
Please.
Thank you.
All right, then I'm going to look at my emails. I've got emails, it says down here, but I will leave the meeting running so people can file those.
I apologize, Your Honor. I just thought of one other thing. You had asked for the parties to convene on Friday, February 4th at 2 p.m. to have a sort of a pre-trial conference, a pre-hearing conference before these summary judgment hearings. I was going to ask if we could do that at 3 or at 4 instead. I've got a pro bono case in Travis County where I'm an attorney ad litem, and I just got set for a hearing at 2 p.m. on Friday the 4th. That's conflicting. I can send someone else to this hearing if that's not workable for you or others, but if we could move that hearing an hour either direction, that would help me juggle 2 hearings the same afternoon.
I'm good. 1 o'clock, 12:30. I don't want to ruin people's Friday lunch. I don't live in a big city.
Yeah, I would just mention that hearing's on Thursday, the 4th, not
Thursday.
Friday.
Okay.
Oh, well, let me check. Maybe I'm mistaken that I'm double booked. I thought it was Friday. Let's see. Okay, well, I was correct that I'm double booked, but I had the date wrong. It's Thursday the 4th that I have that ad litem pro bono court appointed hearing at 2:00. So if we want to do it Friday the 5th, that'd be fine. If we want to do it earlier or later on the 4th, that would be fine with me as well. And if you'd prefer to keep it there, I can send somebody in my stead.
Okay, I couldn't move it back any earlier. I could move it later. I could do it Friday.
And y'all are saying y'all have it set for 2/4 because I don't have it on my docket for that date.
Yes, it's just a telephone, or we can do it by Zoom. Yes.
That was what my question was. Could we get a Zoom link for that, or how else would you like us to?
Okay. All right. So 3:30 on the 4th.
That would be fantastic. Thank you, Your Honor.
All right. So we'll set that by Zoom. Okay, I will leave this open so that I have a letter from Mr. Kilday on his proposed order, I assume. I'll leave this open so Mr. Wehmeyer and his firm can post their proposed order.
Thank you.
All right, everyone's excused. Have a good day.
Thank you, Your Honor.
Your Honor.